Good morning. This is the Colorado Energy and Carbon Management Commission. It is August 5th at 9 a.m. We will start our business meeting with a roll call.
Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
and Commissioner Robbins.
Here.
Mr. Chair, you have 5 commissioners present.
Great. 5 out of 7 is a quorum. And want to welcome Commissioner Oath, who is a newly appointed commissioner in the public health seat. Really excited to have you with us. Do you want to introduce yourself?
Sure. Thanks, Mr. Chair. Hi, everyone. Really glad to be here this morning. The newest member of this commission, and some of you may recognize me. I have spent the last 10 years at the Colorado Department of Public Health and Environment, and in that capacity did have an ex officio seat with this commission, so have participated in a number of hearings, but very excited to join full time, bring my public health expertise to these really important issues of energy and carbon management, and work with all of you commissioners, work with all of the great staff at the ECMC and all of the stakeholders and parties that participate. So that's, I think, all I have to say, Mr. Chair.
Very good. Welcome. Again, we are thrilled to have you with us. Nothing like hitting the ground running. We start with a rulemaking this morning. Before we get into, so that docket is docket 2405-00115. It is the deep geothermal rulemaking that begins this morning. The first step in this rulemaking is going to be public comment, and we had 6 folks sign up for public comment. And if my hearing staff could go ahead and start elevating folks, Ruth Hund, Emerald Sage, Kevin Cross, Hannah Berman, Tricia Hanako, and Sam Bandemir.
Currently, no sign of the first 2. Mr. Chair, we'll keep looking. We've elevated Hannah and Tricia to speak.
Great.
And Mr. Cross.
Tricia, you're the first to visualize yourself, so we will hear from you. We generally set aside about 3 minutes for each public commenter. So with that, you're recognized. We look forward to hearing from you.
Thank you. Good morning. I'm Tricia Canonico, a Fort Collins City Council member. Thank you for taking comments on the deep geothermal operation rulemaking. Fort Collins is committed to reducing greenhouse gas emissions and our reliance on fossil fuel. We're excited for research into emerging technologies that can help us all reduce our impact. As you know, the planet recently reached its warmest day on record, followed the next day by even warmer temperatures. Every month for the last 13 months in a row have broken temperature records. The smoke and ozone in our air this summer is a constant reminder of the urgent work we have to do. I'm hopeful and optimistic about the future of deep geothermal operations in our state, and I'm excited for a rulemaking that will ensure safeguards for neighboring communities. As you work on this rulemaking, I hope you will answer the many outstanding questions about converting oil and gas wells to geothermal wells. There just aren't enough examples yet of where this is successfully working. Also, the rules should require alternative land analysis and setbacks to protect communities from potential impacts of this technology. The law that established the need for this rulemaking was clear that disproportionately impacted communities be protected. Because pre-production impacts for deep geothermal wells are expected to have similar impacts to oil and gas pre-production wells, it's important that the rules address potential nitrogen oxides, volatile organic compounds, and air toxics, and the impact on public welfare of these pollutants. Please be sure to include cumulative impact rules to deep geothermal operations. This is an important component of ensuring true reductions in emissions and safety for neighboring communities. Thank you for your work on ensuring that deep geothermal operations can safely help the state meet its emission reduction goals.
Thank you, council member, for the comments and for being with us this morning. We appreciate your presence and your commentary. Thank you very much.
Thank you.
Let's see, Mr. Cross, you are recognized.
Yes, thank you. Good morning, commissioners, and thanks to Tricia for her commentary. My name is Kevin Cross, and I am also a resident of Fort Collins. I'm the convener of the Colorado Coalition for a Livable Climate, but want to make clear that I'm speaking on my own behalf to you this morning and not on behalf of that organization. I believe that power plants based on deep geothermal wells offer a good deal of promise for providing a renewable source of firm power capacity. This is especially important as we see utilities in our region, in our state, and in the US generally consider moving from coal-fired electricity to methane-powered electricity. There's nothing renewable or climate-friendly about either one of those fuels. And again, geothermal wells do hold the promise of providing a renewable source of firm power capacity. However, it's important to acknowledge that there are many unknowns concerning the development of deep geothermal resources, particularly those based on previously drilled oil and gas wells. Those unknowns include how much methane and other greenhouse gases might be released and what harmful chemicals might be released via groundwater or the heat transfer fluid during the process of repurposing those wells. Because of those unknowns, I strongly urge the Commission to take a go-slow approach to the rulemaking process. More concretely, I urge you to require third-party monitoring of air and water pollution released of geothermal resources, and to use the information gathered to inform development of a second and more specific set of rules in the next 2 to 3 years. While the technology is promising, it's important to bake a process into the rulemaking process to protect the health of Coloradans and the environment that we all depend upon. Thank you very much.
Thank you very much, Mr. Cross. Thanks for being there with us. We now will hear from Hannah Berman.
Hi, thanks so much for having us today. I'm Hannah Berman and I'm on Basalt Town Council. And Basalt is just down the road from Aspen, which has lost a month of winter since 1980. That's 31 days on average that no longer get below freezing in a region whose economy and way of life depend on outdoor recreation. So for us, climate is a very real threat, and the town of Basalt has climate goals, but we will need state action to be able to achieve them. We're very lucky to have Holy Cross Energy as our utility, gearing towards 100% renewable power by 2030. So that means we can also need to focus on conservation measures if we're going to meet the state's emissions targets. It's so important to develop new technologies to meet our energy needs, and deep geothermal is a promising part of that puzzle. But we also want to make sure that there are some safeguards in place to protect communities like ours from any unintended impacts of this sort of energy production. Because this is new technology, we don't know all the impacts of commercial deep geothermal operations. And so we hope that you guys will keep in mind that it's important for local governments to have regulations established to allow us to protect public health and safety and the environment of our residents. So we're hoping that this will include notice and consultation procedures for local governments, as well as helping get some information to answer questions that are lingering on how converting oil and gas wells to geothermal wells would impact our communities. We're also looking and hoping to see that the draft rules would get additional protections for disproportionately impacted communities. So that could include a community liaison, proposed and pending cumulative impact rules for geothermal operations, And we're also looking at things like financial assurances that could be required for inactive DGO wells. So we really appreciate your time and the energy you're putting into this. And I thank you for your time this morning.
Thank you very much. We appreciate your time this morning with us. We now will hear from Sam Vandermeer.
Good morning. My name is Sam Vandermeer. I'm a current candidate for Senate District 19. And I just wanted to talk to you this morning a little bit about geothermal, talking about shallow geothermal instead of deep geothermal. Currently have my home currently right now is a net zero. I can show you my last Excel energy bill here. It's zero. And we're converting on an average of 2 homes per week to ground source heat pumps. We really don't need more energy. We don't need a bigger grid system, because if you could convert every home in Colorado to net zero, we have a grid system that is plenty big for EVs, for whatever you want to do with it. What it does for the environment is obvious. So we do have a program. It's not futuristic. We're out there doing it. And as a senator, I will be looking at budgets to figure out how we can take these millions of dollars that are being spent on the environment and figure out how we can better utilize those dollars. And we can get down to where we have a grid system that will handle whatever we need in the future for EVs and whatever else you want to drive. So with that, I will just say we can do it. We're out there doing it, and appreciate your efforts. And any questions you have on how we're doing it. Thank you.
Thank you very much. Do we have any of the other members of the public with us this morning? In
I do
particular,
not currently see our other 2 public commenters in the attendee list.
So if
Ruth Hunt is
Ruth
there,
Hunt or Emerald Sage is in the meeting, raise your hand. We'll elevate you. All right, seeing none, we will close for now public comment. And I believe we are now looking for a presentation by the staff from the Energy and Carbon Management Commission, Benjamin Boudreau, an Assistant Attorney General, and Michael Rigby, our Deep Geothermal Coordinator.
Hello, Commissioners. Thanks for having me. I will share my screen and can start the presentation if that makes sense here. Are you all seeing my presentation? Well, thanks for having me again. Appreciate it. I will be just kind of running fairly quickly through what the draft rules have, a little background, kind of some of the updates that were done, and I will move fairly quickly, but can answer questions as well. So a little background, and I'll move fast through this. SB 23-285 granted us authority over deep geothermal operations. DWR, the Division of Water Resources, retains authority over shallow geothermal projects that utilize tributary resources and any consumptive use of water in these projects. So generally, deep geothermal operations are geothermal operations that use non-tributary geothermal resources, which are resources not really connected to surface waters, or any geothermal well deeper than 2,500 feet. General summary of the Geothermal Resources Act and these rules. The Act requires to safeguard life, health, property, public welfare, the environment, including wildlife resources, encourage maximum economic recovery of each resource and prevent its waste, and to protect correlative rights associated with deep geothermal operations. In doing this, we drafted the 1300 series, and while it does reference out to other rules, all of the requirements for deep geothermal operations are within 1300 series draft. So moving on to permitting. So to begin, permitting is by default an administrative approval, but there are opportunities for it to be escalated to a hearing. In permitting, there is fairly extensive notice and consultation requirements. There's a pre-application consultation meeting required to bring together different impacted agencies and stakeholders to ensure that everything's kind of thought of up front with the potential operator or the applicant. There's notice to nearby members of the public. There's required notice and consultation with state and federal agencies, including CPW, CDPHE, State Land Board, the Division of Water Resources, and the EPA. There's also notice and consultation with the BLM and tribal governments for projects that may impact their minerals or resources. And there's also consultation built in with local governments. Of note, local governments may promulgate their own siting regulations for the surface facilities of these operations. And applicants must inform the ECMC if the local government does regulate and what's the status of the permit. Moving into kind of some of the requirements and plans. So the Form 2G, this is pretty much the geothermal equivalent of the 2A. It is the surface location permit. It includes a lot of similar items and some different, but many similar items as the 2A, like site equipment, site drawings, photos, details of end use. This was maybe unique to geothermal, as different end uses are used in geothermal, either direct use or power, among others. There's also for potential projects that may disproportionately impact a community. There is a map and plan required, and the plan must avoid, minimize, or mitigate adverse impacts to the DI community. There is a wildlife map and plan required, a geologic hazard map and plan, emergency spill and response plan, as well as some other plans for mitigation that you all are likely very familiar with from the Form 2A. Moving on to the Form 2, that we're going to keep the same form for this well, the well permit for this type of well anyway. So it'll include distances to buildings and infrastructure, different technical plans and diagrams, such as proposed drilling plan, proposed casing and cementing. There'll also be details of the planned injection activities. If they are injecting, not all projects will, but for ones that do, a detailed plan for how they're doing that will be included. There's also geothermal resource units. So there's a preference for concurrent permitting of resource units with the 2G and the 2, so that it's kind of brought in all together as an entire kind of plan. This process facilitates multiple interest owners into a single project, so that all impacted owners are brought together. And this is intended to protect the correlative rights of these impacted owners. And there is requirements for equitable compensation within the units. And for any operator looking to bring other owners in, they must make good faith offers in that process. The applicant must submit a plan describing how the unit will encourage sustainable use and have equitable compensation. So this is how the geothermal fluids will be produced and re-injected, and how they're abiding by the requirements of the equitable compensation rules. The applicant is required to review all existing wells within the unit, as well as 1/4 mile around the unit, ensuring that they're really thinking about all the different wells in the area and making sure that there is no kind of conflicts or additional remediation efforts that need to occur there. The applicant must include proof of ownership within the unit, and operators who demonstrate that they own the entire unit will not need to address equitable compensation. So moving into the operations part of the the rules, the operators are required to submit how they constructed the location, how they drilled the well, if any stimulation occurred, and provide details on these activities. They're also required to log all the wells, and there's additional requirements for logging injection wells. So all of these wells will be acquiring data and submitting that data to us. There's also abandonment requirements for all wells. Moving into kind of the water reporting. So throughout many of these projects, they'll be producing and injecting a lot of water in and out of the ground. So there's requirements to accurately catalog all these different volumes, if they're using any makeup fluid to maintain these reservoir levels or pressures. What are the temperatures and flow rates at the wellbore? Was any reused or recycled water used in the project, and annual fluid usage reporting that would be submitted annually, just for kind of a holistic view of how the reservoir and water and fluid volumes were managed. Further, for protections and safety, there is mechanical integrity testing and reporting required within 30 days of completing the well. So once the well is drilled and cased, they must test it that it has good mechanical integrity. After that, there's ongoing mechanical and integrity tests and braided head monitoring to ensure the wellbore is working properly and no leaks are happening. There's also seismic monitoring that can be required by the permit that will need to be done on a site-specific case. There's corrosion risk assessment, as corrosion can be an issue in geothermal projects. So operators will be required to look at it and have ongoing monitoring as necessary to ensure that corrosion doesn't become a problem. There's groundwater sampling and monitoring for the protection of all of our underground sources of drinking water and ensuring that this project isn't harming any of those aquifers. Moving on, these are kind of similar protections that we've seen with oil and gas operations. There's signage requirements, fire prevention and protection, hydrogen sulfide gas protections as necessary, flow line integrity regulations, as well as interim reclamation requirements to bring the location back to a working pad surface after the initial drilling of the well. Moving on to financial assurance. There's a single well and location financial assurance structure. Single well financial assurance is based on depth, and it's 100,000 per location. There are plan requirements for the operator to submit these plans, as well as annual and discretionary reviews of the plans. For all operators, there's general liability insurance to ensure they're operating in a way supportive of sustainable operations that doesn't leave the state liable for anything. I wanted to remark a bit on the special deep geothermal zones. It is rules based that are local government focused. It's required collaboration between ECMC and local governments to tailor requirements to local concerns or local technology use. It always requires local government approval and collaboration with the commission. And this is intended to create flexibility in localities that want to promote geothermal development and maybe emphasize certain technologies. And wanted to say that we put out our initial notice in May, and we put out an updated draft in July. We really appreciate all the feedback from our stakeholders. We got a lot of meaningful, really good input, and included a lot of this input into a secondary draft that we put out last month. Some of the updates that were made was an update to include consultation and notification to the BLM when near federal lands, and tribal governments when near the tribal lands. Rule 211 was updated to be more in line with geothermal wells. The flow line definition was updated to include upstream flow lines connecting potential power facilities with ECMC well locations. Additionally, there's a rule added for amending units to clarify how operators will amend units as necessary after a project begins if their initial impact to the geothermal resource was maybe not what, or after collecting data while the operation is ongoing. Maybe it says it's a little larger impact. This gives a clear ability to extend the unit to protect the correlative rights of these property owners. And again, I just want to thank all the stakeholders for taking the time to review and give a lot of feedback to us. And we look forward to all the discussions, and happy to answer additional questions on any of this. I kept it pretty general as to keep everything moving. So appreciate the time this morning, and thanks again.
Thank you, Mr. Rigby. Before we open it up for questions, AAG Boudreau, do you have anything further to add to the presentation?
Thank you, Mr. Chairman. Yeah, I just wanted to go through real quickly the requirements by the Geothermal Resources Act, which is the statute from which ECMC gets its regulatory authority over deep geothermal ops. I'd point everyone to 3790.5 of the Colorado Revised Statutes, which is the Geothermal Resources Act, specifically Section 106, discussing ECMC's requirements for promulgating the rules we're here to talk about today. The requirements are that ECMC promulgate rules that, 1, protect public health, safety, and welfare, including the protection of the environment and wildlife resources, and that avoid, minimize, mitigate adverse impacts to disproportionately impacted communities. The Geothermal Resources Act also requires that the commission not issue an operations permit for deep geothermal operations unless the applicant provides evidence that the applicant has filed an application with the local government with jurisdiction to approve the siting of the proposed deep geothermal operations, including the local government's disposition of that application, or that the local government does not regulate siting of deep geothermal locations. The only other thing I'd add is staff has noticed and appreciates input from stakeholders, both through stakeholder discussions, pre-hearing statements, written testimony, and the public comments this morning, recognizing that there's concern about cumulative impacts analyses and whether or not they're applied here. A little context there. Staff left cumulative impacts out of the deep geothermal operations draft based on our reading of the Oil and Gas Conservation Act, which is 3460 of the Colorado Revised Statutes, specifically Section 103, which is the definitions, subsection 7, limits cumulative impacts analyses to proposed or amended operations regulated by the commission pursuant to Article 60. So the legislature specifically pointing out that cumulative impacts analyses are meant to apply to those activities regulated pursuant to Article 60, which are things like oil, natural gas, underground natural gas storage, CCS. And as I mentioned earlier, Commission's regulatory authority over geothermal resources is not derived from Article 60, but rather Title 37, Article 90.5. So I just wanted to provide a little context there on why staff's draft handled this situation the way that we did.
Okay, thank you very much, Mr. Boudreau. Can I ask you just a follow-up on the interplay with local government? How does the staff draft sort of approach that? I know that The authority was provided to ECMC for deep geothermal. It preserved authority for local governments with regard to siting things. Who goes first? Does it matter? They both permits have to get obtained, I believe. You speak a little further into that piece.
Yeah, I think that's a great question, Mr. Chair. You're right. The operator would need essentially 2 green lights, assuming you're operating in a jurisdiction where the local government regulates siting of deep geothermal locations. You would need 2 green lights, one from the state, the ECMC, and another from the local government. There's nothing to stop a local government from promulgating siting rules that are more stringent than those promulgated by this commission. And the way the rules address this, or the draft rules address this, at draft rule 1303, the operator is required to provide in their permit application for deep geothermal ops whether or not they've applied to the local government for a siting disposition and what the outcome of that is. And then moving on to 1303C, that kind of determines, based on how the local government made that determination, it sort of spells out what the next steps would be for ECMC. So if the local government does not cite deep geothermal locations, then the director will conduct a siting review pursuant to the 1300 rules. In other words, the way that the rules are spelled out. If the local government has denied the siting of the deep geothermal location, ECMC will have a hearing before the commission rather than an ALJ or a hearing officer, and the commission will make a determination on what to do about that. Having said that, from the operator's standpoint, even if you somehow get a permit from ECMC, but the local government has denied your siting, going back to what we said earlier, you need a green light from both of them. So the fact that the draft rules don't specifically say you have to deny the permit if the local government has denied it, that doesn't mean that anyone's usurping local government authority. So you being the operator would still need a permit from the local government.
Thank you very much. I think that's a helpful point of clarification for folks as we move into this rulemaking. Commissioners, Mr. Rigby and AG Boudreau are available for questions. Commissioner Ackerman?
Thank you, Mr. Chair. Just wanted to point out that I've had an opportunity to work with these gentlemen and many others over the last year as the Commission's liaison on geothermal matters, and wanted to thank them for the great work that they've done and many, many others. And we'll talk more about that, I'm sure, throughout this process. But Mr. Rigby, I think this question's for you. I know as part of the legislation, there were 2 geothermal studies also required. One of those was a resource study, which has been released. The other was a regulatory study. Can you talk a little bit more about or a little bit at least, about the nature of the regulatory study and just give a brief synopsis of how that will work?
Sure, happy to. So we did just release our resource study. That is a valuable data resource for anyone who has an information resource. It is posted on our site. It was posted about a month ago, and has a lot of good information on the resources around the state. As to the regulatory study, that is due in December. We are actively working in collaboration with the Division of Water Resources to identify, as we have through our work on this rulemaking, as well as the resource study, if we've identified anything that might need further attention. We are diving into the details of any additional legal or regulatory clarifications that may need done. And the study will be a collaboration with the DWR, as I stated, and we'll be identifying topics that we think maybe need further study to really identify if there's just more work that needs to be done either in law or in regulation. So it will be flagging additional topics to be discussed and move forward in December. So that's the general idea. Some of the kind of topics we're just initially thinking about is how oil and gas operations work with geothermal and things of that sort. So and making sure there isn't any kind of different legal barriers or regulatory barriers in the state as these operations kind of progress into the future.
Thank you, Mr. Rigby. And one more question for Mr. Boudreau. Again, appreciate his insight and work on the legal side of this. And with regard to the Geothermal Resources Act, Mr. Boudreau, can you characterize the legislative intent as far as the legislative interest in moving forward with geothermal exploration in Colorado?
Yeah, I think that's a great question. The legislature spells out a declaration at 3790.5102 that the development of geothermal resources is in the public interest in that it enhances local economies and provides an alternative to conventional fuel sources, and that it should be undertaken in a manner to safeguard life, health, property, public welfare, and the environment, including wildlife resources, but also to encourage the maximum economic recovery of each resource and to prevent its waste and to protect the correlative rights of those who own the geothermal resources. So the legislature was pretty clear. I think that they see this as a public benefit, deep geothermal operations, one that can help with the energy transition away from those energy sources producing greenhouse gases to ones that are more ecologically sustainable. So yeah, that's kind of what the legislature directed us to do there.
Thank you, Mr. Boudreau. Nothing further from me, Mr. Chair, this time.
On that topic, Mr. Boudreau, can you articulate or Mr. Rigby articulate kind of that balancing act in terms of creating a regulatory environment that will incentivize this new type of deep geothermal? And then also, can you speak to how it is a little bit of a chicken and egg sort of thing, in my opinion? Like, we don't know exactly what all the different types of uses are going to be, but we want to make sure that we're protective. If you could speak to either of those, that would be helpful.
I think that's a great point. So yeah, on the one hand, this is a nascent industry in Colorado, and we've gotten a lot of that from stakeholders all across the spectrum, that there needs to be flexibility in the way that operators propose these projects, flexibility in the way that they drill the wells, operate the subsurface operations, but also flexibility in what's going on in the surface and the end uses and their ability to be able to use the geothermal resources utilized for a wide variety of end uses, whether that be energy production, cascading uses, meaning after energy production, further uses for the geothermal resource, direct uses of heating homes, greenhouses, aquaculture, that sort of thing. So, but at the same time, we have to protect public health, safety, welfare, and the environment. And so the staff draft incorporates a number of technical requirements that we see in some oil and gas rules, particularly those associated with wells, the drilling of wells, and the operation of those. So you'll see a lot of rules from the oil and gas series incorporated by reference, specifically at 1305. Permitting requirements, 1305B2 is the Form 2 that'll be required. That's the form in which the operator describes their intentions of how they're going to drill the well, and includes a lot of the protections that you see from oil and gas, including things like a wellbore diagram, a deviated drilling plan, casing and cementing plan, offset well evaluation, details about hydraulic fracturing if it's at depths of less than 2,000 feet. So in compiling staff's draft, staff did our best to sort of strike a balance between making these projects permittable in a way that encourages operators to come to Colorado and develop these projects, but at the same time, paying homage to ECMC's well-developed regulatory experience in protecting public health, safety, and welfare in the state.
Thank you for that. I think that's an important point that will be vetted as we move through the parties in this. Commissioner Messner had raised his hand.
Thank you, Mr. Chair. Appreciate all the work that's been done on the draft rules. Certainly
a lot of thought has been put into these, and I did have just one question as I've got you here as we go into the next stages of the rulemaking. I think Mr. Boudreau, you acknowledged some of the requirements associated with the act. And I think one of those requirements talks about the local government's disposition and how that ties into ECMC's decision-making on permit applications. And I'm trying to understand from staff's perspective, how you feel like that piece of it has been met with the drafts, in particular, as you look at the 1303B, which is the local government siting information, and the recent inclusion of number 4, which is the relevant local government regulates the siting of deep geothermal locations, but has not made a decision on the siting of the proposed deep geothermal location. And then again in C, where the director has to review the local government siting information, but may or may not know the disposition.
Yeah, thank you, Commissioner Messner. I think that's an important question to clarify. So there was concern from stakeholders that if the local government denies the siting of the deep geothermal location, some suggested that that should prompt an automatic denial by ECMC. The reason staff wrote that up the way that we did is recognizing the local government's authority to cite in accordance with their own rules. Staff didn't want to include sort of anything that would automatically, basically it's like a co-equal citing authority situation. So the local government can't tell ECMC what to permit or not permit, but at the same time, ECMC also cannot tell local governments how our regulations might impact their permitting determination. And so that's why we kind of wrote it in a way that didn't automatically prompt a denial or any kind of other outcome. It just prompts a commission hearing to determine what the situation is. I think realistically, it'd be difficult to imagine an operator pushing forward with an ECMC deep geothermal operations permit if they know that they don't have the siting permit from the local government. It would seem like, in my mind, an exercise in futility. So we wrote 1303 B and C in a way that was meant to not force anyone's hand in an effort to recognize that sort of co-equal authority.
No, I appreciate that. And I think I was thinking about it more in line of not what would happen if the local government had denied the permit, but more in line of whether or not the applicant is far enough through the local government process to be able to provide information to ECMC as to the disposition of the local governments from a siting perspective. Understanding that we may or may not be able to get a disposition of the local governments from a siting perspective until it's pretty far through the process. And so I'm just trying to understand in your mind how you thought that that would work.
Okay, so we're talking about a hypothetical in which the operator has applied with the local government but doesn't have an answer on their local government permit yet.
Well, specifically in the rules in 1303B4, where it does indicates that the relevant local government regulates the siting of deep geothermal location, but has not made a decision on the siting of the proposed deep geothermal location. That's allowable within the state rules, but I'm trying to understand how the operator is going to be able to determine the disposition of the local government under 1303B4, because then again in 1303C it indicates that the director will conduct a siting review pursuant to the Commission's 1300 series rules if 1303B4 applies. Does that make sense?
I think so, yes. So one thing I want to point out right at the top is before ECMC and the operator get to the point that we're talking about, there will have already been a pre-application consultation with the local government to address any siting concerns the local government has. So ideally, the permitting unit at ECMC will have some idea of how the local government in mind at issue is sort of thinking about it. If they don't have, and then if you get to the point where you have the operator has submitted their permit application for deep geothermal ops, there's been a completeness determination pursuant to 1305 D, I believe, and they still don't have information on whether the local government is going to approve or deny, or any kind of sufficient information to give the commission any indication of where the local permit is going. I think that would be a situation where the director will conduct a siting review pursuant to the 1300 series, make a determination on whether or not ECMC approves the deep geothermal location, but at the same time recognize that whether or not the director of the commission approves the proposed location, that ultimately the operator would still need the permit from the local government. So it's not ECMC's place to enforce the local government regulations, but certainly the staff draft recognizes that the operator would need both permits in that situation. One of the reasons we wrote it like this is we didn't want to force the local government's hand to sort of live by some sort of timeline that we set out in our rules. We just felt like we didn't have the authority for that.
Okay, thank you.
Other questions for the panel? Commissioner Oath.
Thank you, and appreciate these questions so far about clarifying some things with the local government. This has been really helpful. And hold on, I just lost my list of questions. Where did they go? There we go. I wanted to make sure I understood something that was said earlier around this local government piece, that if the local government has denied, then there will be a full commission hearing. And I think I heard that there would not be a hearing with an ALJ or a hearing officer. And so are there cases when there would be a hearing with an ALJ or hearing officer? I think my understanding of administrative approval was sort of with the director level approval, and that the options or like the pathways were either director level administrative approval or a full commission hearing. But is there a third pathway that is a hearing with an ALJ or hearing officer?
That's a great clarifying question, Commissioner Oath. No, there's not a third pathway. That's just meant to specify that when it goes to the commission, the decision won't be delegated to the hearing officer or the ALJ.
Okay, got it. Okay, thank you. Okay, and bear with me, my list of questions are a little bit jumping around a bit from my preparation. So with respect to the provisions added around tribal governments, appreciate that new section. Can you speak a little bit to who will determine if an impact to tribal minerals or geothermal resources may occur? So the new language, says that, there will be a consultation if there is a potential impact. So just, who makes that decision, and kind of what happens if there's a difference of opinion in terms of maybe staff has one viewpoint on that and the tribe has another viewpoint on that?
That's another really good question. So I'm not sure I have a definitive answer for you, other than the tribal government should receive notice if an operation is proposed nearby one of their reservations. I guess I'd imagine the tribe would make a determination of whether or not they feel like their geothermal resources or other minerals may be impacted by the proposed operation, and then that would trigger the consultation. So it's meant to be, it was drafted to be more inclusive rather than less.
Okay, so I think I hear what you're saying is that basically it will be the tribe that can make that that will make the determination of whether the tribe believes that there could be an impact, and then the consultation will occur.
In my mind, yes.
Okay, thank you. Can we talk about special deep geothermal zones a bit? There were a lot of comments and questions about that. Appreciate kind of the slide on that, but would love to explore that a little bit more and hear kind of what the thinking is in terms of the advantages of them. And so let's say one is created, then kind of what happens differently for a permit that is requested or applied for in a special deep geothermal zone.
So I think the direct answer to your question is it would depend on what are the sort of parameters in creating the special deep geothermal zone. So it's special deep geothermal zones 1321 was written in a way that was meant to be flexible, create flexibility, especially at the early stages of deep geothermal here in Colorado. It's worth noting that a special deep geothermal zone cannot be created without express approval of every individual provision of the special deep geothermal zone by both the local government and ECMC. That being the case, I think it's possible that that applications for special deep geothermal zones could sort of run the gambit of how they function, whether that be specific things that a local government might be concerned about in a particular part of their jurisdiction that maybe they want to address that isn't already addressed in ECMC rules. Special deep geothermal zones could be a way to handle it there. Another way that special deep geothermal zones might be used is if you have a large area within a local government jurisdiction where a particular permitting provision in ECMC rules maybe doesn't apply. So just trying to think of an example off the top of my head. If there are no high priority habitats in this particular part of a county, then maybe that's something that operators don't need to include in their permit applications for deep geothermal ops. So if you create a special deep geothermal zone for this particular area, and in that special deep geothermal zone hearing, it's determined that there are no high priority habitats here. So the special deep geothermal zone order would indicate, okay, well, when an operator applies for a permit application within this special deep geothermal zone, they don't need to address the high priority habitat provision of ECMC permitting because there are no high priority habitats, and that's already been determined in the hearing for special deep geothermal zones. So nothing's being excluded without ECMC consideration. It's in that scenario. It's just that it was already considered in creating the special deep geothermal zone in the first place. So those are two examples of how special deep geothermal zones, I think, can be used quite in a quite flexible manner. But I think it's always worth sort of circling back to no special deep geothermal zone can be created under staff's draft without express approval of both the local government and the commission.
Okay.
But it is intended to allow sort of flexibility in recognition of the fact that deep geothermal operations could vary greatly, both in the way that the actual operations are conducted and in their end uses. And so, and at these early stages, we don't have the sort of 60 or 70 years worth of data that we have, like we do with oil and gas, to have a better idea of how sort of the industry functions. And we expect this to be a much more varied industry in the sense that, unlike oil and gas, where the operations are more or less the same, you drill a well, you extract the resources, you separate it, you put it into a gathering system and send it off for processing. We've gathered from stakeholders that these operations can vary greatly relative to the oil and gas scenario.
Okay. Changing topics a bit. So I was just trying to find which section it's in. So if I need to get that, let me know. But there's a section that indicates that under administrative approval by the director, a conditional approval will become effective 10 business days after that approval is provided. There was some comments about, I think specifically a request from local governments for some additional time. So want to understand what can occur during the time after a director makes a conditional approval and when it becomes effective, and whether there is, something very important about staff's proposal of 10 business days.
So I think I understand the question. You're saying during the 10 days between when the director recommend or grants a conditional approval and when it becomes final, is the question kind of like who can intervene, how can they intervene, or
Yes.
like what can
Yeah.
happen to
Yeah,
to
and if
prevent
more
it from
time is
becoming
if more
final?
time is provided, what's the purpose of that? What could a local government or other entity do during that time period?
As far as what a local government could do during that time period, I suppose they could petition the commission to review the conditionally approved permit application. I'm not 100% on that. I will say that by the time we got to a conditional approval, the local government will have been engaged in the pre-application consultation. They'll have had an opportunity to apply their local government siting regulations and make a determination on the deep geothermal location permit application. And so they'll have already had opportunities to get involved. I don't think there's anything in the rules that would preclude a local government during that 10-day period or whatever time period the commission deems appropriate. I don't think we don't have anything in the rules that would prohibit local governments from intervening during those 10 days. So if I understand your question correctly, can the local governments do anything during those 10 days? I think that would be my answer. I can't see anything in staff's draft that would indicate they can't petition the commission to take it up at a hearing rather than allowing the 10 days to end and the conditional approval to become final.
Okay. Thanks for that. Couple more questions. Sorry, thank you for bearing with me.
No, please.
So there were some comments about wanting the forms for geothermal applications to have separate names from oil and gas forms. I think that was accomplished with the Form 2G, but want to make certain that I'm understanding that right.
Yes, so there, rather than a 2A, which is the oil and gas location assessment form, the permit application for deep geothermal ops requires a Form 2G, which is the sort of geothermal equivalent of that. It's the location assessment for the deep geothermal location. And that was some stakeholder feedback that we got that, you guys should change the name of the forms that is geothermal specific, and we did that. We also changed the Form 7 to a Form 7G. The Form 7 is the monthly operations reporting form, where operators report their monthly operations in the context of geothermal. That'll be things like volumes of fluids withdrawn, volumes of fluids re-injected, those sorts of things. So that also is a geothermal specific form, the 7G. It's worth noting that the Form 2 is still the Form 2 though, which you can find at 1305B2. The Form 2 is meant to address the well itself and the sort of technical requirements of the actual well rather than the location. So that remained as a Form 2 because a lot of the technical requirements for drilling a deep geothermal well are expected to be similar to oil and gas. So the 2 remains the same from the oil and gas context. The 2A has become the 2G and the 7 has become the 7G.
Okay.
A little bit to add on the Form 2. There will be amendments particular to geothermal of the Form 2. We didn't feel they were significant enough to warrant a new form, rather just a new tab in the form. whereas the 2G will be a brand new form specifically tailored to geothermal.
Okay. Thanks. Okay, I think it's 1305E4 and 1320B, there are the provisions about how the director may refer an application to the commission for hearing. So this is sort of kind of just a general discretionary opportunity for the director to do so. And I think I understand that it seems like it's left pretty general given where we are, you know, and just early in trying to understand this a little bit better. But could you speak a little bit to maybe what types of things you expect that you would be looking at that might trigger a consideration for referring an application to full commission for hearing beyond the circumstances of the local government denial or not having made a determination that we talked about earlier?
I think that's an interesting question. It's hard to predict exactly what the director might determine to be something that warrants a commission hearing.
Yeah.
You're absolutely right. It was meant to be general, so that if there are any concerns that the director feels like can't be resolved through the administrative process, that she or he could kick it to a commission hearing. I'd be hesitant to sort of spell out what I expect the director to do, just because I don't know. But the reason we included that is recognition that this being a new industry in Colorado, there are a lot of concerns or considerations that we may not have been able to predict in compiling staff's draft. And so anyway, like you said, we kind of left it quite general, so as to allow things to sort of develop, especially in the early stages. I don't mean to dodge your question, but I feel like it would be inappropriate for me to sort of guess at what the director might consider circumstances that warrant.
Yep.
Sorry to end with an
No, I understand that. I think that's well said. I just didn't know if you had maybe some examples of things that you all had thought about and thought, well, that might be the types of things that we'd be thinking about or be looking for that might trigger it, but understand that it's hard to say at this point of where we are. So like,
I mean, I can tell you what I have in my mind, but it's no indication of what the director might do or not do. You know, I think if there's a lot of public comment, particularly with locations within 2,000 feet of DI communities, in my mind, I can imagine that might warrant a commission hearing. But again, that's just my thoughts. It's in no way meant to commit the director to any particular set of circumstances.
Okay. And then you talked pretty generally in your initial presentation about kind of monitoring that may be required, the types of like groundwater monitoring and maybe other water monitoring or air monitoring, and wondered if you could speak a little bit more specifically about what is in the rules to ensure that appropriate monitoring is in place, either by rule or through the permit process to ensure protection of public health and the environment.
Thanks, and I might ask Mike to help me out on this, Mr. Rigby to help me out on this one. But certainly monitoring, there are provisions requiring monitoring of the temperature and pressure of the subsurface formation being accessed, fluids withdrawn, fluids re-injected. Mr. Rigby, do you have more comprehensive list?
Sure. So there will be monitoring of the wellbore to ensure the integrity of the wellbore, to ensure there aren't any leaks occurring. So that'll be regular monitoring and ongoing monitoring. Reservoir pressures and things of that sort will be monitored, as well as like injection pressure to make sure they're in rates and volumes, that they're not injecting at a rate or pressure that exceeds what is capable of the receiving formation. There's also going, you know, depending on the type of project, if they're injecting larger volumes, seismic monitoring will be required. likely response plans put it onto the permit in case of any sort of, to mitigate any sort of issue in that regard. Beyond that, groundwater baseline monitoring would be done, as well as additional later monitoring on a project-specific basis, ensuring groundwaters aren't being impacted by these operations. But that also goes back to the wellbore monitoring. We'll be ensuring that the wellbore has integrity, the cement in the pipe is in good shape, the corrosion monitoring. We'll be reviewing different parts and pieces in the system to ensure they're not corroded and could fail and are replaced on time, and plans in place to ensure that they're being looked at timely and updated and replaced to ensure, again, reducing the amount of leaks. There's an emergency remedial response plans in place in case there are incidents to be promptly dealt with. So that is what's currently in the rules. I might be missing one or two items, but certainly project-specific conditions of approval could be placed on the permit for specific considerations to that particular site.
And those might be like air or water monitoring that come out of the consultation with CDPHE or others, for example.
Yes, and other agencies are able to, during the consultation process, provide this type of input for conditions on permits.
Thanks. Thank you very much. I think that is all my questions for now.
Others with questions? Commissioner Cross?
Thank you, Mr. Chair, and thank you for this information that's been provided today. It's definitely helpful to understand a little bit of the background for this and some of the thought processes that went into place in drafting and amending the rules. I want to try and get a better understanding of some of your thoughts behind the time limits in permitting. I know it was brought up in several of the comments that were prepared about longer periods, and even the period that was provided is different than what we have for oil and gas drilling. And so I was kind of curious the thought process that went into the 3 years in 1307.
Oh, for expiration.
Yes.
Yes. First of all, you're absolutely right. That was something we got a lot of feedback from stakeholders after staff put forth a proposed draft. Some saying 3 years is not quite long enough. Others indicating 3 years is fine. I'm not sure that staff. I think staff, in putting the 3 years down, recognize that ultimately that would be a decision for the commission to make on what would be an appropriate amount of time before a permit expires. Also, I would point out that though 1307 is written so that you have 3 years from the time the well is permitted or the location is permitted to start operations, that's not necessarily the only possible sort of measuring stick. It could be 3 or 5 years from the time it's permitted until the time you complete the well. So there are options that the commission can use on when to measure the expiration or when the permits expire. 3 years was meant to be a starting point and to kind of see what happened from stakeholders, whether they thought that was long enough, whether they thought 3 years from the time the permit until you start the operations is appropriate, or maybe a longer period of time from the time the permit's granted until you complete the well. So there's a number of options that I think the commission can choose there. And 3 years until the point of starting operations was, what staff thought was appropriate to recommend, but also recognize that there's no reason the commission couldn't adjust that however they deem appropriate.
Perfect. I appreciate that clarification. I think all my other questions were already asked. Thank you.
Commissioner Messner?
Thanks, Mr. Chair. I just have a redo here quick, and I think this is a good time to make a clarification or just provide some information. I think I know that there was a lot of comments around the special deep geothermal areas, and this was a an idea that I had provided to staff. And so wanted to at least provide some clarity around my thought process for making a recommendation towards it. I'm not sure it's a good idea or not, but I wanted to at least provide why I proposed it. So in local government land use processes, there's certain provisions that get utilized to look at applying special provisions for certain areas in the geographic area that the local government has jurisdiction over. Some of those local government provisions include the utilization of planned unit developments, or special area regulations, or things of that sort. My thought in this process was that if a local government was interested, they could cooperatively work with the state to develop special geographic areas specific to deep geothermal development and do the necessary groundwork and public processes to pre-authorize those prior to an application being in place and apply any local specific rules, regulations, or considerations to those in a cooperative effort with the state to identify areas where there may be unique circumstances that may be optimal for geothermal development, whether that's a retirement of a coal-fired power plant that has existing transmission lines or infrastructure that could be utilized in deep geothermal development, or areas within a local government jurisdiction that are uniquely appropriate for this type of development. And really the thought process there was to do the pre-planning and the public outreach and input on these areas prior to an applicant being there, so that a lot of the issues and considerations would get worked out before an application was in hand. And when an application did ultimately get in hand, it may make a more efficient process for the applicant, because the pre-work between the state and the local government cooperatively had already been done. It may or may not be a good idea, but I wanted to just at least provide some perspective on why I had suggested the concept, at least in pulling from land use considerations that local governments use pretty regularly. And so I wanted to at least make that statement. So if everyone hates it, you can blame me. How's that? The other question I had, because there was a lot of comments around this, both from a public comment standpoint and in pre-hearing statements. So I wonder if you could provide a little more detail around the protections that are proposed in the rules for repurposing existing oil wells into deep geothermal development, and in particularly ensuring that that allowed provision in the rules doesn't create opportunities for abuse.
Thank you, Commissioner Messner. I think you're asking about the provisions we added to 1320 regarding the specific applicability of Rule 211. Is that right? I'm glad you did, because that is a pretty big revision that we made from the originally noticed draft, and it gets a little abstract pretty quickly. So I'll try to make this as clear as I can. So stakeholders identified, we think what they were identifying is two situations where they were concerned about how Rule 211 applies. So just some clarification. Rule 211 in its most broad sense is a rule in which local government or surface owners can petition the commission to issue an order compelling an oil and gas operator, or just any operator, to plug and abandon a well. And the standard for doing that includes that the applicant, the local government or the surface owner, needs to verify that the well, the oil and gas well, has been low producing for at least the last 3 years. And there's a definition for low producing in the rules. and that the well is no longer used or useful. And it's worth noting that the sort of used or useful provision is not only a requirement that the applicant needs to meet, but it's also a potential defense from an operator standpoint. So if you have a 211 application to P&A one of your wells, you being the operator can indicate that we think the well still has future use or usefulness in order to try to avoid the order to P&A your well. So the two scenarios that we think stakeholders were trying to identify and that we tried to address in the revised draft are, one, how do you apply that low producing for 3 years standard to a deep geothermal well, considering we don't really expect geothermal wells to see that sort of drop off in production toward the end of their life. So in that context, low producing doesn't really make sense. So that's why we adjusted 211's applicability so that if an applicant, a local government or surface owner, wants to petition the commission to order the P&A of a geothermal well, rather than indicating that the well has been low producing for 3 years, the applicant would indicate that the well has been inactive for 3 years. And that's meant to recognize what that we don't expect to see that drop off in production. The second scenario is when an oil and gas operator has an oil and gas well and an applicant petitions to have that well P&A'd by commission order, and the operator uses that used or useful as a defense, and specifically in the context of geothermal, saying, okay, we've got a 211 application to force us to P&A one of our wells, but we think it has future use or usefulness as a deep geothermal well, and we're going to do that. The concern from stakeholders was that's sort of like an indefinite defense to never have to P&A your well, and if there's no way to make the operator prove up their intentions to convert the well, then it's really just a sort of indefinite defense to avoid 211 forever. So the way we tried to address this situation is to adjust the way 211 applies in that scenario. So the applicant would still apply and indicate that the well has been low producing for the last 3 years, that it is no longer used or useful. The operator would respond saying, well, we think the well is used or useful in the future because we're going to convert it to a deep geothermal well. In order for the operator to access that, for lack of a better term, defense, they would need to have applied to convert the well to a deep geothermal well within the first 3 years of it becoming inactive. Otherwise, there'll be a rebuttable presumption that it is not, that the well does not have future use or usefulness, a rebuttable presumption that the operator would have the burden of overcoming it here. So, and the reason we included the rebuttable presumption is there is a bit of a catch-22 built into that, which is the applicant can't petition the commission to force the P&A of an oil and gas well until it's been low producing for 3 years. And by that point, the operator's 3 years to apply to convert the well will have already passed. Ideally, the operator will have applied within those 3 years to convert the well, but if they haven't, that option is not completely foreclosed. It's just that there's a rebuttable presumption that the operator wasn't planning to do it and is now only using this as a defense.
Okay,
So
thank you.
it's pretty convoluted, but it's meant to address two fairly specific and fact-intensive scenarios.
No further questions, Mr. Chair.
All right. Well, Mr. Rigby and Mr. Boudreau, we really appreciate your initiating this rulemaking. I too want to extend our thanks to the good work you've done over the course of the last several months. Also want to recognize Commissioner Ackerman for his leadership on behalf of the commission. Really appreciate that, Commissioner Ackerman. With that, we'll let you go for now. Stick around. We've got a lot to hear from a lot of different stakeholders. And at times we may want to bring you back up to for further questions, which I believe we've got the right to do. With that, I believe we're now going to hear a short presentation from the Colorado Energy Office, and then after that, we'll take our morning break. Good morning, Mr. Tour.
Good morning. My name is Will Tour, and I'm the Executive Director of the Colorado Energy Office, and really appreciate the opportunity to speak with you this morning. The Energy Office supports the proposed rules. We believe they set the right balance of being appropriately protective while enabling development of deep geothermal in Colorado. The office believes that the new definitions in the 100 series rules and the inclusion of the new 1330 series rules for deep geothermal support the use of geothermal energy and electricity production, which is a really important 24/7 reliable, dispatchable, clean energy resource that will be important for the state to meet its goal of achieving near zero GHG emissions in the electric power sector. I'd also note that as chair of Western Governors Association in 2023, Governor Polis's chair initiative, Heat Beneath Our Feet, examined opportunities for and barriers to the increasing deployment of geothermal energy for both electricity generation and heating and cooling systems in Western states, where the vast majority of high-yield geothermal energy capacity in the US is located. The initiative's final report identified improving regulatory certainty and optimizing permitting as one of the most important steps to increase development and deployment of geothermal energy in the West. I want to give just a little bit of context as to why our office thinks that geothermal is so important. As a reminder, all the way back in 2019, the legislature adopted economy-wide climate goals for the state. We now have a goal of cutting economy-wide greenhouse gas emissions in half by 2030 and of achieving net zero emissions by 2050. And in order to do that, we are going to need a lot of clean electricity. The electricity sector is the sector that has been decarbonizing most rapidly. We're on a trajectory towards about 85 to 88% GHG reductions in the electricity sector by 2030. That is really driven by the deployment of low-cost wind and solar and increasingly battery storage, while using existing natural gas capacity as essentially the balancing and firming resource. We've recently done analysis looking out past 2030, working with the consulting firm Ascend Analytics to understand pathways out to 2040. And when you think about electricity needs in the 2030s, it's in a context where we're going to be electrifying a lot of sectors of the economy. In order to achieve our climate goals, we need to move away from gasoline and diesel vehicles to widespread use of electric cars, trucks, and buses. We are going to need a very significant expansion of the use of electric heat pumps for heating and cooling buildings. And we are increasingly seeing the importance of electricity in reducing emissions from the industrial sector through things like industrial heat pumps or through electrification of operations in the oil and gas sector. All of this means that based upon our analysis, we're looking at least a 50% increase in electricity demand by 2040. And when we looked at sort of the pathways to meet that demand, certainly wind and solar are the workhorses because they are so low cost. The deployment of significant amounts of wind and solar will help us to meet those demand at the lowest cost to customers while also driving emissions down. But if we want to get all the way to zero emissions, we also need to have zero carbon resources that aren't intermittent but are 24/7 and dispatchable, can be ramped up in order to match the needs of a primarily wind and solar grid. And in the analysis that Ascend Analytics did for us, what we saw was that geothermal electricity was really one of the most cost-effective resources for doing that. When we looked across the whole range of zero-emission resources that were out there, the two that rose to the top as being the lowest cost were the use of clean hydrogen and the development of deep geothermal electricity. I would also note that the legislature has taken multiple steps to support the deployment of geothermal in this state. That includes legislation creating a grant program to support both geothermal heating and cooling and geothermal electricity production. The Energy Office recently made the first set of awards, including 6 awards to support geothermal electricity production. Tax credits through House Bill 23-1372 that create production tax credits and investment tax credits for geothermal electricity, as well as the legislation, directing the Energy and Carbon Management Commission to address permitting for geothermal. While technology advancements are making geothermal electricity production viable over a much larger area than older approaches, it's worth noting that the production of electricity using geothermal resources is very well understood, safe, and has been in use for decades in many locations around the world, including in the US. If you look at California and Nevada, which have had geothermal production for a long time, or if you look at places like Iceland that have had many decades of experience with geothermal, what we've seen is that this is really a well understood and safe technology. Deploying geothermal will have the direct effect of reducing combustion of fossil fuels for power and reducing the demand for fossil fuels that drives extraction. It's essential that regulatory requirements don't create unnecessary barriers or processes that will delay the deployment of geothermal electricity in Colorado. Given this reality and the low level of risks of impacts associated with geothermal electricity, it's appropriate to have a relatively simple and quick process as compared to oil and gas development. I think that the legislature recognizes this, and specifically, for example, did not require the use of cumulative impact analysis that is required for oil and gas development. And the commission should not impose such a requirement. As the ECMC considers comments and testimony in this rulemaking, it's important to see geothermal electricity production in its broader context. It's a proven, safe resource that can be used for direct heating and cooling as well as electricity generation. Colorado's greenhouse gas reduction targets require a rapid transition to zero carbon electricity sources, and a stable, reliable resource provided by geothermal is extremely promising, offering the option for both baseload and flexible power that will complement wind and solar. The Energy Office urges ECMC to adopt rules that recognize the potential of geothermal in Colorado to meet our climate goals and help reduce energy costs for Coloradans, and to provide a predictable, efficient regulatory environment to ensure that we capitalize on this opportunity. And we believe that the draft rules before you do this. Thank you very much.
Thank you, Mr. Tour. Appreciate your being with us and providing those comments. Let me explore just a little further. So you started out with the words, the correct balance, and you sort of ended with that. Can you just sort of amplify that? We do have a lot of stakeholders that are making points in pre-hearing statements and responses that these are not nearly enough, that they need to be more robust, they need to be, there needs to be more involvement, that there needs to be the cumulative impact analysis, et cetera. But is it CEO's position that this is, as drafted, is, kind of in the right spot in terms of the balance of protective, while also creating something that is predictable and will ensure, safe, effective, deep geothermal in its embryonic stage here in the state?
So yes, I would say that we believe that the draft rules that are before you strike that appropriate balance. That when you look at what is known about geothermal, this is not a high-risk technology. This is very different, for example, from oil and gas drilling, in that you are not you continually sort of releasing volatile compounds into the atmosphere. You don't have the same sort of issue with VOCs and with methane. And at the same time, because geothermal is so important as a technology for deep decarbonization of the electricity system, which really is the essential technology that will enable a reduction of GHG pollution from transportation, buildings, and industry, the environmental benefits from rapid deployment of geothermal, we think, are far greater than any risks associated with it. That said, we think that it is appropriate on a site-specific basis, to make sure that you're taking an appropriate look at the relatively small impacts and risks associated with geothermal, And we think that the rule as drafted gives you the tools that you need to appropriately examine and mitigate any of those site-specific impacts while still allowing the industry as a whole the predictability that it needs to move forward in our state.
Thank you for the clarification. It's much appreciated. Do any of the other commissioners have questions of Mr. Tour? Commissioner Ackerman?
Thank you, Mr. Chair. And Mr. Tour, thank you for your leadership on this issue. I feel like we've had a lot of great work done at many levels, including from your office and from your staff. I just, as per your last comment there, I wanted to double check and see if you feel the way that I do, that if, as we work towards deploying geothermal, that taking a balanced approach that like we keep talking about, do you feel like the regulatory study that's mandated gives us in DWR an opportunity to maybe examine some of these issues that, we think will either be issues or not issues, and have another opportunity to be able to, work with the legislature and or our rules or DWR's rules to be a little bit of a, I don't want to say fluid, but a little bit of an extra opportunity to continue to examine how geothermal regulations might be deployed over the long term in Colorado.
So I would agree with that statement. Much as I would like to say that we always get everything exactly right, in the real world, we certainly learn as we go, and I think that there will be opportunities as we deploy geothermal if we discover that there are tweaks that are needed to the rules in order to either remove unnecessary barriers to deployment of geothermal, or we found that here are some impacts that we really should be addressing in ways that go beyond the initial set of rules. I would certainly anticipate that these rules will evolve over time as we learn both from the regulatory study and from sort of real world deployment experience. That said, I think there is enough experience from other areas to be fairly confident that we're hitting pretty close to the mark with the initial set of rules.
Thank you, Director Torrigan. Thanks for being here.
Anyone else? Director Tour, we really appreciate you being with us. Thank you very much for the comments and for being involved with us as we try to land the correct permitting regime for the state of Colorado.
Thank you very much.
Commissioners, let's take a morning break. Let's return at 10:45. That's about 12 minutes out, and we'll see everybody at 12:45, and then we'll get into party presentations. All right, welcome back. This is docket 240500115, the deep geothermal rulemaking before the Colorado Energy and Carbon Management Commission. We received in the amended final pre-hearing order, and that allocates the time presentations for the parties that are with us. I note from that docket that Oxy USA, who had received an allocation of 30 minutes, has ceded that time to Geothermal Rising, and that Geothermal Rising has now 78 minutes. The time allotments are inclusive of presentations and rebuttals. They do not calculate time by commissioners that may ask questions. With that, I see Mr. Lepore, attorney for Geothermal Rising, is with us. Mr. Lepore, do you have witnesses this morning?
Good morning, Mr. Chairman. We do have witnesses, two witnesses, Dr. Bryant Jones and Miss Joanna Ostrom.
I see they both are on the panel. If you'd like to go ahead and have them visualize themselves, we'll get them sworn in. A.G. Davenport, are you with us?
Apologies, Chair. I having some internet issues, but I'm here.
Okay, we got two witnesses to swear in.
Okay. I will start with Miss Ostrom. Would you please raise your hand, state your name, and that you swear to tell the truth?
Joanna Ostrom, and I swear to tell the truth.
Thank you. Mr. Jones?
I'm Bryant Jones, and I swear to tell the truth.
Thank you.
All right, Mr. Lepore, the floor is yours. And before we get started, Hearings Manager Thomas, are you the official timekeeper?
Yes, I'll be keeping time this morning. Another hearings unit individual will be doing it this afternoon, but I will have that for now.
Okay, sounds good. Mr. Lepore, the panel is yours.
Thank you very much, Mr. Chair. Before I launch, for the timekeeping purposes, I'd like to reserve 25 minutes of our time for rebuttal. I don't know if that's my responsibility or the hearing officers, but put that out there.
Kind of a little of both. We'll try to get the hearing officer to make sure he keeps track as well.
Very well. Good morning, Commissioners, Mr. Chairman. A special welcome to Commissioner Oath. You seem to have transitioned successfully from the frying pan to the fire. It is my pleasure to appear before you today for this landmark deep geothermal rulemaking. I am privileged to represent Geothermal Rising, the oldest geothermal association in the world. Geothermal Rising sincerely appreciates the staff, the assistant attorneys general, and the commissioners for your engagement with stakeholders over the past year to develop the revised draft rules now before us. We also appreciate the participation of the other parties, and we look forward to arriving at a set of deep geothermal rules that will usher in a new era of clean, reliable, baseload power generation, heating and cooling, and just energy transition jobs in Colorado. After launching his Heat Beneath Our Feet initiative 2 years ago, Governor Polis has championed geothermal energy development across the state, seeking to jumpstart adoption of geothermal energy technologies. The General Assembly has also been a strong supporter, passing 5 bills in the past few years to promote geothermal energy development. The Colorado Energy Office is on board too, as you just heard from Director Will Tour. They have doled out $7.7 million of grants this May, and there's more on the way. With this rulemaking, commissioners, you are now the gatekeepers of geothermal energy's future in Colorado. To attract geothermal operators and investment to Colorado, we must have regulations that are efficient, provide regulatory certainty, are right-sized for the fledgling industry as it exists today, and that protect public health, safety, welfare, the environment, and wildlife resources. The Heat Beneath Our Feet initiative describes this as optimizing permitting to encourage more exploration and discovery of geothermal resources. Just last week, while promoting geothermal energy in Vail, Governor Polis said, quote, "We want to make it easy to site and permit geothermal, and we will be one of the first states to really have an expedited approval system for geothermal." Commissioners, Geothermal Rising hopes that Governor Polis is right. Whether he is will depend largely on what this commission does in the next few days. Geothermal Rising largely supports the July 23rd revised draft rules. We believe the rules are protective of people, wildlife, and the environment. We believe they will provide regulatory certainty. And while we would not call them a model of efficiency, we understand they represent the Colorado way. As Director Tour just said, we believe these rules strike the right balance between protecting and encouraging investment and development in geothermal. We are recommending 2 minor changes to the rules. First, we share 350 Colorado's and GeoX Energy's concerns about proposed Rule 1321. As written, it is unduly vague and could be misused in ways that Commissioner Messner did not attend and in ways that would be detrimental to future geothermal development. Second, we again agree with GeoX that a permit duration of just 3 years is inadequate and suggest an initial duration of at least 5 years. Dr. Jones, Executive Director of Geothermal Rising, will testify about these proposed changes in greater detail shortly. Our greater focus is to avoid overwhelming a nascent geothermal industry by loading up the rules with requirements that ignore the current scope and scale of geothermal development and are predicated on the false premise that geothermal development will have the same environmental impacts as hydrocarbon development. The allied local governments, Larimer County, 350 Colorado, proposed to mandate a cumulative impact analysis, an alternative location analysis, a 2,000-foot setback, and a commission hearing on all deep geothermal operation permits. Those changes would eliminate any possibility of an expedited approval system for geothermal, and they would create unnecessary barriers to entry for new geothermal energy development, exactly the opposite of what Governor Polis hopes to achieve. Geothermal Rising opposes those changes for 6 reasons. First, Colorado's geothermal industry is in its infancy. In the near term, geothermal operations will be pilot projects, proofs of concept, and test wells. The Commission must right-size its rules to current operating conditions to allow operators to gain a toehold. The requirements sought by ALG and others were adopted for oil and gas operations under vastly different circumstances than we may ever see in geothermal operations. At this formative stage of the industry, permitting requirements that are grossly disproportionate to current operations will stifle development and capital investment. Second, imposing the requirements that ALG and others seek would stretch the permitting timeline well past expediting. We must begin by acknowledging that the current oil and gas development plan permitting process does not exactly hum along. On average, it takes ECMC staff more than 7 months to reach a director's determination on an OGDP application. A commission hearing automatically adds 2 more months due to notice requirements, even if that matter is ultimately placed on the consent agenda. Administrative approval of deep geothermal operating permits is a certain way for the Commission to advance an expedited permitting process. Geothermal Rising supports the creative solution in the draft rules for a conditional approval by the director, and the Commission can call that up if it deems appropriate. Additionally, as Commissioner Oath asked and the staff clarified, the director has discretion to require a commission hearing on a given matter if circumstances warrant. Third, the ALG group mistakenly assumes that geothermal operations will have the same environmental impacts as hydrocarbon development and will occur on the same scale. ECMC's Geothermal in Colorado report repeatedly explains that geothermal development has fewer and smaller adverse environmental and public health impacts than hydrocarbon development, even when drilling and fracking are occurring. We cited many relevant passages from our response statement. Here are 2. Quote, the total impacts from geothermal power and heat are remarkably low in comparison with both fossil fuels and other renewable sources. Page 154 of chapter 7. Quote, major differences exist between geothermal and petroleum wells, even in the pre-production phase. Again, chapter 7, page 158. In addition to fewer impacts, geothermal operations will occur at a much smaller scale than hydrocarbon development in Colorado for many years to come. There is no imminent geothermal shale boom. The Commission must regulate geothermal operations as they are today, not based on an imagined worst-case scenario that may never arise. Fourth, this is the first deep geothermal rulemaking, not the last. Geothermal Rising joins with 350 Colorado and other parties in the belief that the deep geothermal rules will need to evolve as the industry matures and technologies change. Serendipitously, as has been discussed earlier, ECMC and the state engineer are evaluating the state regulatory structure for geothermal resources and whether any changes to state law or rules are necessary. They must file a report with the legislature by the end of this year. That study and further observation of geothermal development in Colorado will inform future rulemakings. The additional requirements sought by ALG and others are unnecessary now and can be re-examined in those future rulemakings. Fifth, local government's land use authority gives them significant control over geothermal energy projects in their jurisdiction. Again, this was covered to some extent by this morning's comments. ALG, Larimer County, and other local governments could require something equivalent to an alternative location analysis for geothermal development if they wanted to. They could also require certain setback distances and mandate something akin to a cumulative impact analysis. Because local governments have that authority, Geothermal Rising sees no need for ECMC to impose such regulations statewide. Many of the most promising geothermal development targets are in rural areas like the Piceance and the Raton basins. Local governments in those jurisdictions may not welcome the same restrictions on geothermal development that the ALG and Larimer County want. The Commission should give the industry room to grow and allow those jurisdictions in which geothermal development takes root to develop land use requirements best suited to their community's needs. Sixth, the draft rules, as presented, will protect people, the environment, and wildlife, just as they are. This was also covered this morning. I will try to speed this up a little bit, but I can't emphasize that the geothermal rules bring in virtually all of the requirements of a Form 2, virtually all the requirements of a Form 2A, all relevant portions of the general drilling rules, including integrity testing, Braden head monitoring, and wellbore integrity and mechanical testing. They bring in the 600 series rules, including blowout prevention, secondary containment rules, groundwater baseline sampling and monitoring requirements. They bring in the 900 series rules, environmental impact prevention rules. This includes the 902 prevent pollution rule. It includes strict limitations on venting and flaring of natural gas. It includes rules to prevent, report, and remediate spills. The geothermal rules include wildlife protections and reclamation rules. As Director Tour noted, the rules strike the right balance between protecting health, safety, welfare, the environment, and wildlife, and encouraging the maximal production of the resource as the legislature wanted. Bringing geothermal energy development to Colorado will be a win for all Coloradans. It will reduce our greenhouse gas emissions, increase our renewable energy portfolio, help local economies, and provide good jobs for a ready-made, skilled workforce. We ask the Commission to adopt the revised draft rules with only minor revisions. Doing so will give the geothermal industry room to breathe and to grow. To preserve Colorado's ability to attract geothermal developers, investors, and jobs, we ask the Commission to reject ALG and Larimer County's proposals for burdensome and unnecessary rules that will create barriers to entry and place Colorado at a competitive disadvantage for developing its geothermal resources. With that, Mr. Chairman, I would like to call our first witness, Dr. Bryant Jones, Executive Director of Geothermal Rising.
Go ahead, Mr. Jones.
May we proceed?
Yes.
Thank you, Mr. Chairman. Good morning, Dr. Jones. Will you please state your name and occupation for the Commission?
Yes, good morning. It's great to be here. My name is Bryant Jones. I'm the Executive Director of Geothermal Rising.
Could you briefly describe your work history at Geothermal Rising and your responsibilities as Executive Director?
Yes, I am Geothermal Rising's Executive Director since 2023. So as the Executive Director, I oversee all aspects of GR's mission and implementing that mission. And I oversee the day-to-day operations of Geothermal Rising, which has a staff of 16 people spread out across 10 different states in the US.
Thank you. And give the commission an overview of your educational and professional background, if you would, please.
Yeah, certainly. So I have about 20 years of experience in working on public policy at the federal, state, and local levels. Prior to coming to Geothermal Rising, I was a PhD candidate and a researcher in energy transition studies at Boise State University in Boise, Idaho, which coincidentally has a deep geothermal heating district. From 2007 to 2016, I was a policy advisor and for climate change and for public diplomacy at the White House Office of Management and Budget. And I've also worked at the U.S. Department of State, and I'm still currently a fellow at the Truman Center for National Policy. I have a bachelor's of science in biology from the University of Vermont and a master's of public administration from George Washington University, and my PhD again is from Boise State University.
Thank you, Dr. Bryant. Would you describe generally Geothermal Rising's mission, membership, and areas of focus?
Yes, absolutely. So simply put, Geothermal Rising is the professional and trade association for the geothermal industry in the United States. We are a 501c3, which makes us unique in that we operate at the nexus of industry, government, and academia. Geothermal Rising has three main objectives that we try to accomplish on a daily basis. The first is that we empower the geothermal community. That's the people that make up the geothermal community. This is a unique and strong and close-knit community. And so Geothermal Rising puts on activities and events to help share knowledge about geothermal technologies and applications across the entire geothermal ecosystem, everything from geothermal heat pumps through direct use applications of geothermal, all the way to the very many different types of power production of geothermal resources. Second, we conduct our own research around geothermal technologies and applications, and also promote academic, industry, and government research, including national lab research. And the third thing we do at Geothermal Rising is try to familiarize external audiences with what geothermal is and what it's not. There's a lot of myths and misconceptions about geothermal energy, and so Geothermal Rising tries to address those, whether that's textbook publishers or students, teachers, policymakers, the media, investors, or the general public.
Thank you. Would you summarize for the commission the main points of your testimony today?
Yeah, so first, I just want to say that Geothermal Rising supports the rules as drafted, and that we believe that any additions to the current rules as drafted will have a negative effect on promoting and accelerating the geothermal industry in Colorado. We believe that bringing geothermal development to Colorado will be a win for the environment, for Colorado's energy portfolio, and for a clean and just energy transition for all Coloradans. Geothermal energy provides efficient, carbon-free baseload energy, and geothermal has a very high capacity factor, as you may know. It has the highest capacity factor of all energy sources other than nuclear. We believe that the draft rules as drafted will signal to the geothermal industry that Colorado is open for business, and it'll attract investors, private investment, attract geothermal operators, it'll create new jobs, and it'll provide Colorado with a really important carbon-free energy that not only helps decarbonize the electrical grid, but also the built environment. And one of the other benefits of geothermal is that it does have the lowest environmental side effects of all renewable energy technologies.
Thank you. Let's keep it in Colorado.
Yes.
Are there specific changes to the revised draft rules that Geothermal Rising is advocating for?
Yes, we have two concerns. One is with Rule 1321, and the other one is with Rule 1307. So starting with 1321, we just believe that this rule is too vague right now. And we believe that right at this point, special deep geothermal zones it's too premature to have these types of zones. That we need to give operators a chance to understand the subsurface of Colorado's geology, to discover where resources are in order before we set up such special zones. Also, these special zones don't account for new technologies that are being developed within the geothermal space, specifically closed loop geothermal systems or enhanced geothermal systems, which are new types of geothermal technologies that are allowing geothermal to be accessible in larger places and have a larger geographic footprint than the traditional geothermal resources. The other one is Rule 1307. We believe that the 3 years is just too short right now. Geothermal operators have to go through a lot of different reviews, resource analysis. They have to set up electrical grid analyses. They have to have PPAs before production. They have to do exploration for drilling. They have to confirm the resource, do temperature gradient drilling. All of that has to be done, and 3 years is just not enough time for all of those activities to happen. So we recommend a 5-year permit window so all of those different steps can be achieved, and the geothermal operator can then start drilling within those 5 years.
Thank you. You referenced a PPA. Is that a power purchase agreement?
Oh, my apologies. Yes, a power purchase agreement with a public utility. A geothermal developer needs to have a PPA in place in order to attract private investment.
In your experience, would the operator need the permit from the state to get that PPA?
Yes, they do need the permit to show the investor that they have the ability to then explore for geothermal.
Thank you. Tell the commission, if you would, some of the benefits of geothermal energy from your perspective.
Yeah. Well, one of the benefits is that it's an invisible energy resource. It has, as I mentioned earlier, the smallest environmental footprint of all energy technologies. And it also has the lowest life cycle carbon footprint of all renewable energy technologies. So wind and solar included in that. It is an abundant resource. It is everywhere. It's just using the naturally produced heat of the earth, as you all know, and it is a 24/7 clean technology. It also provides heating and cooling for homes, which reduces urban heat islands, which is increasingly becoming an issue. And I can go into that public health benefit as well. One of the things that geothermal offers us as a benefit is that a 9 megawatt geothermal power plant on average, can generate electricity for about 5,500 homes, whereas a 9 megawatt solar power plant would only be able to provide power for about 1,800 homes. So what that translates into is a lower environmental impact from geothermal, less critical minerals needed, which reduces geopolitical conflict as well. And that actually makes solar more expensive and wind more expensive. And those facts are not calculated into levelized costs of energy. Geothermal also creates important and high-paying jobs. It's an off-ramp for oil and gas workers to move into the clean energy economy, and it utilizes those existing skill sets of oil and gas workers, so you don't need to retrain them. Geothermal creates about 34 jobs per installed megawatt, whereas wind power creates about 19 jobs per installed megawatt and 12 for solar. Additionally, companies and geothermal rising takes the environment really to heart. Maintaining a balanced environment is the ROI of a geothermal developer. If the geothermal subsurface ecosystem becomes unbalanced, that undermines the geothermal developer's own ROI. So this is very different than all other energy generation technologies, including solar, wind, oil, and gas. Geothermal is the only technology that requires that symbiosis with the environment.
Thank you very much for that. Sorry.
Those are just a few.
What is Geothermal Rising's approach to regulatory policy for geothermal energy, especially at the state level?
Yeah, we, like Executive Director Will Tour was mentioning, we advocate for a balanced approach that upholds environmental standards while also enabling streamlined development for geothermal energy. So we want the values of Colorado to be at the forefront, but also allow Colorado to be a leader in the geothermal industry in the United States.
Thank you. Are you familiar with Governor Polis's the Heat Beneath Our Feet initiative?
Yes, I'm very familiar with it. GR participated in many interviews and focus groups that were conducted for the report, and we hosted some events at some Heat Beneath Our Feet events with the Western Governors Association. GR is also involved with NREL, and we help them with their geothermal marketing report every year.
Governor Polis has said the following: jump-starting the adoption of geothermal energy technologies can create new opportunities to boost local economies, provide low-cost, reliable power, heating, and cooling to communities, and assist in meeting our renewable energy and energy security goals. What is your view of both the opportunity for and the current state of geothermal development in Colorado?
Yeah, so first of all, the potential for geothermal development in Colorado is tremendous. But we also need to recognize that the industry is at its infancy in Colorado. And so there are also other competing Western states that are attracting geothermal developers and that are developing rules around geothermal right now, and that are creating that regulatory certainty that is going to attract developers to those states as well. So we want to be mindful of that, as well as recognizing that Colorado does have a tremendous potential for geothermal development.
And how would you describe kind of where we are in Colorado now with geothermal?
It's in its infancy. It's early stage deep geothermal development right now. There are a handful of pilot projects and research being conducted. There's no production on the horizon at the moment. But we do have companies like Gradient Geothermal and Occidental Petroleum that are looking at Colorado, and there are other geothermal developers as well that are looking at Colorado. We also know that some geothermal developers have moved to other states, including Nevada, Texas, and Utah, because permitting there can take less than 4 weeks to get a permit on state or private lands.
Thank you. Are geothermal operators, and maybe you just partially answered this, are geothermal operators selective in where they invest for new geothermal development?
Yes, they are selective. It does take a long time, as I was just mentioning a little bit earlier, to go through all of the different steps that it takes to develop a geothermal production well. And so because of the private sector investment that's needed, geothermal developers are selective. And right now they're looking at states like Utah and Nevada, and partially also because of the proximity to California, and that the state of California has mandated 2,000 megawatts of clean, firm electricity be added to the grid by 2028 in order to balance the intermittent solar and wind that is on the grid in California, and that can only be achieved with geothermal. So that's part of the draw for those states as well.
Can you say for the commission what you see as some of the key hurdles to jump-starting geothermal energy in Colorado?
Having a streamlined permitting process, having certainty around a permitting process, and reducing any duplicity in the permitting process, and making sure that a permitting process is not lengthy are going to be reducing those hurdles will help the geothermal industry grow in the state of Colorado.
Thank you. Have you had the opportunity to read the commission's July 23rd revised draft rules?
I have, yes.
And from your perspective, do the draft rules meet geothermal rising's goal of being a balanced approach that upholds environmental standards while enabling streamlined development of geothermal energy?
Yes. at Geothermal Rising, we believe they do, that the draft rules are very comprehensive, that they contain strong public health and safety protections that address things such as noise, odor, lights, that they have the proper environmental and wildlife protections, and well construction requirements as well. So we feel that the draft rules as written are provide the regulatory certainty for geothermal operators to seriously consider developing geothermal projects in Colorado.
Several other parties are advocating for adding rules that are taken from ECMC's oil and gas rules. They want to incorporate those into the deep geothermal rules, including things like cumulative impact analysis, a 2,000-foot setback from certain structures, an alternative location analysis, and a commission hearing for every permit. How do you think industry and investors would respond to those rules?
I don't believe those rules are necessary at this phase of the industry's development in Colorado. It's going to take many years for production wells to actually start producing electricity or providing heating and cooling in Colorado. So I believe that the rules as currently drafted are a good balance. And if we add more rules, we're going to deter operators from choosing and investing in Colorado. I think the draft rules are comprehensive and protective. And one thing that's as has been mentioned by several people so far is that the commission can engage in future rulemaking as the geothermal industry matures in Colorado. And I think that's where special geothermal zones could come into play. And if in the future is once geothermal developers have a better understanding of the resources available in Colorado, that future rulemaking will be able to be conducted. So I see this as an iterative effort. Geothermal development is not going to be the next shale boom. It's still in its infancy. And as we've mentioned already, there's the environmental impacts are smaller than all other renewable energy technologies. And so that's, yeah, I'll stop there.
Hold on just a sec. Let's stop the time clock. Mr. Thomas, I believe Mr. Lepore had asked for 25 minutes for rebuttal. Can you give us a time check? My clock has him getting close.
He reserved 25 minutes of his 78 minutes. So my calculation, he has had 53 minutes for this presentation and he's used 30 minutes, 30 seconds so far. So about 23 minutes left for presentation of unreserved time.
And then that'll still have the reserved 25. Great. Okay, just checking. Go ahead.
Thank you, Mr. Chair. Now I have to find my place. Dr. Jones, some stakeholders have said in their pre-hearing statements that geothermal energy is an unknown technology. Do you believe that's an accurate characterization?
No, I don't believe it is. The geothermal industry has a rich and long history. Boise, Idaho, where I got my PhD, has been using geothermal direct use resources since 1892. That was long before Iceland. In fact, Iceland modeled, the capital region of Reykjavik modeled its direct use system after the Boise system. We've been producing electricity from geothermal resources since 1904 in Italy and since 1954 in Northern California. That same infrastructure is being used today. Those same wells in Boise, Tuscany, and in Northern California are all still being used today. And so it's a mature industry. It is a very small and nascent industry, partly because hot water is not a commodity that you can put in a barrel and transport as easily. And so that's part of and it's an invisible technology. You don't see it when you're driving down the street. So it has a long and rich history. It also has a really powerful community that prides itself in things like inclusiveness and diversity. I mean, many of the startups in Colorado are founded by women. Another fun fact is that all of the 8 geothermal developers in Canada are founded by women. So there's a lot that differentiates the geothermal community from the oil and gas community. And yes, we recognize in the geothermal industry that we use a lot of the same knowledge and workforce and technologies from the oil and gas community, but we are very different.
Thank you. What is your sense of the likely pace of geothermal development in Colorado over the next several years, assuming the commission adopts the rules essentially as they are drafted?
Over the next several years, for 3 to 5 years, we're going to see exploration activities in Colorado, not production of geothermal and electricity on the grid. It's going to be conducting temperature gradient drilling, monitoring, exploration drilling. That's the kind of activities we'll see. It's not, again, as I said, it's not going to be this huge uptick like the shale revolution was in the early 2000s.
Do you have an idea of whether other states are paying attention to this rulemaking?
Yes, there are many other states, including Alaska, Washington State, and Idaho that are watching what Colorado is doing. And so what is happening here is going to be incorporated into other states' processes.
Thank you. Is there anything else you would like the commission to know about geothermal rising's position on the proposed draft rules?
I will just say that geothermal, as you all know, offers a clean, renewable, firm power, and it also provides heating and cooling benefits. That cascade of benefits is something that no other energy technology can offer us. And speaking of heating and cooling, one topic that Geothermal Rising would like the commission and DWR to consider is incorporating thermal energy networks and the oversight of direct use geothermal resources in future rulemaking. These geothermal applications have tremendous benefits to decarbonizing the built environment and reducing demand on a grid that is already fragile and at capacity. And one of the things Geothermal Rising would like to mention is that having a single agency providing oversight over the entire geothermal ecosystem helps to reduce operator confusion and creates more certainty for geothermal developers and operators. So at Geothermal Rising, we're hopeful that this process here that we're going through right today will provide Colorado with geothermal energy development that will boost what Governor Polis is looking for in his comments and his heat beneath our feet report. So thank you very much.
Thank you, Dr. Jones. That concludes Dr. Jones' testimony, commissioners, and he's available for questions. I don't know if you want us to proceed to the next witness or take questions now.
Why don't we go ahead and proceed to the next witness, and then we'll make both witnesses available for questions in one fell swoop.
Thank you. I'm going to pause my timer. I was very close to Mr. Thomas and timing, and I forgot to turn it back on, but. Thank you, commissioners. Our next witness is Miss Joanna Ostrom. Good morning, still morning, Ms. Ostrom. Thank you for being here. Would you please state your name and your occupation for the commissioners?
Hi, my name is Joanna Ostrom. I'm the Chief Operating Officer at Gradient Geothermal, a geothermal technology and development company headquartered in Denver. I also sit on Geothermal Rising's Policy Committee and the Diversity, Equity, and Inclusion Committee.
How long have you been employed at Gradient Geothermal?
I've been working at Gradient Geothermal and its subsidiary Transitional Energy since March of 2020.
And could you outline your educational and professional background for the commission?
I hold a Bachelor's of Science in Geological Engineering from Montana Tech, and I have 15 years of experience in engineering policy and management positions in the oil and gas industry and with an environmental nonprofit, the Clean Air Task Force, prior to starting in geothermal energy with Gradient.
Thank you. Please tell the commissioners a little bit about geothermal. Sorry, I knew I'd do this. Gradient Geothermal's business model.
Gradient Geothermal and its subsidiary Transitional Energy were founded with the idea of capturing heat waste from oil and gas wells. Geothermal energy is produced every day in this state from oil and gas wells, but the heat is simply radiating into the atmosphere right now. At Gradient, we have developed a small modular system that can capture the heat directly from oil and gas wells and associated facilities and use that heat to generate electricity. Our process does not require us to drill new wells. Instead, we capture and utilize geothermal heat that oil and gas wells are already producing or zones that the wells are already drilled to. As you look at the future of geothermal development in Colorado, please keep in mind that it's ex-oil and gas professionals like me that will be seeking jobs in this industry and striving to stay in Colorado as we look towards a decarbonized energy future. We are passionate about reducing emissions from oil and gas sites and the electrical grid at large.
Thank you. Would you now tell us about the equipment you use, the footprint of your operations, and any siting constraints that you might have?
Our system is portable and can be moved from site to site, capturing heat from wells when they have the necessary temperature and flow rates. Our system is roughly 7 feet wide, 7 feet tall, and 50 feet long. We set it on existing oil and gas locations with no additional land or surface impacts. Our system is emissions-free and it's entirely closed loop. In overly simplistic terms, our system works like an air conditioner running in reverse. Frequently, we replace gas and fluid chillers or coolers that operators use to cool fluids prior to entering a plastic or poly pipeline. Heat is commonly viewed as a nuisance or a safety risk by oil and gas operators, and we provide a system that captures and utilizes the heat waste to generate emissions-free electricity. Since our system is modular and utilizes the waste heat to generate emissions-free electricity, we frequently replace existing equipment like diesel or natural gas generators on site. If there are 2,000-foot setbacks from existing residential units and well pads that we might set our equipment on, that would significantly reduce or eliminate our ability to capture heat from existing wells, preventing us from providing electricity and or direct use benefits to communities or buildings nearby.
Thank you. Exhibit 1 to your pre-filed testimony has some photographs of your equipment on an oil and gas location. If I can share my screen, I will ask you to describe the equipment that is on those. And let's see if I can accomplish the sharing function. Okay, is that visible to the commission?
Yes, it is.
Thank you. And Ms. Ostrom, you can see it as well. That will help.
I can, yes.
Terrific. Can you tell us what we are looking at, please?
Yeah, so this is an image taken from our pilot project located at an oil and gas site in Blackburn, Nevada. It's about a 45-minute drive from Carlin, Nevada. This is an existing oil field. It's been around for many decades, and they produce a lot of hot water with a skim of oil, say 2%, 1 to 2% oil. The operator approached us and asked us if we could do anything with this heat to generate electricity, as their largest electrical use is pumps to move a lot of hot water around. So we tested our Generation 1 system, and this is an image of that set at the central facility. So there are wells that all flow into a central location. The tank behind, you'll see in the upper right, is holding water. If you were to touch that tank, it would be very hot to your hands. You couldn't hold it there for more than a second. So that we are taking heat from the produced fluid into our system, and it goes through this blue and red heat exchanger you'll see. And that is where we transfer the heat from the produced water that coming directly from the oil wells, mostly water wells, into our system, where we transfer that heat to a clean, fresh water system that we then use to turn a refrigerant into vapor that spins a turbine, a lot like that air conditioner in reverse example. So this whole system I mentioned is about 50 feet long, and all it does is transfer heat so that we can turn thermal energy into mechanical energy that then turns into electrical energy that we use to power equipment on the site, so they don't have to buy electricity from the grid. We are also, the car that you'll see, we are also, our Gen 1, we had ChargePoint electric car charger. And so that's a Ford Mach-E that we drove from Salt Lake City over here, because you can't really rent those in Elko. By the way, if you ever fly in Elko, hard to get an electric vehicle. We rented it in Salt Lake City, and we charged it off of the power that we generated here.
Terrific. Thank you. I'm sorry, I'm laughing about Elko. I can't help it. You mentioned the produced fluids transfer the heat to a different fluid. Do those two fluids come in contact with each other during that process?
They do not. Our system is entirely closed loop, as I mentioned. So all that's being transferred is heat. There's no fluid that moves or touches the produced water. So it's all closed loop and no emissions because we are boiling a refrigerant that has a lower boiling point than water. And as that refrigerant turns into a vapor, it spins a turbine, and that's what generates electricity. And then you cool it down with the fans on the back of the system back into a liquid. So all closed loop.
Thank you. And I know you said this was in Nevada, where you cannot rent a Mach-E. And I observed that there is not a berm, a secondary, what I think of as secondary containment at this site. To your knowledge, if this was in Colorado, would there be a secondary containment berm around this?
Absolutely. Yeah, this is located in Nevada, actually at a BLM location. I believe one of the upcoming pictures is from our latest installation in North Dakota, where we are inside the berm.
Brilliant segue.
Yeah, so this is a picture of that same unit. So we completed our pilot project, ran about a year and a half, and now we moved it into commercial operations with an operator located in North Dakota, partially funded by a grant from the North Dakota Industrial Commission. So we set our system here, and our primary purpose here is to cool produced fluid so it can meet pipeline spec. The temperature coming out of the wells is about 200 degrees Fahrenheit, and they have to cool it to 120 degrees Fahrenheit so it doesn't melt the pipeline, which is also a common issue in Colorado. So you'll see a lot of industrial fluid chillers in Colorado as well. So we are replacing their fluid chiller and generating electricity for this client.
Thank you. One more, I think.
And this is just a side view. If you'll scroll down a tiny bit, but anyway, also a nice image of the clouds out there. But I just wanted to illustrate where we are on the pad right next to the produced water, pretty close to their VOC capturing system. But just wanted to show that we really fit within the existing footprint and replace existing equipment on site.
Great. Thank you very much. Stop sharing. Thank you again, and having seen some of your equipment, what impacts to public health, safety, welfare, the environment, and wildlife do you anticipate your operations will create?
Because our process uses waste heat that's already being brought to surface from oil and gas operations, fluid production, we believe the potential for adverse impacts is very small. In fact, the operator we're working with in North Dakota has had issues where the fluid has burned some of their operators. So in some basins, we are actually a benefit and can reduce fluid temperatures so they're not harmful. As I mentioned, ours is a closed loop system with no air emissions, and our system uses no additional water because we are simply mining heat from the produced fluids, which continues through the process after we utilize the heat. Our system is entirely closed loop, so there are no greenhouse gas emissions. The only moving parts of our sled are a series of pumps and a twin screw expander. With the pumps, there is some noise created from the system, but nothing louder than existing equipment on most oil and gas sites.
And does Gradient have a means to avoid or minimize its foreseeable adverse impacts?
As I see it, the only potential impact from our equipment is noise from our electric pumps. While this noise is similar in decibel to operations on oil and gas sites, we would make sure to be compliant with existing noise regulations and provide appropriate mitigation measures.
Thank you. Would you describe Gradient Geothermal as being in the startup phase?
Gradient is a young company. Transitional Energy was founded in March of 2020 and merged with Gradient Geothermal in October of 2023. Transitional Energy won several grants from the Colorado Office of Economic Development and International Trade, as well as the U.S. Department of Energy to execute studies and pilot projects. In May of 2022, we started generating electricity from our Gen 1 HXC geothermal system at an oil field located in Blackburn, Nevada. I just showed you some images from there. We recently were announced as one of the winners of the Colorado Geothermal Energy Grant Program for a thermal energy network study of Pierce Field in Pierce, Colorado. I appreciate Brian's comments on thinking about what that might look like regulatorily. Pierce is a small town located in northeastern Weld County. This study will determine if oil wells in and around the town of Pierce could be used to generate geothermal electricity and provide heat to the town. This heat would be used to keep sidewalks or roads free of ice and snow in the winter, or be used to lower utility bills and greenhouse gas emissions of the local elementary school and other industrial users within the town. Heat is a resource that has been ignored, and our mission is to find it, utilize it, and reduce emissions from the grid and the built environment.
Thank you for that. As a young company, is Gradient in favor of ECMC adopting rules that would provide regulatory certainty and efficiency?
Yes, regulatory certainty is very important because without a clear pathway to receiving permits, there'll be no interest in investing capital into Colorado projects. Without question, it is important for the rules to be protective of public health, safety, welfare, and the environment and wildlife, and also be efficient so that a permit can be obtained within weeks or months at the most. New companies don't have deep pockets, and they need to spend capital on actually developing the resources, not just getting through the paperwork.
You had the opportunity to read the July 23rd, 2024 revised draft rules.
Yes, I've read them.
Do you believe in their current form, those rules would provide regulatory certainty?
Yes.
What kind of grade would you give them on the efficiency scale?
I think, well, and Bryant might have touched on this during his testimony as well. There are other states around that have a history of geothermal development, and getting permits through those states takes 30 to 60 days. And so I think for Colorado to be competitive for development, those kind of benchmarks need to be thought about.
Thank you. And if this strikes you as redundant, you can tell me that and we'll move on. But what is your perspective? Bryant sort of gave his on the current state of deep geothermal energy development in Colorado.
In my role within the industry and at Geothermal Rising, I frequently attend events and speak with colleagues within the industry about technology advancements and new developments. And as a longtime resident of Colorado, I'm excited to see interest in the industry developing in Colorado. In general, I'm supportive of what the ECMC is doing and hope that we'll soon see the first geothermal electrons flowing onto the grid. Hopefully, Gradient Geothermal is a part of that. Presently, there are only a few proposed pilot projects and very early phase research and development projects. While I'm optimistic, I want very much for geothermal energy to take hold in Colorado, I do not think we will see much geothermal development happening here in the immediate future. Nearly all the new drilling, power purchase agreements, and exploration happening is occurring in Utah and Nevada. Those sites are being developed with the intention of selling electricity into California. Electricity is the commodity that geothermal sells, and some of the highest electricity prices are seen in California. Utah and Nevada also have hot geothermal reservoirs that have been drilled, and their reservoir capability has been de-risked.
Thank you. What do you mean by de-risked?
Drilling wells in an unexplored, previously undrilled basin carries geologic and reservoir capability risk, and which can ultimately affect the economics of the project. 3D seismic and mapping can tell you some things, but nothing replaces drilling a well to truly know if your models are correct. No deep geothermal productive wells have been drilled in Colorado. There will need to be some exploration drilling before certain areas of Colorado can be de-risked.
Thank you. So you kind of talked a little bit about California has higher electricity prices, and therefore operators are choosing Utah and Nevada, perhaps at Colorado's expense. What are some ways that Colorado could offset those competitive disadvantages?
Colorado has made some great strides to attract geothermal development despite the pricing disadvantages and geologic and reservoir uncertainty. Legislative work via 23-285 has led to the creation of the ECMC, or should I say rebranding, and the opportunity for regulatory certainty and expedited permit approval, as well as requiring a geothermal resources study. Through a series of legislative actions, including SB 22-118, encourage geothermal use, and House Bill 23-1272, tax policy that advances decarbonization. These legislative actions have allowed the Colorado Energy Office to set up tax incentives and grant programs to encourage interest and development in Colorado. So I think a lot of good things are happening, but until some wells are drilled, you're not going to see very much action happening in Colorado.
Thank you. Last question, which I also asked Dr. Jones. Would you describe geothermal operations as an unknown technology? Why or why not?
Geothermal operations cannot be described as a, quote, unknown technology because geothermal energy has been harnessed for centuries. Geothermal power plants have been in operation since the early 20th century. Brian talked about Boise, Idaho. I grew up in Idaho, so I've always been a big fan of that system in place there that have led to a lot of the advancements you see in Iceland. And the first commercial power plant was established in Larderello, Italy in 1913. The United States is the largest producer by megawatt of geothermal energy in the world. There are numerous operational geothermal power plants and direct use projects worldwide. These projects provide tangible evidence of the technology's viability and reliability as a clean energy source. While geothermal energy may not be as widely utilized or visible as other renewable energy sources like wind or solar, it is far from an unknown technology. Its proven track record and ongoing advancements make it a well-established and promising component of the global energy landscape.
Thank you very much. That concludes Ms. Ostrom's direct testimony, commissioners, and I believe it's your turn for questions.
All right. I've got a few highlights that I wanted to go back to real quick, and then we'll open it up to the rest of the panel. Mr. Jones, you testified as to 1321, it's unduly vague, could be misused. Do you suggest at this point that 1321 just be deleted?
Yes, but revisit it in the future is something we would be okay, we would support. But right now, we think we should just not have it. Yes.
Okay, fair enough. And then you support, you suggest the duration of 3 years be extended to 5. Can you provide some testimony around the duration of permits from other states? And can you also testify as to whether 5 is like, that's the right balance in terms of being able to do all the things that you need to do?
Yes. So we do believe 5 is a good balance. And again, because this rulemaking is iterative, that if that is too short or could be too short of a time or turns out to be longer than needed, we could always revisit that at a future rulemaking hearing. But we think that 5 years is a good balance because of the time that it takes to get, as I mentioned, a purchasing power agreement, a grid agreement. Sometimes a grid agreement can sometimes take multiple years. A PPA can sometimes take up to 18 months. Yes, Commissioner.
What are those things? A grid agreement? What is that? What is PPA? Sorry.
So yeah, a grid agreement would be the agreement that the developer has with the transmission company. Sometimes that might be a utility, but sometimes it might be a different company in order to get their electricity onto that transmission line to send it to the customer. And that might be separate from a purchasing power agreement or a PPA, where the geothermal developer needs to have a PPA with an actual utility. So Excel Energy, for example, who says we will buy your electricity at X dollars per megawatt hour and sell it to our customers. And those take time, and you need those agreements to convince the private investor that you as a geothermal developer have the right agreements in place to get your product, electricity, to the end user, the consumer. And that all takes many years. Some testimony around length of time. So in Utah and Nevada, geothermal developers are able to get permits on state and private lands. I'm told by members of Geothermal Rising around 4 weeks maybe 2 months, but 4 weeks is not is common. Same in Texas. And that is again, that's state or private lands, not federal lands. That's a whole different conversation. And so those are what geothermal developers are experiencing in Texas, Utah, Nevada, which are currently the states where we're seeing the most geothermal activity at the moment.
Do either you or Ms. Ostrom have an opinion as to if the rules get adopted as is, perhaps with the 2 changes that you suggest, what's your anticipated time frame to process a permit under these rules, if you know?
My understanding is that it could be about up to 6 months under the current ECMC draft rules.
Okay, and that's obviously a whole lot longer than 30 to 60 days. Does that create concerns from a competitive perspective as to whether folks would come to Colorado?
It does. Yes.
Okay, you're just being gracious about not putting that in your direct. I think Mr. Lepore had pointed out that in his summary that, well, you said something along the lines of, Mr. Lepore, like your client would be willing to accept, but that this still is, what I'm hearing is it's still a pretty conservative, protective approach that's going to take some time.
I think that's a fair characterization. Sorry. Chairman. Are you finished? I'll respond.
I'm finished, and I don't know if I put a question mark at the end of that comment, but you're more than happy to answer.
I was just going to say, I think your characterization was fair. My client has endorsed the rules as they're proposed with the understanding it's going to take longer than it does in Nevada and Utah and Texas right now. That is what I referred to as the Colorado way. We get that. But, if it's 6 or 7 months now, that's one thing. If it's a year, that's a different thing, in my opinion. And a piece of that, for example, is whether or not there's a commission hearing or not, as I tried to articulate in my opening, that there's no way around adding 60 days unless you change the notice requirements. So that's one example.
But the approach that's drafted, which is an administrative approval with a potential call up, is digestible at this point for this first iteration of geothermal rules.
Yeah, I think it was a very creative solution. I like the approach. There's a lot of discretion granted to the director now. I appreciated Commissioner Oath's question about that earlier. In a different context with a different hat on, I'm not a huge fan of wide discretion, but I think it's appropriate here for some of the reasons that the staff articulated. So I thought it was a good solution.
Okay, thank you. I don't want to monopolize. Other commissioners with questions for the panel? Commissioner Messner.
Thank you, Mr. Chair. Appreciate the information and the testimony. I want to ask just a little bit. So understanding that, my job, and I take my job very seriously, is derived from statute. Statute in this particular indication requires me to ensure that whatever regulatory process we come up with here is protective of public health, safety, welfare of the environment, and wildlife resources. I've had an opportunity over the last year to learn a lot about deep geothermal development, including, visiting sites and hearing lots of talks about it, as well as engaging in a seminar put on by top core at the Colorado School of Mines about regulatory considerations around deep geothermal. So I wonder if you could talk a little bit about some issues that have occurred around deep geothermal operations that need to be considered as we develop regulatory structures to ensure that it is protected. Any incidents that have occurred in the development of deep geothermal over the last 30 years, in the United States, and how you think these regulations have addressed those kind of known instances that have occurred over the last 30 years. And this is probably most appropriately directed to you, Mr. Jones, since the organization that you represent has been involved with this since its inception.
Thank you, Commissioner, for that question. And if there's any specific examples of that you're referring to, you could let me know if I'm familiar with them. But this concerns around, so for example, in Boise, Idaho, it was about a year ago, they had a geothermal pipe break in downtown, and it was actually happened on New Year's Eve night, New Year's Eve. And the issue that they had was hot water on their roads in their downtown, and it basically sort of created a hot springs right there in the downtown, and there were people out celebrating for New Year's Eve. And people in it, the temperatures were not hot enough that because it had been cooled down, the system had cooled the resource down. So really what you experienced was people on New Year's Eve walking around in hot water, actually dancing and splashing around in hot water in a inadvertently made downtown hot spring. In fact, the city of Boise posted pictures on their Twitter feed and other social media feeds about that hiccup, if you will. There are like every energy technology. There's no true clean energy technology or purely, innocent energy technology. All energy technologies have a downside. Geothermal needs to make sure that there's a balanced ecosystem, as I was mentioning in my testimony, in order to maintain the subsurface reservoir. There need to be precautions in place to make sure that when the drilling is occurring, that it protects the drinking water aquifers, because the geothermal aquifer or reservoir is geologically separate from any drinking water aquifers and agricultural aquifers, and you want to protect those. So that's achieved through casings during well construction. And then seismicity. Anytime that you are engaging with the subsurface, you want to monitor seismic activities, and the geothermal companies do that as they are exploring and producing. Now, one thing about seismicity, though, in a Congressional Research Service report that was released last year showed that seismicity does not occur from the exploration of drilling, and that there are no known cases of seismic activities in the United States from geothermal exploration.
Thanks for that. Let me ask you just a little bit more about seismicity, because there has been some testimony around that, and I think there's different opinions that I'm hearing as far as the amount or lesser amount of seismicity. There is seismicity that has induced seismicity that has occurred as part of deep geothermal operations, not necessarily from the drilling aspect of it, but from the injection or balancing of the reservoirs. Is that right?
Yes. Injection is where seismic activities happen, especially in the oil and gas industry.
Okay. And then you had talked about in your opening comments about how geothermal is going to aid in just transition, and I wonder if you could flesh that out for me a little bit, and how this particular this particular industry is going to aid in just transition.
Yes, so there's a couple ways to look at the just transition. One is we're seeing a lot of rural communities, including in places in Colorado, where the fossil fuel industry is either closing power plants, like in North Valmy, Nevada, or Colstrip, Montana. I believe the same is happening in Colorado. those communities are experiencing a loss of their economy. Geothermal offers those communities another opportunity for those people to stay in their communities, to instead transition maybe a coal power plant from the coal resource to a geothermal resource using the existing fossil fuel infrastructure, the surface power plants, the transmission access. So if, as we start to transition away from fossil fuels, or as we are transitioning away from fossil fuels, we can repurpose those sites in those communities, so we don't have to tell those communities that they should move to another place for employment. Maybe they've been living there for quite some time, and they, for many generations, and they'd like to stay. Geothermal offers those communities that just transition into the clean energy economy. The other thing about just is for marginalized populations, including tribes and tribal nations, where they have historically, a lot of tribal nations have resources that the larger country has been utilizing over the years. Those communities will benefit from geothermal because it doesn't produce carbon, and it doesn't require critical minerals. And you can bring the energy closer to load centers. So especially with newer technologies like closed loop geothermal systems and enhanced geothermal systems, the generation of geothermal, whether it's heating and cooling or electricity, can happen closer to a community. So you don't need transmission line to build out transmission line as much. And you also have the added benefit of that cascading benefit of geothermal, so that as Joanna mentioned, you can bring heating and cooling to a nearby school or a nearby hospital or a nearby community, reducing utility costs for that community. This is already occurring in places like in isolated communities in Iceland, and even in their, as you all probably know, in their capital region, where you're able to effectively bring the utility costs down to almost nothing, because you're providing that hot water resource to a community. So all of that is helping. All of those are examples of the just energy transition.
Great, thanks. I appreciate you fleshing that out, because I think it's a term that gets thrown out a lot, but without a lot of meat behind it. But I think that's actually a good explanation, right? And so thanks for that. So I want to go back to the different technologies, because there are a lot of different technologies in deep geothermal. Technologies like Ms. Ostrom is promoting, which are pretty small surface technologies, and then other technologies which are enhanced deep geothermal operations that include hydraulic fracturing or other technologies. Are there considerations in the development of regulatory structures that there should be one regulatory structure fits all technologies, or are there considerations for different regulatory structures depending on the technology that's being proposed?
Yeah, I think that's a good question, and it's a jurisdiction by jurisdiction question. There are going to be some communities in the United States that are very comfortable with enhanced geothermal systems, and other communities that will not want to use enhanced geothermal systems, but would prefer to use closed loop geothermal systems, or traditional hydrothermal systems. And that's one of the benefits, I think, of geothermal is that it offers so many different types of technologies for a community to choose from, that a regulatory environment could be set up around those, around each type of different technology. I will say that enhanced geothermal systems, it's very important that we do not think of them as synonymous with oil and gas hydraulic fracturing. There is a very big difference, and the ECMC report goes into those differences, and there's a chemical and a physical difference, and those are really important, because and that people understand that geothermal, when it uses hydraulic fracturing, it is completely different than oil and gas hydraulic fracturing, and those differences are really important. That's one of the myths and misconceptions that we have to try to help audiences better understand, because the minute you start using the word fracking, the minute communities get really concerned, as they should. But geothermal hydraulic fracturing is very different.
No,
And the
I
ECMC report
appreciate
goes
that.
through
I
those.
understand that. I wasn't trying to indicate that it was problematic. My question really though was, I think as you answered, should there perhaps be different considerations or different regulatory structures depending on the technology that might be employed, as some may have, each technology being employed may have different impacts associated with it. Is that
Yeah,
fair?
I think
Yeah.
that is fair. Like, for example, thermal energy networks. This commission might want to look at regulations around thermal energy networks at a later date, for example.
Thanks. Well, I had another question, but it's off in the ether now, so I'll stop and let other commissioners ask questions. Thank you.
Just following up real quick on a segue on Commissioner Messner, then I'll look to the other commissioners. You talked about sort of this different technology, one regulatory structure, versus different regulatory structure. Does geothermal rising again, this is kind of getting back to the comfort level of the proposed draft. Are you comfortable that the proposed draft is where it needs to be as this geothermal starts to initiate, pilot, develop, et cetera, in Colorado?
Yes, right now, the way the rules are drafted, it's geothermal technology agnostic, which is a good approach right now. Some of these newer technologies are still in their infancy, and so I appreciate the agnostic approach that the commission is taking right now.
Okay. Other commissioners with questions for the panel? Commissioner Cross, and then Commissioner Oath.
Thank you, Mr. Chair, and thank you for this presentation. I did find it helpful, and a lot of my questions have already been answered. And I want to touch a little bit on the timing issue again, because you did suggest the 5 years, and you called it, I believe, a good balance, Dr. Jones. And so to delve on that a little bit more, do you think the 5 years, is it appropriate to say this is when you should have drilling started? Do you think it's appropriate to say this is how long you have to finish operations? Do you have a view on that compared to what happens in other states?
I would say that the 5 years, it'd be great if that could say exploration. Within the first 5 years, giving a geothermal developer the grace to be doing the exploration. So that includes subsurface analyses, and then starting to drill for the exploring for the geothermal resource to confirm it's there.
Okay. I believe that's all for now. As I said, I think most of my prior questions were already asked.
Commissioner Oath.
Okay, thank you very much. Appreciate all of the information that you have provided. What I've got left are maybe a handful of fairly targeted questions based on some of the comments and suggestions that were provided in the written testimony by various parties. So I don't know exactly which of you is going to want to take them, so I'll feel free to kind of jump in. So the first is one of the parties, I think it was 350 Colorado, made a suggestion that operators should be required to, in addition to putting together a community outreach plan, to also create educational materials and share those materials, with the notices that are going out and at community meetings and on websites. So just curious if you all have a reaction to that, of whether that is feasible, something that is required in other states, or whether that would still, if required, if it would still be within the range of, not creating any unnecessary barriers to entry.
Joanna, do you have thoughts on that?
Sure, I can respond to that. So I do know the Colorado Energy Office was tasked with creating educational materials, and they're in the process of doing that. I think overall, in general, it's good to communicate the benefits and educate the public on what geothermal can do for the state of Colorado for air emissions, all sorts of things. So in general, I'm a proponent of educational materials, and I think that's already being worked at the state level, and that's something certainly gradient geothermal would be supportive of. But I'll let Bryant speak to any other comments from the geothermal rising's perspective.
And so I'll build on what Johanna was saying, and that because of there's so many myths and misconceptions about geothermal, it would be beneficial for a developer to be providing the community with materials about what geothermal is, what the benefits are, and what geothermal is not. Like it's not synonymous with Iceland. You can have geothermal everywhere. So that does seem helpful to help familiarize the communities where geothermal developers might be looking to explore for the resource.
Okay, thank you for that. And then on the in the written materials and the pre-hearing statements, the Colorado Oil and Gas Association had suggested that there should be a requirement for consultation with potentially impacted mineral owners. I think you all provided some responsive comments about that, or some comments about that, and so wanted to just kind of get your take on where the state of that conversation and implementability of that suggestion.
Commissioner, I think I'll take that one, if I may. So I have been in an ongoing dialogue with KOGA, and we have landed on some language that I would describe myself as being comfortable with. I'm still sort of waiting for a bright green light from Geothermal Rising on that language. I'll leave it at that. And Ms. Ryan will be up later and may want to elaborate on that a little bit, but our initial concern was the potential burden of identifying mineral owners over a large area. As you probably know, there can be thousands of mineral owners, within a, say, 640 square mile. So if you had a large surface owner, you'd be tracking down a whole lot of people. That could potentially take a title opinion from a lawyer, which is very time consuming and very expensive. So we were trying to narrow that down. And again, I think we've got some language that we could get comfortable with.
Okay, so are you saying KOGA is going to be presenting that potentially compromised language in there later on?
I'm going to leave it to them to present it and hope to have some offline conversations with my client before we wrap this rulemaking up.
Great, thank you. Okay. Then you all had some suggestions in the section 1304B3 consultation with the surface owner. You all had some suggestions about that section and some additional clarifications that could be beneficial. It looks like in the updated draft, that section is struck altogether. So I wanted to get your reaction to that.
Thank you, Commissioner. Again, for me, you are correct that the revised draft struck the language that was giving us a little bit of heartburn. I had a conversation with AAG Boudreau about, he reached out to me and asked what our concern was. And fundamentally, our concern was that the language quoted in the rule also exists in statute. The statute has some additional language that we thought was pertinent, that if Part A was going to be there, Part B should be there also. And the compromise was to take it out of the rule because it is in the statute and you don't also need it in the rule.
Okay. Thank you. One of the parties, Green Latinos, suggested that for the notice requirements, so in addition to providing notice to schools and some others, that notice should also be provided to a fairly broad group of additional facilities like hospitals, rehab centers, assisted living facilities, and others. And so just thoughts on what this would look like for again, like, trying to strike that balance between making sure that all of those impacted are aware of and part of the process without creating unnecessary requirements and rules.
I think our position would be, Commissioner, that the notice rules that would be adopted from the oil and gas side have been hammered out over a lot of hours of stakeholder meetings in different rule makings, pre-mission change, post-mission change, et cetera. I think our position is they're adequate, more than adequate, right, in a good place right now, and we're probably opposed to any expansion of those.
Okay. Thank you for that. And then the last one is there were a couple of places where some of the parties suggested additional timelines. And so again, trying to strike this balance of, you all testified earlier that in some other states, the timeline for getting a permit is 30 to 60 days. The current draft is probably looking at around 6 months or so. But then there were some suggestions to expand, for example, like the notice for to communities from 45 days to 60 days. So adding another 15 days. Just curious if you feel like that would tip the scales into you all feeling that it's, beyond what you can support as an additional, or if that would be something that you could get behind and live with.
Thank you, Commissioner. It's I don't know that I want to quibble with anybody over 15 days. On the other hand, I think the OGDP process right now, 6 months, you're being generous to yourselves. I think it's longer than that. And I don't see very many places outside of the administrative hearing that definitely is a time saver. And I just don't see a lot of other places where the commission is economizing, if you will, on how long a permit review and decision or recommendation is going to take. I don't think my client will kick me under the proverbial table. I don't think we're going to die on that hill, but I think, again, these are rules that have been negotiated over a long period of time. So I'll stop there.
Thank you. Appreciate it. That's all.
Commissioner Ackerman.
Thank you. Really just one question. I think the points that I had in mind have also been addressed, and this point admittedly has been addressed as well, but I just wanted to be very clear on the record that I took this as a salient point, and I believe this question is probably best directed at you, Mr. Lepore, but you certainly can farm it to the other two if you feel appropriate. We've heard testimony that these rules with noted exceptions are right-sized for the current state of Colorado's nascent geothermal industry. And that point is also imperative to the establishment of the geothermal industry in Colorado. And I just wanted to reiterate on the record that as the industry develops, as technologies arise, as social concerns become elevated, if they do, that geothermal rising would generally be open to future rulemakings and or other processes that would address those specific issues or concerns, even if those conditions arise in the relatively near term.
I'll hazard a guess, not a guess. I'll hazard an informed guess, and then I'll let my client speak. But to me, the answer is absolutely yes. It's always been that way, Commissioner, from my perspective. Even when ECMC was COGCC, technological changes, social changes, those are the things that drive rulemaking. I really honestly appreciated 350 Colorado's comments in this area. I thought they made some good points about clarifying definitions. Again, I think as the technology evolves, some of Commissioner Messner's questions went to this point. We don't know yet exactly which specific advanced or enhanced geothermal processes might take hold here as we get that information. As these things evolve, then 100% the rules should keep up. I think also, you know, with the report coming out at the end of the year, that may inform all of us, and I think we should respond to that. If my client disagrees, now's his time to say so.
No, I don't disagree. Commissioner Ackerman, one of the things I appreciate about our policy process at the state level and federal levels is the iterative nature of it. And I think that's important because things do change, and policies need to adopt as with whether they're social or scientific changes along the way as well. So no, iteration is important.
Thank you, Mr. Lepore and Dr. Jones. I appreciate those responses. And I certainly think that's been the history of oil and gas development in the state of Colorado. We've also learned from that history, and Colorado is protective of nature by its nature. And I certainly can understand why these concerns come up as the environmental commissioner. I also think that it's important that we continue to address them in a iterative manner, and appreciate your testimony on that point today. Thanks.
Commissioner Messner.
Thank you, Mr. Chair. Just one last question, or maybe a pushback a little bit. I think Dr. Jones, as you talk about myths and misconceptions, I think there's lots of myths and misconceptions about ECMC's permitting timeline. And, you know, understanding that the most significant part of that timeline for the permit process that we've got so far, at least for OGDPs, is the quality of application that ECMC receives from the applicant, and the need to send it back to the applicant to draft for additional information or revisions for the submissions that weren't included in the initial submission. I'm looking at the timeline of the process as far as the ECMC review of it, and I'm not seeing anything longer than 90 days for ECMC staff reviews. So maybe someone can help me figure out how you got to 6 months to a year.
I'm happy to respond, Commissioner Messner. Thank you for the question. Those numbers, those statistics come from a COGA study that was completed in the end of December 2023. It is my understanding that that data and analysis has been presented to the commission or the commissioners, or at least some subset of you. So that's where they come from. Their number was 230 days in 2023 from the time of a submittal of an application to the director's recommendation for that. I understand that sometimes things go back for revision or what have you. It's probably a rabbit hole that you don't need to go down at this particular moment, but that's where the numbers came from.
So I appreciate that. I'm familiar with that study, and just because we have geothermal industry in the room, and I think it's important that they understand the true timeline associated with at least the state's review of things. It's this commissioner's opinion, at least, that our review process, particularly even with the existing OGDP process with hearings, is about 98 to 100 days. And with this particular proposal, I think would be significantly less. And so I just want to make sure that the myth and misconception of what may our process may be from the timeline isn't just promulgated. So that's all. Thank you.
Any last questions for the panel? All right, seeing none, thank you. You've got your rebuttal time reserved. Commissioners, I believe it's probably appropriate for a short lunch break. I don't know, 40 minutes, return at 1 o'clock. That work? We will return at 1 o'clock. All right, welcome back. This is the Colorado Energy and Carbon Management Commission. It is August the 5th. It is 1 p.m. We are taking up docket 240500115. This is the deep geothermal rulemaking. At this point, I would recognize Mr. Ships on behalf of the Southern Ute Indian Tribe.
Yeah, thank you very much, Chairman Robbins and members of the commission. I'd like to also make sure, and I don't see that she is, oh yes, she is, that Lindsay Radcliffe, who's also an attorney in our firm, is present. And she, unlike Mr. Lepore, who's demonstrated the capacity to work both document sharing and talk, I'm not there. So Ms. Radcliffe is going to assist me with regard to screen sharing.
Okay.
We really appreciate the opportunity to participate in the rulemaking and be here today. And as just a very short preliminary matter, I wanted to comment and extend the regard that the Southern Ute Indian Tribe has for the relationship that's been created between the tribe and ECMC, and even in its former status as the Colorado Oil and Gas Conservation Commission. It's a model relationship in Indian country nationally, and we wouldn't have that relationship but for the commitment, I think, both from the state of Colorado as well as the tribe to engage in meaningful dialogue and communication. And I think that this presentation is also an extension of that. In terms of how I'd like to proceed, I would like to address a matter that came up earlier as a result of the comments that Mr. Boudreau made. And then I'd like to turn very briefly to the history of the Southern Ute Indian Reservation. And then most importantly, I think, is to turn to the proposed language in the regulation that we've suggested for consideration by the commission. And that may very well require us to jump back and forth with some discussion about history and relationships and other statutory language. But I think that's the most efficient way to proceed, and I think it'll be most meaningful for the commission. The initial comment that I'd like to make, and it's a clarifying comment, and it really, and I'm not sure that it necessarily requires being addressed, but I want to be very clear. And that related to the relationship of the powers of the commission to regulate geothermal resources under Senate Bill 23-285, now embodied in CRS 3790.5-101 at SEC, and the powers of the commission with regard to not just, well, oil and gas resources, but other resources under CRS 30-60-105. And as I understood the explanation this morning, and I could have misunderstood, I thought that Mr. Boudreau was suggesting that the powers of the commission as it relates to the regulation of geothermal resources is statutorily distinct and separate from the commission's other powers. And the significance of that to the tribe is based on the limitation of the commission's powers as it relates to Indian tribes and reservations that is embodied in CRS 30-60-105A1 and 2. Important to this understanding, we believe, is the effect of the intervening legislation that was passed following the Geothermal Act that is referenced in, is embodied in HB 24-1346, which made intervening changes to the powers of the commission, and specifically to include energy and carbon management operations in the definition of 30-60-103 to mean, and I quote, all operations regulated by the commission. And we interpret that to include geothermal resource activity. And that's significant for our jurisdictional purposes because there was also a corresponding statutory change in HB 24-1346 that created the exception, if you will, under 3460-1054 so that that exclusion of the powers of the commission as it relates to Indian tribes and reservation lands extends to energy or carbon management operations, as that definition was reflected in that subsequent legislation. And I address this issue only to eliminate any doubt that the statutory limitation on the powers of the ECMC in relation to Indian tribes and the reservations was also expanded following HB 24-1346 to include not just oil and gas activities, but also to extend to carbon sequestration or geothermal resource activity. And I think it's an important initial clarification. It may be unnecessary, but I definitely wanted to make that point. If I could then quickly jump to and ask that Lindsay, Ms. Radcliffe, post the Exhibit 6. And I don't know if there's the ability to expand that or not, but it would be helpful if we can. And specifically, what I wanted to point out that this is, and you could take judicial notice of this, I think it's just helpful to have it. This legislation was a law that was passed by Congress in 1984. And the purpose of the law was to address questions about the exterior boundaries of the Southern Ute Indian Reservation, which are specifically addressed in Section 3 of this legislation, and also to at least attempt in part to address the jurisdictional complications that have resulted from this long history involving the Southern Ute Indian Reservation over the last 150 years, and the vagaries of different Indian policies, federal policies that have arisen during that time period. But the main point here, I think, really is just to confirm the exterior boundaries of the reservation that are reflected in Section 3. And Lindsay, if you could move then to Exhibit 1, please. This is a map that's generated by the Tribe's Department of Energy, and it shows the exterior boundaries as reflected in that Public Law 98-290. We've put on and have added the township and range numbers. I suspect that a map like this or one similar is probably Chairman Robbins is familiar with in some of his prior dealings with the tribe and with La Plata County. But it depicts the exterior boundaries of the reservation as confirmed by Congress. If you could turn then, Ms. Radcliffe, to Exhibit 2, please. The difficulty that perhaps generated the need for Congress to pass Public Law 98-290 first appears if you start looking at the ownership of the surface of lands within the boundaries of the reservation. And as a result of different federal policies, including the allotment policy and then subsequent homesteading and then restoration of undisposed of lands back to tribal trust ownership, we have quite a patchwork of different types of surface ownership within the boundaries of the reservation, which you can all imagine has created jurisdictional challenges as both the tribe and the federal government and the state attempt to address their relative jurisdictions. If you could move then to Exhibit 3, please, Lindsay. And that gets even more complicated. It's not as if even that surface map that we just looked at Exhibit 2 establishes the rule across the board. As a result of different statutes that were enacted by Congress dealing with homesteading, you had a progression of different laws that the federal government ended up reserving certain mineral estates from homesteaders, including in 1909 and 1910, coal resources, and then following passage of the 1916 Homesteading Act, reserved all other minerals from homestead patents that were issued to subsequent allottees or subsequent homesteaders. And so as a result, what we have on the reservation is a 3D checkerboard of ownerships that involve the surface land, which can be distinct. And I could point out some specific ones. I don't think in the interest of time it's necessary, but we have some properties where the tribe owns all the minerals and you've got private landowners that own the surface. And that's really the point of these exhibits, is to show the complicated nature of that land ownership. And with that, Lindsay, keeping in mind both the nature of this, as well as Congress's attempt to address that in Public Law 98-290 or 280 to some extent, and also to reflect on the past dealings we've had with the state, I'd ask that you turn to Exhibit 7, please. I think it would be most helpful to talk about how those different factors interplay in the context of what we've suggested for the Commission's consideration in terms of amended rules. And turning to the very first one, we suggest that there be a new subpart that's added to the definition of geothermal operation or deep geothermal operation in terms of your rules that would include the following provision. Deep geothermal operation does not include any exploration or production activities for allocated geothermal resources or geothermal resources that are deeper than 2,500 feet below the surface, conducted by a federally recognized Indian tribe or an entity owned or controlled by such tribe within the exterior boundaries of an Indian reservation. There's already, under the proposed series definitions that have been suggested in the rules, several exceptions. And we think that it would be helpful to make it clear that where we're talking about Indian tribal conduct anywhere within the boundaries of the reservation, that it should be excluded from being considered as deep geothermal operation under the ECMC's rules. If I could turn to the second definition that we suggest, or changes that we suggest, and again, looking at the July 23rd, 2024 proposed rules, there's a definition of Indian lands, and we appreciate the staff and the Commission's efforts at trying to address these matters. And I'd like to read it with the suggested language changes and explain to you why we have those suggested changes. Indian lands shall mean those lands located within the exterior boundaries of a defined Indian reservation, including allotted Indian lands, in which the legal, beneficial, or restricted ownership of the surface or the underlying oil, gas, including coal bed methane, geothermal resources, or other energy or carbon management resources, or of the right to explore for and develop the oil, gas, geothermal resources, or other energy or carbon management resource belongs to or is leased from an Indian tribe or the applicable Indian allottee. And it might be helpful, Lindsay, if you can, to expand to the screen on that section too. We think that the current definition of Indian lands is just too narrow to address the kind of complicated land ownership issues that we have on the reservation. And this change in definition would make it clear that if we're talking about the surface of land being held by an Indian tribe or an Indian allottee, that would fall within the definition of Indian land, as would the ownership of any other resource that's regulated by the ECMC. And again, this corresponds, we believe, with HB 241346, as mentioned before. The third definition that we would suggest near the bottom of the page is really a suggestion that's intended to maintain as neutral an unresolved issue as to ownership of non-tributary groundwater within the boundaries of the reservation. And we've addressed these issues both in our pre-hearing statement as well as the pre-filed testimony. But what we suggest, because the proposition leading to this language is that neither the state of Colorado nor the Southern Ute Indian Tribe has at this point been able to definitively reached a resolution as to who owns non-tributary groundwater within the reservation, would say whether the state of Colorado or the Southern Ute Indian Tribe owns or has jurisdiction to regulate the use of non-tributary groundwater underlying the Southern Ute Indian Reservation has not been finally adjudicated or conclusively determined. In support of that, Lindsay, if you could jump, we're going to come back to Exhibit 7, but if you could turn, please, to Exhibit 5. Yeah, Exhibit 5 is a copy of the settlement agreement that took many years of negotiation and court proceedings between the Southern Ute Indian Tribe and the Ute Mountain Ute Tribe and the state of Colorado and many water users. And this is a final settlement agreement that was ultimately incorporated as part of the final adjudication of certain water rights that were owned by and asserted by the Southern Ute Indian Tribe or the United States on its behalf under the implied reservation doctrine. And specifically, this settlement agreement did not address ownership of non-tributary groundwater. It did address ownership of surface and tributary water, including some regulation of wells with regard to tributary water. And specifically, if you could turn, please, let's see, to on Exhibit 5, if you could turn to, I apologize here for a second. Turn please to the PDF page 62 PDF page 64. It's page 62 of the actual settlement agreement. And this talks about what claims have been waived as a result of this adjudication. And the tribes in the United States waived any and all claims to water rights within the state of Colorado not expressly identified in the final consent decree established by existing state or federal court decree or otherwise recognized under the state, including any and all claims to water rights or injury to water rights for the benefit of the tributary, for the benefit of the tribe or any individual claiming the right to use water under the tribe from any source of surface water or waters tributary thereto. And it's that limitation on the scope of the waiver that has given rise, that's been recognized by the Division of Water Resources and the state engineer as not having settled this issue about what about non-tributary groundwater not having been resolved in the settlement. And if you could turn, Lindsay, then to Exhibit 4, please. Exhibit 4 is it comes from the tribe's Department of Energy mapping, but I will tell you this particular map is actually generated in a rulemaking regarding non-tributary groundwater that was undertaken by the Department of Water Resources. And I'll make a reference to it that you can look to as well. This is just an example of the mapping of non-tributary groundwater within the boundaries of the Southern Ute Indian Reservation as it relates to the Fruitland Formation. And if you were to actually look up, and I think we've made reference to the CCR that was involved with this rulemaking, which is 2 CCR 402. There was a series of maps that are found as exhibits to that rulemaking, including map A-9A, A-9B, A-9C, A-9D, and E, that relate to different formations within the boundaries of the reservation, including not just the Fruitland, but also the Pictured Cliff Sandstone, the Cliff House Sandstone, the Menifee Formation, the Point Lookout Sandstone, the Dakota Formation, all of which are found at varying depths within the boundaries of reservation. And for each one of those formations, there's actually a different map with regard to non-tributary groundwater. And the result of this rulemaking was, as we've pointed out in our filings, was that there was no resolution as to ownership from a regulatory recognition standpoint by the state engineer as to the ownership or administration of non-tributary groundwater within the boundaries of the reservation. And again, this is just a sample of one such formation. So I think that explanation, if you could turn back to Exhibit 7, and you can understand now why it would have been total loss if I was doing this myself. Our purpose for making the suggested change to the non-tributary groundwater definition, again, was to preserve that neutrality, which has already been recognized in the Colorado Ute Settlement Agreement, and also has been previously recognized in Colorado rulemaking. I think that if we could then move to the next page, please, of Exhibit 7. And if I could, this goes now to the 1300 series. And the reason why we did put in, thank you for that notice. The reason we did put in a difference, if you will, in dealing with the definitions of Series 100 and Series 1300 is because those Series 100 changes are going to have application to not just the geothermal operations, but other matters that the commission undertakes. And so I think it's important to have the clarifying language, both with regard to the ownership of non-tributary groundwater, but also as to the other matters that were addressed in HB 24, that later legislation dealing with carbon sequestration, among others. So now turning to the 1300 series, the ECMC should add a specific clarifying provision, a proposed new rule 1301D addressing application of the geothermal operational rules to the tribe and the Southern Ute Indian lands as follows. Except for the requirement for consultation with tribal governments set forth in section 1304K, and that should be a period K instead of a parenthetical, the 1300 series rules do not apply to 1, Indian lands, or 2, the Southern Ute Indian tribe, or any tribally controlled entities conducting deep geothermal operations on lands within the exterior boundaries of the Southern Ute Indian Reservation. This language, we think, corresponds to the statutory exemption that currently is applicable to the ECMC, but in terms of you're having a separate series that deals specifically with geothermal operations, our request is that you also include this exception for that purpose. And then if you could move to the next one down in terms of geothermal, or non-tributary geothermal resources, this is intended within your operational rules for geothermal to have a corresponding express provision that nothing in these Series 1300 rules is intended to establish ownership or the jurisdiction of either the state or of Colorado or the Southern Ute Indian tribe over non-tributary groundwater within the boundaries of the Southern Ute Indian Reservation, and that reservation has confirmed in Public Law 98-290, which you've previously seen. So again, this is just a duplication in some ways, but makes it clear that it's specific to geothermal series, 1300 series. And then down below, there is currently, and we really appreciate the commission staff has added a consultation requirement with regard to tribal governments. And specifically under these 1300 series, it's intended to address any impact on tribal minerals and or geothermal resources. And we wanted to add or may adversely affect other tribal resources. And I don't know that at this point, I'm not sure that I could specify what the impacts might be. But the Southern Ute tribe, for example, regulates air quality, not just for the Southern Ute Indian tribe, but for everybody within the boundaries of the Southern Ute Indian Reservation as a result of an intergovernmental compact between the tribe and the state, as well as a statutory amendment by Congress dealing with the Clean Air Act. So I don't know whether we're going to have any potential air impacts associated with the activities, but this is to expand the scope of the consultation to address those if we do. Similarly, the tribe has a tribal historic preservation office dealing with cultural resources. It used to be that the state of Colorado had a state historic preservation office, and under federal law, it was principally involved with cultural preservation or preservation of cultural resources within the boundaries of the reservation. That has changed as a result of the tribe having a recognized tribal historic preservation office. So those are just a couple of examples of where we might have other tribal resources that would be impacted, and we want the consultation requirement to extend to those. And to the next page, please. Again, these are procedures that are intended to just be consistent with that suggestion. So I apologize for the kind of hasty treatment, but I do think that the proposed language we suggest is probably most important for your purposes. And I'm happy to try to answer any questions. And actually that becomes a different issue. At this point, I have addressed each of those exhibits. I don't know that there's a need to move their admission into the hearing record, but if so, I request that the exhibits be included in the hearing record. And also, I would like to talk about subsequent availability to address questions from the commission.
Sure. We'll consider the exhibits admitted into the record. And I would like to elevate my Attorney General, Benjamin Boudreau, who was listening in because a lot of these are legal arguments. And Mr. Ships, as you know, I turned in my license quite a while back, so I don't even pretend to be a lawyer anymore. But I do have a really good one in AG Boudreau. Do you have any comments, Mr. Boudreau, in terms of response?
Thank you, Mr. Chair. Yes. And first, I'd like to thank Mr. Ships and his clients. They've been active stakeholders throughout this process and have helped us with their thoughts on how to address some of the issues that we know are near and dear to the Southern Utes as it pertains to development of their geothermal resources. So I'll try to take these one at a time. First, regarding my comments this morning about the Geothermal Resources Act versus the Energy and Carbon Management Act, perhaps I misspoke. The Geothermal Resources Act is where ECMC certainly derives its authority for rulemaking as it pertains to deep geothermal ops. And that's not to say that the Energy and Carbon Management Act has no role to play, but I appreciate that clarification. Moving on to point one in the SUIT attachment, the proposed language that Mr. Ships had on the screen. So as I understand it, one is an addition to the definition of deep geothermal operation, one that says deep geothermal operation does not include any geothermal operations that pertain to geothermal resources deeper than 2,500 feet, conducted by a federally recognized Indian tribe or entity owned or controlled. So we are aware that ECMC has pretty severe limitations on its regulatory authority within the exterior boundaries of the Southern Ute Indian Reservation. We, in the staff's proposed draft, we tried to address this by incorporating by reference rule number 201D, which we felt spelled out those limitations. So 201D says that these rules, and referring to all of ECMC's rules, do not apply to Indian trust lands and minerals or the Southern Ute Indian tribe within the exterior boundaries of the Southern Ute Indian Reservation. The commission rules will apply to non-Indians conducting oil and gas operations on lands within the exterior boundaries of the Southern Ute Indian Reservation, but only where both the surface and oil and gas estates are, in this context, geothermal. Although I understand under federal law, oil and gas and geothermal are both recognized as mineral estates. Are owned in fee by persons or entities other than the Southern Ute Indian tribe, regardless of whether such lands are communitized or pooled. So when incorporating that by reference, we read that to mean that ECMC only has regulatory authority within the exterior boundaries of the Southern Ute Indian tribe if 3 conditions are met. 1, the surface is fee. 2, the subsurface is fee, specifically in this context, what federal law would recognize as the mineral estate. And C, the operator is not connected to the Southern Ute Indian tribe. And so that's how we kind of read 201D, specifically 201D, and why we incorporated it by reference. So going back to Mr. Shipp's proposed language, deep geothermal operation does not include. We felt like 201D already covered that. Having said that, I think I see what Mr. Shipps is trying to do with this proposed language, and it's consistent with my understanding of both federal and state law on ECMC limitations. So the only reason we didn't include that is because we felt like 201D already covered it. Similar situation for the proposed amendment to the definition of Indian lands. I will say in the revised draft, staff did edit the definition of Indian lands to specifically exclude geothermal resources from ECMC regulation, but it doesn't have as many red lines as Mr. Shipps does here. Getting on to the third point about non-tributary groundwater and the language, which I'm quoting, whether the state of Colorado or the Southern Ute Indian tribe owns or has jurisdiction to regulate the use of non-tributary groundwater underlying the Southern Ute Indian Reservation has not been finally adjudicated or conclusively determined. It's our understanding, and Mr. Shipps, correct me if I'm wrong, it's our understanding that that has to do with an ongoing discussion with DWR as to sort of what's the status of non-tributary groundwater underlying the Southern Ute Indian Reservation. If that's accurate, we recognize that this was in the pre-hearing statements or possibly in your written testimony. The reason staff didn't include it in the revised draft is because staff felt it was maybe inappropriate to address discussions between 2 governmental entities that doesn't include ECMC, and that memorializing that in the rules might not be best. And I think putting a statement in that basically says ECMC takes no position is the same as remaining silent. And I don't mean to denigrate what's written here. I recognize that there is an ongoing discussion between the Southern Utes and DWR over that. So those were the 3 that I wanted to address. I think specifically the first one, Mr. Shipps went through some statutory provisions in Colorado law that are applicable and limit ECMC's jurisdiction over tribal geothermal resources or minerals under federal law. Staff is aware that there are federal provisions that govern this and have no means of usurping that power or sort of stepping on anyone's toes. So anyway, that's kind of why we addressed the issue pertaining to Southern Ute resources the way that we did, incorporating 201D, which we felt like covered it, but that's in no way meant to minimize Southern Ute's concerns here. Chairman, you're muted.
I'm muted, yep. Mr. Ships, did you want to respond back vis-a-vis the points made by the Attorney General? I think at the end of the day, what I think I'm hearing is we're all saying the same things. It's just a matter of how to make sure we get it drafted consistent with how we worked together previously.
Well, I do have some specific responses that I think go to why we chose the language we did. I'd be happy to talk with Mr. Boudreau separately outside of this, but also to address it. I think even in this, and we recognize the efforts by the commission and staff, but on that first one, for example, on deep geothermal operations, by using the incorporation by reference to section 201 of the ECMC rules, that's tied to oil and gas and doesn't also incorporate the expanded statutory treatment that we now have with regard to pore space, as well as these geothermal resources. So we think that there's some additional reasons that are supportive of the language that we've suggested, but we'd be happy to engage in additional conversation on those language issues separately, just in the interest of your time and the commission's time. I do think I think it's correct, and I don't view us as being in disagreement. I think that substantively, I think that we're in substantial agreement, if not total agreement. I think it's a question of wordsmithing, but we're very close.
With that being the case, I would love to encourage Mr. Boudreau to reach out, and maybe you guys could work offline. I mean, it's not an issue that is going to be relevant to all the other stakeholders that are going to be testifying today, but it is a highly important issue. And it's a little bit different than how we would approach another stakeholder. But and we're not going to finish this up today, but if you guys could chat amongst yourselves and sort of get to the right spot, and then I could probably recognize you, Mr. Ships, even though it will be a question from me to you a little bit later in the proceeding, and you can sort of show us what was arrived at, if that sounds like a plan.
That's helpful. Just as a matter of scheduling, if it's at all possible, I mean, we don't have any problem at all trying to participate later, but the potential need to be available full-time for the next week is really challenging. If there's some way we could have notice or an opportunity to rejoin this hearing or visit otherwise, we'd be glad to make whatever accommodations we can.
Absolutely. All that can be taken care of. Mr. Boudreau, would you reach out directly to Mr. Ships, have that discussion, and then get back to me? And I also am not trying to cut off other commissioners who may have questions. I just, having worked with on this sort of issue in a previous panel, I understand the importance here and how it's sort of singularly different than the rest of the stuff we're dealing with on deep geothermal. Does anyone have questions of Mr. Ships before we have he and Mr. Boudreau to talk about this offline a little bit? All right, seeing none, thank you very much for the participation. We'll figure this out. Mr. Boudreau will be reaching out to you here probably pretty shortly.
Thank you very much.
Yeah, thank you. Thank you, Ms. Ratcliffe. Great job on the slides. All right. With that, we need to elevate the folks that are associated with the allied local governments who would be participating next. And commissioners, I think this is like 3 or 4 lawyers, so let's take 5. Let's return at 1:45. All right, welcome back. This was the Energy and Carbon Management Commission. It is August the 5th. It's 1:45. We're in docket 2405-00115, the deep geothermal rulemaking. We have now before us the representatives and witnesses from the allied local governments. Who wants to take the lead? Kate, looks like you're unmuted.
Yeah, good afternoon, commissioners. I do have 4 witnesses who will need to be sworn in, and then we've got another couple folks who are here
kind of as resources to answer questions if needed. So maybe we want to do the swearing in
Yeah,
first.
and actually, my Attorney General Davenport reminded me at a break that because this is policy and not a quasi judicial matter, we don't need to do the swearing ins at this time. Obviously, we want everybody to tell the truth, but we'll just leave it at that. And you've got 30 minutes. Did you want to hold back any time for rebuttal, or are you going to keep track of all that?
Yeah, I think we're gonna do our best to be concise and see what we end up with. We've got several points to get through. So again, I'm Kate Burke with the Boulder County Attorney's Office, and I'm going to go ahead and lead off here. And I am going to fly a little bit, but happy to discuss and answer questions after. I would like to share my screen here. Okay, and then I want to start by saying that the ALG communities recognize the potential benefits of DGO and really are in favor of its development. We're looking forward to it stepping in to provide more and cleaner energy. And so our suggestions today are meant to be constructive points to help ensure that this important new technology gets off on the right foot in the state. We've worked to make our suggestions as effective as possible without throwing up unnecessary roadblocks. And despite one additional chance to consult and an alternative location analysis, which could be done concurrently with other plans that go along with the Form 2G, our proposed changes should not add noticeable time or burden to the permitting process, but will increase protections. Oops. We still feel that DGO should be subject to cumulative impacts analysis. But as we said in our response statement, we acknowledge the agency's and the administration's position on that. So instead, we've suggested specific pieces of additional regulation to take the place of a cumulative impacts analysis. So this is our underlying point. Despite its promise as a clean energy source, DGO will have some adverse impacts, although we don't yet know the scope of them, and it's important to recognize that. The net impacts of DGO should be less than oil and gas, and in some instances, the scale may be smaller, but that doesn't mean there won't be impacts to the people, plants, and animals living near the facilities. I don't think the governor intends to build this tech on their backs. Ms. Ostrom with Geothermal Rising showed photos of an on-location closed loop system in combination with an oil and gas well, but it's our understanding that geothermal projects could also include a number of coupled wells surrounding a large power production building. So the regulations are going to have to recognize that these very different scales. In addition to the quotes from your report that Mr. Lepore gave you, that report has a lot to say, as do other sources, about both known and predictable adverse impacts of DGO. Among these, I do point to page 234 of the report, which states that the substances used to hydraulically fracture DGO wells may be different, but it does not say, and staff did not say when we talked with them, that the fracking equipment, engines, or processes would be different. I'm going to flip through all these slides fairly quickly just to give you a taste of the acknowledgement of adverse impacts from geothermal that either can be anticipated or have been documented from various sources, your own report and others. So we have emissions, we have noise, we have water usage, seismicity. By the way, there's on the photo on the left, there is a leak of fluids in a town in Germany, I believe, yes. More seismicity, impacts on wildlife, and we'll provide this PowerPoint so you can look at these more closely. Specific impacts on sage grouse that were documented in a study. Waste heat. And impacts on surface features. So because of these foreseeable impacts on the known unknowns for the state and our long experience with oil and gas pre-production that gives us important insight, we strongly urge taking the precautionary approach and creating more protections in key areas. Do we need to wait for negative impacts to occur and then take decades to respond through legislation and regulation, as has happened with oil and gas? We agree with Geothermal Rising that the rules should be right-sized, and they will likely need to cover a multitude of types and scales of facilities. But rather than ignore crucial protections from foreseeable impacts to begin with, and also require another rulemaking relatively soon, We strongly advocate for starting from a more protected place informed by long experience of drilling and fracking. We don't want to overstate the issues any more than we want to underestimate them, but only time and data will determine the right spot. Which leads me to our first substantive point, which is we would like to see added to the rules a reporting mechanism that would allow the ECMC and the public to learn about the real impacts of DGO. So only by tracking real-world experience will we gain a clear understanding and be able to better right-size the rules with precision. And we didn't provide specific rule language on this because we don't know the best mechanism to do it from staff's point of view. Maybe it's a Form 2B kind of thing or a CIDR database kind of thing, but we strongly encourage something like that to collect information on DGO impacts as the technology grows. Okay, I apologize. My Deputy Director of Planning, Kim Sanchez, was going to testify to this next portion, but she is caught up in fire emergency response in Boulder County, so I'm going to have to speak for her. And following along with our last point, I'm not going to belabor these issues. We explored this quite a bit in our PHS, and they're very straightforward, in fact. But just because of the unknown but predictable adverse impacts, it's essential that DGO be cited with the same care and scrutiny that we've developed for oil and gas over the years, including an alternative location analysis and protective setbacks. The only concrete difference between oil and gas and DGO in the pre-production phase, which is what we're focused on, is the number of wells going in at any one time. And even this is unclear as the state's report mentions any number of wells from 8 to 24 for a given power project. But we know what drilling and fracking pre-production look like, as copiously laid out in our PHS, and why a 2,000-foot setback was necessary in the oil and gas context. And we see no principled reason to allow drilling and possibly fracking to occur within a few hundred feet of homes. As much as the governor and administration want to foster DGO, it would be disastrous if in the rush to do so, we experience the kind of disruption, health impacts, and environmental impacts that we've seen from oil and gas drilling by ignoring the lessons learned over the decades. Now, on a sort of similar note, ECMC and local governments have developed a great collaboration with their co-authority over oil and gas regulation, and we want to make sure that it works as well with DGO. So we have two suggestions here. First, we request a pre-application consultation for DGO that includes local governments. If Rule 1304 intended that to happen, it's really not clear because local governments are not listed as parties to consult in either 1303 or 1304. So we would like that to be clarified. And then we also request a post-completeness consultation opportunity. And this could be something upon our request, not necessarily required, but because we expect that an application would change from the pre-application stage through the end of completeness review. We expect that it's going to evolve, and we'd like to be able to be aware of the new evolved proposal by the time completeness is over. And to accomplish these points, the changes we're proposing are quite simple, just two additions to 1304. Adding local governments into the 1304A pre-app consultation, and then adding a subsection B for a post-completeness consult opportunity. Okay, with that, I'm going to turn it over to Cindy Copeland.
Thank you, Commissioners. I'm Cindy Copeland, Air and Climate Policy Advisor for Boulder County. The ALG takes the position that deep geothermal operators should use clean pre-production engines to reduce NOx and VOCs, as well as odor during drilling. You heard earlier today from CEO Director Tour that there will be no continuous emissions of VOCs and methane. But these comments did not distinguish between NOx and HAPs from dirty diesel engines used to drill wells versus methane and VOCs from venting of natural gas from drilling into hydrocarbon reservoirs associated with oil and gas drilling. You similarly heard from Johanna Ostrom that geothermal development can be zero emissions. What we are focused on is not emissions from the geothermal process itself, but rather from the engines and associated equipment used to drill and complete these wells. Deep geothermal operators should eliminate pollution during pre-production operations by using electric power drill rigs and associated equipment where technically feasible. Alternatively, deep geothermal operators can minimize pollution during drilling by using cleaner burning fossil fuel powered engines and associated equipment such as Tier 4 diesel engines or natural gas generators. And a suite of technologies are available to help deep geothermal operators eliminate or minimize pollution from engines, pumps, and other associated equipment used during hydraulic fracturing. And if we go to the next slide, you'll see that the ALG submitted rule language to this effect in our written testimony. This language provides more detailed requirements for drilling operations and hydraulic fracturing or refracturing. We submitted this rule language as written testimony after learning that geothermal operations would not be covered by the cumulative impacts rules. And this is also similar in theory to the AQCC's Regulation 7 for this type of engine. So our recommendations would reduce NOx and hazardous air pollutants emitted by dirty engines and associated equipment that contribute to ozone pollution and unhealthy air quality. Many of our residents live within the Denver Metro North Front Range ozone non-attainment area, where the state needs to do much more to protect air quality and public health. So thank you very much. And with that, I will turn it over to my colleague, Colin Tom.
Thanks, Cindy. Thank you, commissioners. I'm Colin Tom, Climate and Health Strategist here at Boulder County. The ALG recommends provisions to strengthen the representation and participation of potentially impacted DIC residents in the public process. Our equity concerns are primarily with the cumulative impacts already described from operations at this scale and that will accumulate with similar impacts that are disproportionately experienced by DICs. As this graphic illustrates, additional provisions are necessary to provide adequate public process access for these DICs, so these often overburdened communities can have their concerns heard and addressed. The community liaison proposed in pending cumulative impacts rules is not and should not be limited to oil and gas. The geothermal rules should include the community liaison in all consultations to provide assistance to DICs. The community liaison is equally important for consultations on deep geothermal operations. This is because overburdened communities may not have the time or capacity to monitor applications, request a consultation, or advocate for their needs. So the state should affirmatively provide that support. ALG believes this consultation with CDPHE should be mandatory for any application inside or within 2,000 feet of a DIC, and those consultations should be open to any representatives invited by DIC members. Finally, ALG recommends 60 days rather than 45 to provide public comment on applications mirroring the proposed cumulative impact rules to accommodate language and accessibility barriers of participation that exist in DICs. Thank you very much.
Good afternoon, commissioners. This is Jeffrey Moore, manager of the Energy and Environment Division for the City of Aurora. Thanks for the opportunity to share some thoughts on our perspective on financial assurance for DGO wells today. We very much support the draft rules that you have put in place here. We think they're appropriate. I want to share some of the reasons why we believe that they are appropriate. And we acknowledged, as others have said already, the drilling of geothermal wells requires pretty much the same equipment as the drilling of hydrocarbon wells. That refers to the siting as well as some of the risks that are involved. We also acknowledge that in drilling to some of the geothermal targets, you have to also drill into and through hydrocarbon-bearing zones. This means that there is a future risk of hydrocarbon contamination in well bores and in shallow aquifers because you are accessing through a well bore hydrocarbon zones in some cases. Geothermal projects also have the same operational and financial risk profile as hydrocarbon projects. Many of them are very high capital upfront, particularly the ones that involve drilling of wells, followed by ongoing operational cost and declining revenue at some point, maybe not quite as severe, certainly not as severe as shale wells, but there is an element of declining revenue in the projects. Because of those things, we believe the risk of orphaned geothermal wells is really no greater than the risk are no different than the risk of orphaned hydrocarbon wells, but it actually could be greater when you consider the fact that the industry is new. It may be heavily funded by investors and startup companies rather than established oil and gas operators. Ms. Ostrom testified this morning that startup companies do not have deep pockets. And so our concern for providing appropriate financial assurance really has to do with making sure that we don't end up in a situation that much of the country has with oil and gas wells, when a lot of the wells drilled in the very early days of the industry ended up being orphaned. We don't want to see that for this industry. We do agree with the rules you've put in place, the draft rules, and think that they're appropriate. And thank you for your time. I'll switch now to Mr. Greg Dean with Adams County.
Thanks, Jeffrey, and good afternoon, Commissioners. I'm Greg Dean. I'm the Oil and Gas Administrator for Adams County. Today, I'll be discussing the allied local governments' positions and recommendations for enhanced notice and consultation in the deep geothermal rules. The ALG is requesting expanded consultation notice and/or public comment in the draft rules in several instances. First, for changes to previously approved permits via Form 4s and subsequent operations at existing wells pursuant to Rule 1302C and 1308, respectively. Given the service impacts of DGO are still in the nascent stages of understanding, and most local governments are still learning how to mitigate potential adverse impacts for the residents and resources from this use, it's critical for the director and the commission to engage local governments in these instances. Something that may be deemed not a significant change by the ECMC, as in the draft rules, may in fact trigger a new or amended permit at the local level, and without such notice, our siting jurisdiction may be inadvertently circumvented. Next, relevant and proximate local governments should automatically be notified when the director makes a conditional approval of a DGO application via Rule 1305. Given most DGO applications will likely be approved administratively, absent a hearing, this conditional approval period may be the last opportunities for local governments to comment or consult with ECMC prior final approval. In that same vein, we request the timeline for conditional approvals to become final, absent commissioner intervention, to be increased from 10 days as currently proposed to a reasonable 15 business days. Again, given the incipient nature of DGO regulations, local governments may very well enact or amend rules after an application is initially submitted to the ECMC, and also that many of our local governments boards and commissions only convene a few times per month. Increasing this timeline will ensure that we have the opportunity to review the conditional approval and make comments or request a hearing as otherwise would be allowed in the rules. And lastly, as it's related to the conversion or repurposing of oil and gas well bores for DGO under Rule 1311, we strongly request that this process involve local government and other relevant agency engagement, rather than being done through an administrative Form 2 process as currently proposed. For example, in Adams County, most of the wells in our jurisdiction do not have a permit from us, as they were drilled before we had any authority to regulate, and thus are operated under what we call legal non-conforming status. As such, any change to that use, such as from an oil and gas use to a DGO use, any increase in the intensity on that location, any adding of new equipment or expansion of surface impacts would likely trigger a new land use approval process from the county. And this may be true for other local governments. To ensure local government siting authority that is required in legislation is satisfied, local governments must be notified and consulted during this process. To help address this potential land use implication, the ALG would recommend amending Rule 1311 for the repurposing of oil and gas wells for DGO to require a Form 2G, which would include all consultation, public comment, and notice requirements currently proposed throughout the 1300 series rules, which we are broadly supportive of. Thank you for your consideration of our concerns and suggestions, and I pass it back to Kate Burke to finish up.
Thanks, Greg. We have said several things about the pooling and the forced pooling of geothermal resources, and that's because it's confusing. Pooling is already confusing, and now we have a brand new property regime that nobody really knows how it's going to work or how it's going to play out. So with two classes of recommendations, a few tweaks to the existing rule, and then we would like to ask for a commitment to be rethinking and possibly even setting up a working group to look at potentially new models for how to pool and unitize geothermal resources as we learn more about them. But critically, right now, as I understand the rules, there is actually no notice of a GRU application or a pooling application sent to geothermal resource owners. So in contrast, in 504B3 and 4, oil and gas mineral interest owners get notice of applications to unitize or pool minerals. And we think that this kind of notice is necessary to provide due process to a geothermal resource owner. So that is one important piece. We need notice. Whoops, the rules allow for an operator to pool after the well is drilled. And this, we think, is really defeats due process for anybody impacted by the drilling and the unitization. This is an issue that was recently fixed in the oil and gas context by SB 24-185. It clarified that for oil and gas, the pooling needs to be complete before drilling, and we don't see why we want to replicate that problem here rather than following the wisdom of the General Assembly. Cost recovery in the rules is undefined at the moment. Is it going to be 100%? Is it going to be 500%? How is that going to work? We did suggest using applicable parts of 3060-116-7 that already lay out some technical or specifics around cost recovery that could be helpful. So without notice, without a guarantee of a hearing, and if the resource has already been drilled, how is a resource owner to be heard on any issues about compensation, about cost obligations, about fairness of the original lease offer, or any other topics? So we do request notice under 504B to be required for a GRU application. And a hearing should be held on any contested GRU or pooling application. We do request that, again, following SB 24-185, that local government-owned geothermal resources be exempted from non-consensual pooling. For all the legal and practical reasons supporting that bill, these resources would fall into that same class. And then we're looking for a commitment to revisit pooling procedures in a handful of years to determine how a geothermal property market is starting to develop and how pooling might be aligned with that. Finally, we do support comments to come from Larimer County and Fort Collins about the 45% ownership threshold, which really is too low in this new context. Okay, and then finally, I have two just mechanical things. We have a problem with the definition of proximate local government, and the second most recent revised rules tried to fix it, but with all due respect, I think the fix was extremely clunky and there was a much easier one. So right now, approximate local government is defined by its within 2,000 feet of a proposed working pad surface. A working pad surface is defined as where an oil and gas location is and oil and gas operations take place. The proposed fix was to define a geothermal pad surface and then say where rules in the 1300 series incorporate by reference rules from other series which use the term working pad surface, the term geothermal pad surface will be substituted for working pad surface, which by itself I don't really understand. I also don't know, I don't know that there's a rule that incorporates by reference the definition of proximate local government. And it seems to me it's very, very easy to just amend working pad surface to mean the portion of a location, which is now defined, that has an improved surface upon which, and I would suggest, energy and carbon management operations take place, because that phrase is now defined in statute and will cover this. It'll cover carbon sequestration and anything else that arises in your bailiwick. And then finally, there's just a typo. I assume it's a typo in 1303 F4. It says the relevant or local government. I assume that's meant to be proximate. And then I think we've got a couple minutes left. I just wanted to point out, I think Mr. Sura might mention this too. We really appreciate the changes to the Rule 211 situation with respect to geothermal. There is a little bit of ambiguity, however, where it says they have 3 years to apply to convert it to a deep geothermal well. However, they won't be able to do such an application until these rules come into effect. So today, if a well has already been, an oil and gas well has been low producing for more than 3 years, then that would basically give them another 3 years before a party could initiate a Rule 211 hearing. So we were thinking that we could build in a provision saying, giving 1 year from the effective date of the rules for any pending or any application for a Rule 211 that's filed prior to the effective date or something. Mr. Sura might be able to say that more clearly. But I think that's what we have. So if we have any minutes left, I'd love to reserve them and then offer us all up for questions.
All right, you have 6 minutes left to be reserved. Commissioners, who'd like to start out questions? Commissioner Cross?
Thank you, Mr. Chair, and thank you for this presentation. I wanted to first talk about a little bit of the additional consultation you talked about, and you said 1304 doesn't seem to talk about the consultation, but there is consultation as required under 1303. So with the 1303 having the local government input and saying and citing, is that insufficient in your mind in terms of trying to make sure that the local government will be part of that consultation process, will be part of understanding what's happening in the permitting?
I thought that it was unclear, and let me pull this up so I can speak more intelligently. But so 1304 says pre-app consultation will be held with any parties supposed to be consulted with in 1303 or 1304. And 1303 is the local government rule sort of in general. And there's nothing in that rule about a pre-application consultation or really any consultation. It's mostly about, well, I'm sorry, there is consultation in 1303F after an operator provides notice of a permit application. So as I understand, that means after they filed their application, they would consult with the local government. And what we're looking for is a pre-app consultation. So if 1304 is intended to say local governments will be in on the pre-app, I just think it's not as clear as it could be, and it might just be a minor wordsmith fix. If it was not the intention to include local governments, then I would want to ask that it be so.
Okay.
So it's just that ambiguity because 1303 doesn't.
Because 1303 talks about a consultation after the permit.
Exactly.
You're just hoping that to clarify that because it talks about anybody that has to be consulted, should it be part of a pre-application consult, just make sure that it includes.
Exactly, yes.
Okay. That is helpful to understand what you're looking for there. And then the other question I wanted to touch on. So you talked about having some sort of reporting mechanism, and you said maybe a modified 2B. Are you looking for something that would have estimates on what might be occurring in terms of emissions, like in the 2B, or are you looking for something, the reporting afterwards, like what we get in the CIDR database?
Yeah, thank you. I was intending something like the CIDR database. And I don't know exactly what the mechanism by which operators get info into the CIDR database. So I wasn't sure if it was a 2B or something else. But yes, that was what I intended, was something like the CIDR database, or where the agency collects, these are the actual impacts that we're seeing as this technology gets going, so that can inform our understanding of any right sizing that might need to happen later.
Okay. And then I think the final thing I wanted to touch on was the idea of the post-complete consultation that you talked about as well, because you said being given the opportunity to make changes. And I again wanted to try and understand your position with respect to the fact that local governments will have a say in the siting process under 1303. Again, do you think that the post-complete opportunity is necessary the way you're describing it, given the fact that local governments will also have a say in at least the siting aspect of things?
Yeah, that's a great question. And my answer actually goes back to the discussion from this morning about the 15 business days after conditional approval. They kind of come out the same. Part of the reason I think that's important is simply so the local government knows what's coming. So we have our own process, we'll be going through our own process, or maybe it will already be complete. But I still think it's important for locals to know what is coming to and out of the commission, just to stay, so to speak, in the loop. And then despite that, there's also the possibility, as I think Mr. Boudreau mentioned, that we might have alarm bells go off. I have seen oil and gas applications change from a pre-app discussion to the actual application change just radically. And so I think it would be important for us to just be aware that that's happening, whether we have something to say or whether it's simply to as it may inform our own process. And I don't know if any of my colleagues want to add to that, but I think that principle applies in a couple of the different consultation sections that we've discussed.
So do you foresee this more as a trying to consult to try and make sure that potential non-siting issues that arise, you have your say on, or is this more of a notice so you can provide comment on that?
I'm not sure I see a sharp distinction there. I think maybe both. So I'm trying to come up with a hypothetical here, but let's say the application is proposed in a certain way, and then it evolves, and we have a pre-app and we discuss that, and then we do our own process over here. And then along the way, ECMC, the project evolves, and then there's maybe some BMPs that are suggested, or a lack of BMPs that are maybe suggested. And then at that point, we might have comments about that, or we might want to ask the director, how did this change from what we discussed before? I can think of a lot of conversational, informational sharing that might happen at that stage. And this should be, what I'm proposing is that it's at the request of the local government. So chances are it would not happen that often, but if the local government sees something that it needs information about or wants to offer information to the agency, either way, that opportunity is there. And as it is now, we just would never know once that, as Mr. Dean talked about, once that the conditional approval comes out, or this, or the post-completeness. I mean, I guess we would know, but we'd have to spend our time scrolling around on the website to try to track applications.
So in some sense, is it more of a notice of where the process has gone after you've gone through your local government citing process to say, hey, this is what's coming. This is the application that's come through. These are the BMPs that CDPHE has proposed. These are the BMPs that CPW has proposed, as opposed to the opportunity for a separate consultation meeting with the operator and ECMC. I guess that's just what I'm trying to understand here.
Yeah.
Is it an
I
entire
guess,
meeting with everyone, or is it more so,
right.
hey, I want to make sure I know what has happened in the process since we last touched upon it, and we want to make sure that we can comment on it and are aware of the need.
So I think when you boil it down, it is the notice. And then if we get the notice and there's something alarming about it, then we are going to reach out and want to discuss, but that may not need to be incorporated into the rule, because I'm not suggesting an entire new mandatory meeting. So maybe that piece doesn't need to be in the rule, but the notice itself, I think, is what we're really after. Is that Greg's nodding his head? Does that sound right?
Okay.
That's correct. Just because there's a chance that these processes could be happening concurrently as well.
Right.
I think that clarification is helpful. Thank you.
Other questions? Commissioner Ackerman?
Thank you, Mr. Chair. And just a couple of clarification questions for you, one on financial assurance and one on the concept of setbacks. And the first one, I heard the testimony on financial assurance and agree that it shouldn't be the responsibility of the state to be left with any orphan wells. And in the draft regulations, financial assurance is required via a single well financial assurance program, including general liability insurance and surface protection bonds. Could you elaborate just a little bit more or be more specific on what you might be looking for in addition with regard to financial assurance?
Thank you, Commissioner Ackerman. Can you hear me? Okay, very good.
Mr. Moore,
sorry, my screen blipped there. Yes, I think the rules as you have proposed them are appropriate. And as I read them in 13, I'm going to lose my page here, but 13:16, I believe. Scrolling to that area now, there's two different provisions. One is the single well plugging and abandoning cost, which is a tiered structure based on the depth of the well. There's also the location reclamation cost, which is $100,000 as currently defined. We believe both of those are appropriate because I think there's going to still be, obviously you would have a well and the plugging the well is important, but also reclaiming the location, regardless of what that is. And ideally you would not have things like hydrocarbon spills or tanks that might have to be remediated in the future. but the reclaiming is still going to be necessary. So you're still going to, at the end of a project, you're still going to have to remove certain equipment. You may have flow lines of some degree that could be in place that have to be either abandoned in place properly or removed, and then reclaiming the surface itself back to its original state. So that's going to be required and be necessary. And I think having the funds available guaranteed to do that is the part that will protect the state from having to do that at their cost in the future.
Thank you. I appreciate the additional explanation there. I'm taking that to mean that you were just affirming that the approach to financial assurance is appropriate.
Yes, sir, that is correct.
Thank you so much. And then Ms. Burke, this might be directed at you, but you certainly can pass it somewhere else if you feel appropriate. There's been, some talk, of course. That's an undersell to say there's been some talk. We certainly talk about setbacks a lot in this state. And we've had these discussions about setbacks with regard to oil and gas for many years and over many hearings. With regard to geothermal, for me, it was easy to see that we would want to talk about setbacks with geothermal as well. So I've thought a lot about geothermal setbacks, and with regard to setbacks, some geothermal facilities, especially those used in cascading uses, are by their nature sometimes intended to and meant to be adjacent exactly to the locations which they serve. And so, we might run into some issues where certainly everybody on board wants to site those within a certain distance of a certain facility. With the ability for local governments to pass more restrictive siting rules, spelled out in the regulations and in the act, could you talk a little bit more about if that allays your concern as local governments being able to have control over that, or just help me understand why we would continue to push in that direction?
Yeah, I think it is, as you mentioned, and it always has been, a tricky issue, and especially when you consider the photos that Ms. Ostrom put up of that pretty self-contained little co-production kind of unit that obviously wouldn't have very adverse impacts. But then on the other hand, we have heard from other geothermal companies about drilling that is the same size, using the same engines and the same basic methodology as drilling an oil and gas well. And we just have so many decades of experience of what those drilling procedures do as far as noise and light and odor and dust and all the things. And in their response statement, Geothermal Rising said that we had overstated the ways in which geothermal pre-production is similar to oil and gas pre-production. But when I went back to the state's report to look at the quotes they pulled out, the more I read, I didn't see what they were saying. I think the report said, no, in a lot of cases, it really is the same. And the expectation is that there might be fewer wells in one spot, or maybe there will be some new drilling technology available or something, but there was nothing very concrete that made a big difference. So I think it's our feeling that it just feels irresponsible to say we determined over many, many years and many, many, many scientific studies that 2,000 feet was a safe setback with some exceptions for an oil and gas well, but now we can drill these other wells in the same manner at 200 feet. It just doesn't add up. However, clearly we're going to have these different scales and different styles of technology happening with geothermal. So there's going to have to be some responsiveness in the rules to deal with that. But I don't know that we know what that is at this point. We don't know how to do that yet. And this is kind of back to our theme of we should be taking the precautionary approach. So our sense, the best we can understand from having talked with agency staff and with at least one geothermal company and listening to Geothermal Rising, is that there's just not enough difference between drilling an oil and gas well and drilling a geothermal well to warrant such a drastically different setback from homes and the places where people are congregating, or, for example, high priority habitat. And then as far as local versus state, one of our themes during the mission change rulemaking is that with this co-equal authority, we are interested in seeing the state provide the floor of regulation, and then the locals are allowed to be stricter. And probably the local governments that you're looking at here on this screen are probably very active and will be creating and enforcing their own regulations. But there are many local governments, municipalities, and smaller counties that can't. They don't have the personnel, they don't have the resources. Maybe they would like to, but they just simply can't afford to regulate in that way. And so we would like to see people and environment in those areas equally as protected as they would be, say, in a Boulder County or an Adams County.
Thank you, Ms. Burke. Appreciate you further elucidating on that topic. And I do think this is certainly a topic we can have further discussion about it. And there are some distinctions with geothermal and certainly some similarities and significant similarities during the pre-production process, I would agree as well. So thank you. I just wanted to say, Mr. Chair, before I turn it back to you, that I, as one commissioner, am very grateful for the allied local governments coming and being cohesive in their presentation here and truly helping us understand what really is on your minds. Thanks for your clear documents and for your testimony here today.
Commissioner Messner.
Thank you, Mr. Chair. Would agree with Commissioner Ackerman. Appreciate the level of detail provided in your pre-hearing statements and appreciate you being here. One of the themes that I'm hearing is the theme of notice. And to you in particular, Mr. Dean, I think you're indicating some desire for notice around 1302C, 1305E, 1308, and 1311. Another theme we heard, from other stakeholders is the desire to see an efficient permitting process that, doesn't run into significant roadblocks. Would you argue that local governments getting notice so they understand the operations that are occurring at the state level and so therefore know how that may affect any kind of process that needs to happen at the local government level has the potential to increase efficiency and ensure that operators understand what they need to do and can potentially shorten timelines?
Yeah, thank you for that question, Commissioner. I think when you add a local government process, it may have the impact of making a process inefficient, but I think at the end of the day, making sure that local government siting authority is adhered to ultimately makes the project run smoother. Adams County would hate to get to a point where during an inspection of a repurposed oil and gas well, we discover geothermal use and we have to issue a cease and desist until we can define that use in our county regulations and shut a project down. We certainly don't want to get to that point. That's why we request that notice occur. We know that the use of Form 4s is often used by oil and gas operators to make quote unquote non-significant changes to oil and gas facilities. Local governments have differing definitions in their own land use authority of what a significant change is. And again, we'd hate to get to the point where we have to take action to stop a change from happening. So at the end of the day, it comes down to making sure that the local government siting jurisdiction is adhered to. Our intent is certainly not to delay a process. That's why I think having robust pre-application consultation is going to be really helpful. We could let the director or staff know that, hey, FYI, this is going to require this type of land use approval. This is going to require an oversized or access permit. This is going to require this type of local government permit, not even just citing the geothermal use itself, but we have haul route. Like if you're going to use our roads, you have to enter into a roadway maintenance agreement. Those are types of conversations that are not under the purview of ECMC, they're local governments, but they could impact the timeline for a project approval. So having those pre-application consultations are important. And then when you make changes to a previously approved permit, a lot of this is being done administratively through the Form 4 or the Form 2 process. We just request that it change to a 2G process so that we are included in that pre-app consultation and we can let the director know, hey, I know they're going to change this well from 1970s to a deep geothermal well. That's going to require an entirely new permit from Adams County. They haven't applied for that yet. slow down the process. So it's in the spirit of open communication between all the parties, and it's not intended to be overly cumbersome.
Yeah, and I think that's my point, which is why I'm asking the question, is it seems like some of your requests for notice, is to make sure that the lines of communication between the state and the local government and ultimately the operator are open so that operator understands what they need to do. There's no unforeseen roadblocks that run into, like you've indicated, that potentially cause extended delays to any kind of permitting process. And so really it's whether it's pre-application inclusion in the pre-application conference or notice of different things that are happening at the state, it could actually make the process more efficient for the operator and shorten timelines because they're not running into roadblocks. Does that seem fair to say?
Yeah, that's our position. And again, I can't speak for all the local governments, but in Adams County, an undefined use in our land use code is prohibited until we can define it. That doesn't mean we're opposed to it. Just if things are moving, technologies are moving so rapidly, we're a little slower to adopt things just because we have to go through our processes internally. And we have not even started the process of defining deep geothermal in our land use code. So we would hate to get to a point where they're so far along in the state process and we have to say, hey, you're going to have to wait 2 years until we can adopt regulations. We'd hope it wouldn't take that long at the local level, but you never know, right? So that's kind of where we're coming from our request for notice and consultation. It's so nascent that I don't think any of the local governments on this call have adopted geothermal regulations in place. And correct me if I'm wrong, but so that's the issue here. It's not that we're opposed to it. We're obviously pro greener energy, lower carbon energy sources. It's moving much quicker than our processes can.
Thank you.
Other questions to the panel? Commissioner Oath?
Yes, thank you. And thank you all very much for all this information. And almost all of my questions have already been addressed. I only have one that I don't think we've touched on, which is about the lifespan, I guess, of a permit before it expires. I think you all had kind of responded to a proposal in the written record for 10 years, for it to be extended from 3 years to 10 years. We've heard here today another proposal for 5. Just want to get your reaction to the 5.
Yeah, I'll start with that. We had some very quick email exchanges, but have not had time to really discuss as a group. So I'll hazard a statement that I think we could live with 5. We thought 10 was inappropriate. We think 3 is great, but if it's we think we can live with 5. We did note a sort of inconsistency with geothermal rising, wanting to get that permit issued ASAP and yet also wanting 5 years to even get their operation going. Mr. Moore pointed that out, so I'll just point that out. But I think our bottom line was we could live with the 5 years.
To the local governments, there was this notion, I forgot the rule number, the deep special geothermal zone concept. Y'all are the local governments. Did you have anything that you wanted to weigh in on that topic?
Well, I'll start while everybody's thinking. I wasn't sure quite what to make of it. I wasn't sure of I've heard what people have said of the sort of the problem or the goal that it's trying to address. Because it provides so much opportunity for the local government to consider and make determinations. My initial thought was, well, sure, if they're interested in doing that, or the ideas brought up to them and they're interested in looking at it, why not? But it was hard for me to understand exactly what it would look like. Or, is it meant to be like a mini old Rule 318A kind of thing where these are our set rules for a defined area? I was a little uncertain. But my bottom line response was like, well, if a local government wants to engage in that, why not?
Okay. Yeah, I mean, I too find it somewhat vague. It's probably a good notion. Anyway, just wanted to give you opportunity to sort of weigh in on that. So thanks very much. Any final questions, Commissioner Cross?
Thank you, Mr. Chair, and I apologize. I did come across one other additional note I had here. And I believe, Ms. Copeland, this is one of the things that you discussed was the use of electric rigs. And I believe you said where technically feasible. And I was hoping to get some clarification on that as well. As you talk about technically feasible, are you talking about purely, is this a situation where, especially if it is a particular deep well, an electric rig may or may not be able to drill that deep or have the necessary power? Or are you talking about technically feasible in terms of it's not going to be possible to get a power line to this in time?
Yeah, and I think in most cases it's the latter. It's usually a question of the power and access to electricity. There was a lot of discussion about this very thing when the AQCC went through a Regulation 7 rulemaking at the end of last year, because now the Regulation 7 rules require this type of electrification for engines where feasible, and normally it is kind of, where feasible due to electricity, knowing that, these wells are put in places that are, sometimes farther away from energy sources. And so, I mean, ideally, all the equipment would be electrified because that's a lot cleaner. But we do know that there are cases where, where it can't all be electric. And so then, that's why there's kind of a step down of this or, the next cleanest engine technology. So like with engines, EPA has its tier requirements for engines. And so using the most recent engine requirements is ideal. So including that, in the rule, we think is really good. I mean, sometimes these engines, they can be moved around. And so even though this is like a new technology and, geothermal is a new thing, they're drilling new wells, it doesn't mean that they're going to be using new equipment, right? So they could be using some older engines that, they can be what's called grandfathered in. And so they can be using lower emission standards. And so they could be pretty dirty, especially when we're talking about like the big diesel engines.
Okay. I just wanted to make sure that it wasn't simply the ability for an electric rig to get to depth, but also the availability of electricity as well. But I appreciate that clarification. That's my only other question. I appreciate it.
All right. Again, I think all the commissioners want to extend thanks to a group of different local governments who got together and cohesively and put together a really good presentation for our consideration. So thank you for that. Next up is Larimer County and City of Fort Collins. Let's do our normal take 5 and come back at 2:45 to take up the next stakeholder. All right, folks, welcome back. Colorado Energy and Carbon Management Commission. It is August 5th and it is 2:45 for the record, taking up docket 240500115, the deep geothermal rulemaking. I believe our next stakeholder that is to present is Larimer County and the City of Fort Collins. Afternoon, Mr. Sura.
Good afternoon. May I share my screen?
You may.
Thank you. Great. Let's position here. Okay, well, my name is Matt Sura. I'm special counsel for Larimer County and the City of Fort Collins, and I want to say from the start that the city and county support deep geothermal power as an important part of the state's renewable energy portfolio. The city and county want to see this industry succeed far from creating hurdles, we believe that finding good locations for the initial projects in Colorado will prevent potential problems and help ensure the success of this growing industry in Colorado. The city and county have altered their positions based on the new draft and conversations with staff and responses from other stakeholders. We have 6 points to make today. First, we want to state our support for the change we requested to require surface use agreements for siting deep geothermal wells. It simply does not make sense that we would allow a geothermal company to force its way onto a surface location of an unwilling landowner. In Rule 1304, consultations, we believe that there are issues that would be helpful to initial siting decisions. First, that geothermal well and geothermal use facility siting. In the event the geothermal wells siting are going to be used for a proposed power plant, we believe that the location of the power plant is relevant. The next one is whether an alternative location analysis should be required. We initially asked for this to be required in all cases, but recognize from hearing the discussions and from our discussions with the staff that isn't necessary in all cases. But for the consultations to discuss whether an alternative location analysis should be required, we think that is a reasonable compromise. In the rest of the issues, I don't think that there's going to be any concerns with. Now, in converting geothermal wells, well bores, the existing oil and gas wells to geothermal, we read that converting a well bore not simply as utilizing heat from produced water from an existing oil and gas well as described by Ms. Ostrom, but converting an oil and gas well to a geothermal well that no longer produces oil and gas. In those cases, we agree with the ALJ that these changes should be subject to notification requirements and a location assessment under a proposed 2G. And next, to discuss permitting, one of the most important parts of Senate Bill 181 and the mission change rulemaking that followed was the right for the public hearing. City and county would argue that there are circumstances that warrant hearings. First, a location that is within 2,000 feet of a residential building, high occupancy building unit, childcare center, school facility, or a future school facility that's not subject to a waiver. Second, the location is within a disproportionately impacted community. And third, a hearing is requested pursuant to Rule 507 by any party entitled to consultation pursuant to 1303 or 1304. We feel that this constrains the amount of hearings that you will have and right sizes the requested hearings and gives still that discretion to the director, but constrains that discretion in some cases. Mr. Boudreau with the Attorney General's office stated that it would be difficult to predict when a hearing might be required by a director. The city and county have concerns that the rules give wide and sole discretion to the director. We also believe that that leads to uncertainty for the industry as well. These are rulemakings that reflect your values and desired outcomes. The rules allow you to choose when you would want to review an application through a public hearing. We would offer that these instances are where there should be some consensus as to when a hearing should be required. The draft rules also allow an operator to determine what an equitable compensation is in its own equitable compensation plan. And this raises all sorts of questions. First, does the equitable compensation include the well or the production facility or both? And what if the end use does not generate any income, but just heat? Does the person who has been force pooled get some sort of compensation of heat or what that heat might cost? It's really unclear. And what does participation look like? Are you suggesting that someone force pooled can have a working interest in the wells or the power plant? What are the costs that are going to be assessed? There's just a lot of questions that we would like to have answers to, and we feel that taking it a case-by-case analysis, as is proposed in an equitable compensation plan, I think is going to lead to probably not equitable answers, and ultimately something that could be challenged. And we'd like to see that cleared up so it isn't challenged. And finally, why a 45% threshold interest? If an operator can only get 45% of the owners to lease their geothermal resources, isn't that in itself a demonstration that they're not making a good faith offer or for offering equitable compensation? The city and county have requested that the 45% threshold be raised to 51%. Now, Senate Bill 181 initially required majority interest of 51% prior to pooling, and this requirement was changed to 45% in response to industry concerns that 51% ownership requirement gave one operator who more or less veto authority due to historical U.S. policy that gave Union Pacific Railroad ownership over a checkerboard of sections on huge parts of the Front Range. Because spacing units were frequently requested at 2 sections, areas within the checkerboard ownership would have been under the sole control of one operator at 50%. Making it 45% allowed for other operators to get involved. Well, that doesn't exist in this case. Because it doesn't exist in this case, and because we're talking about an entirely different consideration, we believe that a minimum 51% control should be required. And finally, we're offering a slight change to the new language filed to address Rule 211 application. The local government or landowner cannot file a 211 claim to have a well plugged before the well has been low producing for 3 years. Introduction of another 3-year requirement could be read that no 211 claims may be made for another 3 years from the effective date of the rule. After talking to staff, we don't believe that that was the intent of the draft rule, and this proposed change would be helpful in providing that clarity. Thank you. I'd like to reserve the rest of my time.
Thank you, Mr. Surek. Now that you're being questioned, your time is no longer ticking. Can you go back over that last point? Were you trying to suggest that by accident, if you added you can't do it within 3 years, and now there's another 3 years, that simple math makes it 6?
That's the way that it could be read, or it could be read that just in the next 3 years, because these rules are just being put in place, that somehow or another they'd get 3 years to consider whether or not they wanted to use these geothermal rules and apply for a geothermal permit 3 years from the date of the rules enactment.
And what does your language do then?
What our language does is say, just takes away that 3-year requirement and just says prior to the application being filed for Rule 211 hearing. So you can't file for a 211 hearing until 3 years have elapsed and that well has been low producing for 3 years. In that time, the operator hasn't done anything with that well in all cases, and the well is either inactive or very low producing. This language would just say that starting immediately, you can request that those wells come under the Rule 211 and be considered for plugging and abandonment under that rule. If this language isn't changed, I think that there's some ambiguity as to what that 3-year period really means and when that would start.
Okay, thanks. Other commissioners with questions? Commissioner Oath?
Thanks, Mr. Chair, and thanks for your presentation. I'm wondering if we can go back to your first point about surface agreements. I'm trying to understand, is this a concern that Larimer County itself has? And if so, what is it, or is it that you've seen something in your role as a county with other surface owners that you're trying to address?
What we're asking for is that this this change in the rule was in response to Larimer County and the city of Fort Collins' request that surface owner agreements be required. And we're just asking for that to remain. I don't think that there's a lot of controversy in this. We did hear from Geothermal Rising that they felt that it was Larimer County was seeking a solution to a problem that was unlikely to arise. But in the event that it does arise, I think that it's a real problem. And we've seen real issues on the oil and gas context when there is an effect, an opportunity to bond on, meaning that you post a very small bond and are able to force your way onto an unwilling landowner. That's caused real concerns, and it's a real inequitable way to negotiate. One entity has basically a trump card and is able to come onto their property whether you want them to or not, and that really slants the negotiation in favor of the operator.
Okay, thanks.
Sure.
Other questions? Commissioner Messner?
Thanks, Mr. Chair. Well, not necessarily a question, but asking for a potential solution. So understanding in Rule 1310 around equitable compensation, some of the confusion or potential questions around that. Did you have a suggestion?
Well, not language suggestion, because just a lot of questions that I would have, both as a local government, we have those questions, and I think that I would have sitting in your position as to what the intent of the language is and how it would be implemented. And given those questions, it seems to me that it may be right for additional stakeholder process, frankly, just to come up with a solution that is, not going to be easily challenged. Right now, there's a lot of controversy, certainly, about the forced pooling regulations as it applies to oil and gas, but we have a 16% royalty income, basically, until such a time as the well has paid for itself twice, and then you have an ownership interest in that well, and you get 100% of your, proportionate share of that oil and gas income. None of that applies here because you're talking about either heat that is being generated for buildings, or you're generating electricity, not really from the well, but from the power plant where the well is feeding hot water to. So it doesn't make sense to use kind of the same nomenclature and the same process for oil and gas as we have for geothermal. And I don't think that anybody in the geothermal industry would argue that they want to have all of a sudden someone with a geothermal interest that is force pooled have some sort of ownership interest in their power plant. I can't imagine that that's what is being proposed. The way I read it is that the industry is able to propose anything that they like, and it'll be discussed by you all to determine whether it's truly equitable. One of the things that Larimer County proposed early, and it was shot down for good reason, because there does need to be a legislative mandate to allow for there to be a condemnation authority, but the condemnation process at least allows for a fair vetting of the value. You have on one hand the operator that gets to put forward their appraisal, and that operator has to pay for appraisal for somebody that is being force pooled or their interest is being condemned. And then you have these two appraisals, and you can decide which one is right or have good information to evaluate to make your decision. You're not going to have any of that evaluation to make your decision. You're not even allowing for a hearing in this case. And so you're really just kind of taking the operator's word for it that this is equitable and it's going to be fine. And I think that just makes you really vulnerable to a legal challenge. And again, city and county just want these rules to be fair, and we want them to not be challengeable because we want to see this industry succeed.
Yeah, thanks for that. I was actually hoping you had this brilliant solution.
No, it was more of a punt, and I apologize.
Thanks.
Other questions for Mr. Sarah? Well, you did a good job of providing your perspective because we don't have a ton of questions.
Great, thank you.
Thank you very much. In the spirit of keep it on going, we now will recognize 350 Colorado for 20 minutes.
Hello, commissioners. Can I share my screen?
Yes, you can, Ms. Leithwood. Beautiful photograph.
I will try to go as quickly as I can and reserve whatever is remaining for my rebuttal. So thank you very much for the opportunity to speak today in this rulemaking hearing. 350 Colorado is a local grassroots organization with 20,000 members, founded over 10 years ago to work toward climate solutions while centering environmental justice. The name 350 signifies the safe level of carbon in the atmosphere in parts per million. In May 2024, the level reached 427. We are working to hasten the transition to a clean energy economy so that the worst impacts of global warming can be averted and everyone can thrive in a healthy environment and a stable climate. Today, you are considering rules for a technology that could become a big piece of the clean energy transition. I'm really excited about that, and our members are really excited about that. We want this technology to succeed and succeed quickly, but we do not want to put rapid deployment of this technology ahead of ensuring the lowest possible climate footprint and the highest possible standard of protection for people and communities. We think both are possible and offer today some suggestions toward that goal. As you set rules toward the future, I'm asking you to be realistic that although conventional geothermal has been used for decades and a lot is known about converting heat to electricity, some of the technologies that these rules apply to are nascent technologies, and not enough is yet known about impacts from them. We're asking you for rules that have the highest level of protection from the beginning, since you can always loosen them later if they're not needed. But once harm is done, you cannot undo it. Please do not repeat past mistakes made in energy development, where new technologies were pursued without adequate protections or study. Here's a summary of the recommendations I'll talk about today. We're asking to modify the statement of basis and purpose to commit to a second rulemaking. In the current rulemaking, we ask for changes to ensure the definitions capture the specifics of the technologies and processes being applied for. We ask you to keep the 2,000-foot setback, to include rules for cumulative impacts and protection of the community, to monitor and prevent fugitive emissions of methane and carbon dioxide, and to eliminate the special deep geothermal zone. I would note that we did provide some red lines in our PHS, but we did not provide red lines for all of our recommendations. Also, I note that most of our recommendations should not increase the time to permit. First of all, to commit to a second rulemaking. This is necessary in order that the statutory mandate for protective rules is fulfilled. CRS 3790.5-106 does not specify a deadline for rulemaking, but it does specify that the rules must protect people, wildlife, and the environment. And of course, I don't need to remind you that you have the authority to instigate a rulemaking at any time you deem necessary. Current rules are not specific enough, and they depend heavily on existing requirements for oil and gas operations. We agree with geothermal rising that not all of these may apply to geothermal, but it is too early in the development of the nascent technology to know when and where these existing requirements are applicable. And there's definitely a need for more experience and data to inform future rules. I apologize for the text-heavy slide here, but I'll be sending them later if you'd like to take a look. Director Tour stated earlier today that the use of geothermal technology to produce electricity is understood. Of course, that is true. But what I am talking about here is not the production of electricity, but how the heat is gotten from the ground. The use of developing advanced technologies for doing this, not conventional technologies, and not enough is known about them. This slide shows Department of Energy determinations. There are very few, if any, completed projects for any of the technologies discussed on this slide and covered by the rulemaking. Repurposing old oil and gas wells, enhanced geothermal systems, and closed loop geothermal. The ECMC report on geothermal references studies on impacts of geothermal, particularly for repurposing old wells, but these are based on simulations and modeling and not real-life experience, which could include monitoring and measurement. All of these technologies are evolving. The DOE states that evolving technologies and environmental risks will need to be assessed. Regarding the use of fracking in enhanced geothermal systems, DOE says this is a matter of public concern. And it's possible that the difference in using fracking for geothermal poses less risk, maybe even far less risk to the public than when used in oil and gas. But as the DOE states, transparency and monitoring of environmental impact are the fastest path to ensure the risks are low and provide for a social license to operate. The DOE states that successful deployment of oil and gas technology in new high temperature environments for enhanced geothermal systems has not yet been demonstrated in varying conditions. For closed loop geothermal, DOE says that risks, especially related to water use and seismicity, must be demonstrated to be manageable or avoidable. Additional technologies are also in development, such as millimeter wave drilling and technologies that do not include fracking to break up the rock for water to pass through. And as more is known, ECMC may decide to make rules to incentivize use of technologies that create less impact. The ECMC report itself acknowledges observing actual impacts will be important in developing regulation. Director Tour also acknowledged this morning that in the real world, we learn as we go and anticipates these rules will evolve over time. Geothermal rising also agrees rules will need to evolve in future rulemakings. In a sense, you might regard the early permits that will be given under this first round of rules as pilot projects. And by monitoring them, information gained can be included in a second stage of rulemaking. Others have suggested rulemaking will need to evolve, as I mentioned. We request that you commit to this and make it clear in the statement of basis and purpose. This slide contains some suggested language. What appears here is a slight revision from what's in our PHS. I've added words in blue and struck out the last clause that we had in our PHS. So even though we firmly believe that a second rulemaking will be necessary because technology is evolving, we do urge the Commission to make the current rules as specific and protective as possible with what is currently known and following the precautionary principle. We have some recommendations and we support the allied local governments recommendations for increased protections in the current rules. First of all, the existing definitions will not give an adequate picture of the type of technology that's being used. By adding subcategories to your definitions, you will provide both transparency for the public and also the opportunity to tailor rules for different types of technology. In creating subcategories of well definitions, we ask that the terminology should match the industry, research, and/or the Department of Energy terminology. They should specify end use. They should indicate when hydraulic fracturing will be used and indicate when carbon dioxide is used as the material medium and whether mineral extraction from geothermal fluid is planned. If hydrocarbons are to be extracted, a plan to monitor and minimize emissions needs to be included. Same with if carbon dioxide is used as the material medium and when old wells are repurposed. Next, I'll speak briefly about community protections. First of all, the community outreach plan required by Rule 1305B30 should also be required for Form 2 and for geothermal resource unit applications. Additionally, accessible and easily understandable materials should be provided to the community about the project that's proposed in their area. Community cannot have meaningful engagement without an understanding of what is being proposed. It does sound like geothermal rising might also already have such educational resources. So this should not be an onerous requirement. However, this education should not be boilerplate, but should be required to be specific to the processes and impacts of the proposed operation. Additional protections should also be provided for disproportionately impacted communities, including all protections that may be created in the upcoming cumulative impacts rulemaking. We also defer to Green Latinos and support their recommendations on strengthening DIC protections. Cumulative impacts is not a topic contained in the draft rules. In the initial stakeholder meeting on the cumulative impacts rulemaking, the Commission said that the cumulative impacts rulemaking would not contain geothermal because that would be addressed in the geothermal rulemaking. I also have some previous email clarification from DNR staff that all operations under the jurisdiction of the Commission would be covered by new cumulative impacts rules. Statutory definition of cumulative impacts includes all operations within the Commission's jurisdiction. The current proposed rules do not require a cumulative impacts plan, and we have some recommendations for incorporating by reference rules in 2A applications and geothermal resource unit applications. To ensure that the cumulative impacts rulemaking will apply to deep geothermal, if the aforementioned rules that we've suggested to incorporate by reference change in number or substance, the new rules should be applied to geothermal. We note that the revision of the SBAP states that only current versions of rules apply when they're incorporated by reference. But to me, that makes no sense since you are in the middle of an important rulemaking that will change rules only a few months after the geothermal rules are passed. The most important thing here is that data is gathered to inform our understanding of the issues and impacts, and also to protect disproportionately impacted communities that will be included in cumulative impacts rules, which should also apply to geothermal rules. But regardless, there are concrete ways that these rules can reduce cumulative impacts apart from plans and data gathering. Cumulative impacts includes impacts to climate. Whether or not you decide cumulative impacts should be addressed in these rules, impacts to climate are an impact to public health, safety, welfare, and the environment, including wildlife, and they should be minimized. Enhanced geothermal energy is expected to have lower life cycle greenhouse gas emissions than almost any other source, as geothermal rising reported. But some of this analysis was not based on monitoring and measurement, but on assumptions and modeling. It has recently come to light that methane emissions that are really occurring from oil and gas operations are far higher than what had been assumed from assumptions and modeling. And a lot of this discrepancy is due to leaks. So rules need to ensure that this cannot happen with geothermal that uses repurposed oil and gas wells, or new wells that are drilled in oil and gas basins, or from geothermals that use carbon dioxide as the material medium. In conversions of oil and gas wells, current draft rules require operators to demonstrate the wellbore integrity for converted wells with appropriate logging and/or mechanical testing as approved by the director. Appropriate is vague, and/or is not acceptable to us. We are asking for required state-of-the-art logging of the wellbore, complete corrosion investigation, measurement of casing thickness, and measurement of methane leakage prior to approval. And also to support what Mr. Sura just mentioned, we're assuming that some wells may be repurposed for a use other than that concurrent use that was previously spoken about. Upon completion, we are requesting that you require quarterly mechanical integrity testing and measurement of methane leakage for the life of the well for converted oil and gas wells. And I want to note that Pennsylvania does require quarterly mechanical integrity testing for their tens of thousands of oil and gas wells. So to me, it does not seem onerous to require this from the start for geothermal, since as geothermal rising has emphasized, we're not talking about a large number of wells. We also want to draw your attention to the possibility that when carbon dioxide is used as the material medium to transfer heat, leakage could occur, and there should be rules to require monitoring and prevention of this. In addition, to also minimize GHG emissions, you could require electrification of drilling, as has been mentioned already today. After all, it would really be a terrible shame if this technology, which has such promise as a clean energy source of the future, had unintended and even unnoticed greenhouse gas emissions. There are other ways that you can ensure these rules protect the public right from the beginning. If a well is within a mile of people, why not require drilling to take place during normal Monday to Friday working hours to minimize the impacts of noise, light, dust, and vibration on the nearby community? The proposed rule for inspections is too vague, and we recommend annual inspections, becoming more frequent once any problems are encountered, and for all test data to be maintained by the operator in easily understandable language on a public-facing website. Also, I want to point out that the incorporation of oil and gas safety rules, I think I'm on the wrong slide here. The incorporation of oil and gas safety rules leaves out operations written safety management program and emergency response plan. So I have recommendations to incorporate additional 602 rules into the Rule 1314 to cover that. We do think that setbacks should be the same as oil and gas wells, especially if fracking will be used. A Colorado specific study has shown health impacts even at 1 mile from oil and gas well sites. We do understand that oil and gas wells are very different from geothermal wells, but the impacts of geothermal fracking have not yet been studied. So the 2,000-foot setback should apply, and this can be relaxed as actual impacts are studied. Finally, special deep geothermal zones. We do ask that Rule 1321 is struck from the rules. This provision essentially allows rules to be considered and adopted without a rulemaking procedure, and this is not how the Commission normally proceeds. Allowing this rule goes against the principle of community participation and engagement. Rules should be created for all situations, either now or in a second rulemaking. As geothermal rising stated, it is premature to think about special zones now. Perhaps in a second rulemaking, enough would be known to create a special zone category without the ability to propose zone-only rules that are less protective than general rules, and that is specific enough not to be problematic. In conclusion, Colorado should take the lead in learning about conversion of old wells and ensuring there are not unintended greenhouse gas emissions. Rules should ensure the greatest protection from the start, and monitoring and measurement must be required to help gather data. Preventing unintended consequences and ensuring the highest protection as new technologies are being developed is essential. We believe the rule changes we've suggested, such as better requirements for testing, logging, monitoring, and inspecting, both prior to and after approval, will achieve the lowest possible emissions from repurposed oil and gas wells, and also from new wells that may be drilled in basins, while not increasing the timeline for permit approval. We hope that you will acknowledge the iterative process of successful geothermal rules by committing now in the SPAP to doing the future rulemaking. Thank you.
Thank you very much, Ms. Leithwood. If you want to pull down your slides, there you go, folks. Do we have questions? All right, I'm not seeing questions, and it looks like you have 2 minutes left for rebuttal. So bear that in mind and stay with us. And then, commissioners, I need to attend to another ECMC matter for about 10 minutes. So let's take the mid-afternoon break. Let's return at 3:31. This is the Colorado Energy and Carbon Management Commission. It is August 5th. It is 3:31. We're in docket 2405-00115, the deep geothermal rulemaking. We are now to hear from Weld County. Good afternoon, Mr. Conroy.
Good afternoon, Mr. Chair and Commissioners. I will share my screen real quick. Wait. Wait. Here, can you see that?
No.
I gotta actually click the share button. Okay. I'm an attorney, not a technologist. Thank you for your time this afternoon. I'm Matt Conroy. I'm an assistant county attorney for Weld County. Jason Maxey regrets that he can't be here today. He is currently in Wyoming. He thought he would have cell coverage, but apparently does not. So I will be handling everything and hope I can answer any questions. To hopefully not be overly duplicative of all this testimony as it is getting late in the day, Weld County does believe that these rules as proposed are a strong start on deep geothermal in Colorado. And as there's been much discussion of that the commission should work with relevant local governments to address surface impacts. One thing we do want to make note of is that we do believe that the current setback requirement of 500 feet from building units as in the staff's proposed rules is adequately protective as we figure out what's going on with geothermal. As was also previously mentioned, some of these need to be closer. We believe that the impacts of deep geothermal operations will be less than those from pre-production of oil and gas activities, and Weld County's position on pre-production of oil and gas activities is that 500 feet is a sufficient setback for those. So we have absolutely no concerns with the 500-foot setback. And then also we would just like to say that we support the staff's proposal in Rule 1305C to change for when the director must require completely separate information from what the local government, or in some cases the federal government, requires in their siting process, from must be supplemented from are not equivalent. We know from the oil and gas context that it seems we run into issues that even though we regulate some of the same issues as the ECMC, such as noise and lighting, in particular come to mind, that just because they are not technically equivalent, staff sometimes doesn't defer, and we think it creates overly duplicative process and just makes more work for ECMC. And so we believe that changing it to must be supplemented allows the director a little bit of latitude in making sure that they have sufficient information to make a high quality decision without necessarily forcing them into duplicating things because it's not exactly the same. And so with that in mind, we do request that the commission adopt the rules as proposed, except for Rule 1303C3. One change in the draft of July 23rd was that the commission changed 1303C3 to from defer to consider for a decision of when the relevant local government has approved a siting application. And so we believe that using the word defer makes more sense because it's more of a sort of a tie-breaking vote in the case of you have multiple locations that are all good decisions. It ensures that we don't become crosswise on what the actual final decision is. And then, but so the proposed language that we submitted with our written testimony, I hope strikes an adequate balance between saying that the director will defer to the relevant local government's siting disposition, but also still making sure that the director has enough information to make an adequate decision, make sure that we considered everything necessary. And so that, deference doesn't mean it's just sort of a rubber stamp, but it just means that, there's nothing arbitrary or capricious or clearly erroneous with the local government determination. And with that, I'm happy to answer any questions.
questions for Mr. Conroy? Commissioner Messner?
Thank you, Mr. Chair. Regarding the word defer, and I understand that's currently in the rules, do you acknowledge that utilizing the word defer does require then the local governments complete their review first?
Well, so it's only deferring when the decision has already been approved. We'd have to pull up the language so I don't misquote it. But my understanding is that if the local permit is still in process, the director could, they don't necessarily have to defer. I think from our perspective, our experience is that from, again, the oil and gas context is we go first on almost all of these decisions. And so we would anticipate that our decision is first. I hope that answers your question.
Sure. I mean, I think one of the challenges here is there's some things that have changed in this, but the deferred siting language potentially requires the local government to complete their land use process first, rather than concurrently, as most often done between at least the state and Weld County right now. And so I just want to make sure that you're thinking about that as you're reviewing it, and make sure that's what you want to suggest.
Right. I mean, and I think again, 1303 as proposed in staff's draft rules from July 23rd, 1303B4, the relevant local government regulates the siting of deep geothermal locations, but has not made a decision on the siting of the proposed deep geothermal location. And then that then translates into 1303C1 that is included for when the director will conduct an independent analysis. And so I don't necessarily, I think again, looking at it from the framework of, the state has made the policy decision that we want to promote these projects. It ensures that doesn't get caught up in if the government, we as the local government make one decision, the director makes a different decision, and then now how do we reconcile that? I think deference, it puts a thumb on the scale of, as long as there's nothing clearly wrong with the local government's decision, go with that one, because we have the best understanding of sort of local conditions and local impacts.
So, I'll think about this a little further. I actually think the shift that we'll consider potentially creates some efficiencies, because it doesn't create this back and forth between the local government and the state, because it's possible that the local government could approve a site that may not meet the rules of ECMC for any number of reasons. And so therefore, while they may have the local government approval, they may not get the ECMC approval. And then ECMC would have to suggest a different site, which in turn then would require a new local government process. And so in the end, this could cause a less efficient system. And I think there was an attempt to create additional efficiencies, but I'll certainly think about your suggestion here.
Other questions for Mr. Conroy? All right, seeing no further questions, we thank you for your time and appreciate Weld County's being before us. And I'll let Jason Maxey know you did a top-notch job.
Thank you. Have a good one.
Western and Rural Local Government Coalition. Good morning, good afternoon, Mr. Nguyen.
Good afternoon. You mean it's not still morning? Goodness.
Not still morning.
All right. Thank you very much for your time. I'm Kirby Nguyen, representative for our Western and Rural Local Government Coalition of 23 governments. Just have some pretty brief remarks. We believe overall the staff has done a great job of developing the proposed rules. They've arrived at a set of rules that we believe are right size for regulating a safe geothermal energy industry. And we agree with the staff decision to not incorporate any overreaching rule proposals and instead adhering to what we believe are the specific issues and scope of the rulemaking envisioned and requested by the governor's office and the General Assembly for a regulatory schema that of course needs to provide for safe and highly efficient as well permitting process absent unnecessary extra hoops to jump through. As WRLG, we ask you to adopt the July 23rd staff red line rules without any superfluous add-ons requested by some for things like cumulative impacts analysis, alternative location analysis, 2,000-foot setbacks, which we don't see any need for, or a mechanism to generally require full hearings at the commission for almost all geothermal locations. We believe there's no basis for packing in such provisions for this desired and nascent industry that's already known to not cause nuisance impacts on par with oil and gas development. And we believe also you have your own July 2024 ECMC and CGS report, Geothermal in Colorado report, that outlines why deep geothermal operations are far less impactful on most any measure as compared to oil and gas operations. We expect you and hope you all lean on that a little bit. And also, as correctly and we believe importantly stated in the staff presentation today, local governments may choose to closely regulate siting issues, and they may require thoroughly vetted and conditioned local land use permits for any deep geothermal application within their jurisdictions to address what they may see as any real or imagined surface impacts to ensure that there's compatibility with surrounding land use issues. That's textbook local government operation right there. We believe the suggestion that deep geothermal pre-production activity has surface impacts to surrounding community that would be on par with oil and gas, and therefore requiring expansive setbacks from buildings is one such imaginary surface impact that does not really hold water in the real world to suggest expansive setbacks beyond 500 feet are needed at all. There's shorter on-site duration. There's just many things that are well known about why the impacts are lesser for deep geothermal. Local governments can require on their own cumulative impacts analysis equivalents, alternative location analyses, and most any distance setback that they want. And they can also set any public comment period to any length they prefer during their local permitting process without need for ECMC rules to separately require these items. We believe that only when local government permit requirements are demonstrably not protective of public health, safety, welfare, and environment should the ECMC find a need to step in to address siting issues. And we believe that the draft rules already provide every tool necessary at your disposal to do that as you need to, or as you deem you may need to. We do have one small issue on the draft rules. This was brought by Weld County. We see the same thing. That's that rule 1303-C3. We did not agree with the late arriving replacement of the phrase defer to with the word consider regarding local government siting disposition. And Weld County handled it well, so I won't dive into that too much, but we do think that is a substantial and unwarranted change, and we urge the commission to retain use of the term defer to. Such deferral has not, in practice, been problematic to date, as similarly applied in oil and gas operations per Rule 302C3. As such, we see this shift away from defer as a solution seeking and failing to find a problem to address. We understand that a similar shift from defer to consider is currently proposed for Rule 302C3 for the cumulative impacts rulemaking, and we understand a drive and a necessity and a preference to have consistency among rules, but we'd ask that you maybe deliberate, sort that out in the cumulative impacts, a more substantive rulemaking with much more immediacy and need and impact, and maybe come back to this rule set. If you need to switch from defer to consider, make that change in a later rulemaking or adjustment to the deep geothermal rulemakings at that time. But we also, in the cumulative impacts rulemaking, we're also suggesting that defer to should not be dropped from the oil and gas rules as well. So with that, that's all that I really had for you today. I appreciate your time and your attention, and happy to address any questions if you happen to have any.
Thank you very much, Mr. Nguyen. A couple of questions right off the bat. Some of the allied local governments, I understand you're not in favor of some of their substantive changes. There were some changes that they were advocating for on like notice and consultation with local governments. Do your communities echo that? Do you feel like we've got it about right in terms of how it's drafted now? Do you have any thoughts, comments on that more procedural piece?
No, we definitely looked at that across our partnership. We didn't see a problem with what was drafted. We would have brought that up. We think the notice and consultations, you've got it about right already.
Okay, thank you. And I appreciate your and Weld County's bringing up the defer to consider. And I was going to make the point that you just made, that is the word consider is changes in the cumulative impacts rulemaking is being proposed by staff. We'll obviously need to take a look at that there. I think we need to take a look at it here, without sort of noting exactly where I am on that. I think that the term consider is actually more in line with what we do with local governments, in that it's a dual process. And I think we've done a really good job of developing, and I hope you would echo this, with developing lots of different relationships with local governments across the state, which local governments kind of look at things in a lot of different views. So I don't know that I see it as a massive sea change in how things are actually happening. So I just point that out for your consideration, and happy to further chat about that point. Again, I appreciate the relationship we have with Garfield County and the relationship we have with Weld County, and as well as the relationship we have with the allied local government counties. That's not an easy task at times. But at any rate, not trying to beat this horse, but did want to provide some perspective there.
Appreciate that.
Anything further for Mr. Nguyen? Great. Again, really appreciate you being with us.
Thank you.
Colorado Oil and Gas Association and American Petroleum Institute are next. That's probably 3 or 4 lawyers. Let's take 4 minutes and return at 3:52 to get them up and running. All right, welcome back. Ditto, it is still August 5th. It is the same rulemaking, and we are continuing forward. We have Julia Ryan on behalf of COGA, Jim Martin on behalf of API, and we will move into their presentation. You're muted,
You're on
Ms.
mute.
Ryan.
Good afternoon, commissioners and staff. I believe we should also have Mark Matthews.
Oh, okay, let's elevate Mr. Matthews, please, staff.
Chair Robbins, this is Stephen Smeltz taking over for Mr. Thomas. I only see a Matthew Conroy in our attendees unless he's already been elevated. And so I think we're missing second Matthew.
Ms. Ryan, do you want to text him?
Yep. I sent him a note, but your time is valuable, so I could perhaps kick us off and then we could just switch a little order if that's fine with you all. All right, let's go ahead and proceed with that. I apologize for that little snag. Good afternoon, everyone. I'm Julia Ryan with Brownstein Hyatt Farber Schreck on behalf of the Colorado Oil and Gas Association. I just have 2 quick issues to address, and my colleague Mark Matthews will address a third. I will be discussing the special deep geothermal zones and mineral owner notification of proposed deep geothermal surface siting before handing it over to API. As far as special deep geothermal zones go, COGA believes the concept has some merit, but not quite ready for prime time. As COGA mentioned in its pre-hearing statement, COGA is unable to determine from the draft rules what parameters might guide the area-specific rules, the criteria by which the commission or the director might approve such rules, and what type of application contents would be necessary to meet that criteria. We're also concerned that the process of adopting specific rules allows the agency essentially to conduct a rulemaking outside of the State Administrative Procedures Act and its attendant due process and other procedural safeguards. We do appreciate that the latest draft rules remove the phrase every part from the requirement that a relevant local government must support the application for a special deep geothermal zone, but it's still unclear what level of support would be required. And then also, it couldn't be as simple as a relevant local government lacks expertise in deep geothermal operation and can't opine with affirmative support simply due to lack of expertise. As well, giving so much control over special deep geothermal zones to a local government, we believe is contrary to the Colorado legislature granting authority over deep geothermal operations to the commission instead of deferring solely to local governments or asking local governments to regulate deep geothermal regulations themselves. So COGA is open to revisiting this topic in the future, but cannot support it today. Moving on to notice for mineral owners of deep geothermal operation siting. We hope it's clear from our filings that COGA is supportive of deep geothermal energy and believes Colorado can be a leader in this space. But we also want to make sure that deep geothermal projects don't impair existing oil and gas rights or adversely affect oil and gas development opportunities. And because geothermal rights and oil and gas rights may be owned separately from the surface, yet both require surface access, COGA believes it makes sense to codify a mechanism whereby access to those respective rights can be amicably sorted out amongst the relevant owners. So the issue is that a deep geothermal operator could seek to use a surface location that an oil and gas operator also has a right to use. The deep geothermal operator should be required to provide notice to owners of severed minerals underlying the surface where they want to operate, so that those two rights owners can, if necessary, come to an agreement over who will propose to do what, where, when. And this is no different than how developers of residences, commercial developers, industrial developers, they're all required by statute to notify mineral owners of their intentions. We're just concerned there might be a gap here, specifically as it relates to deep geothermal uses, because this is uncharted territory for Colorado. COGA appreciates geothermal's initial concerns, with COGA pointing this out in its pre-hearing statement. And I can confirm for you that, as Mr. Lepore indicated, COGA is not asking every mineral owner in a geothermal resource unit to be noticed, and we acknowledge that conducting title for the entirety of a unit could be a burden on the deep geothermal operator. COGA seeks to do no more than what the other developers are required to do in those other contexts, which is to ensure that a mineral owner has notice that the surface to which it also has a surface access right is being proposed for another use. So before turning it over to Mr. Matthews, I do have language that the trades are proposing on a slide that I'll pull up in a moment. I do want to make it clear that while COGA has shared this language with Geothermal Rising, I can't represent that Geothermal Rising affirmatively supports the language. But I will share my screen. Oops, that's not it. Can you see that? All
Yes.
right. Great. So the applicant will provide notice to leased and unleased mineral owners of any, excuse me, now I can't read it. Owning minerals exclusive of geothermal resources underlying any quarter section of the surface where a deep geothermal location, deep geothermal facility, or geothermal flow lines is proposed to be located. We'll, of course, provide that to Ms. Amaro. That concludes my portion. I'd like to ask that you do adopt the draft rules as presented on July 25th, with the exception that we ask the special deep geothermal zone concept to be stricken, and for you to consider adopting the mineral owner notification. Over to Mr. Matthews, please.
Thank you. I apologize. I was waiting in the waiting room the entire time. I will work to make sure this doesn't happen again prior to the next rulemaking. My comments are going to be more general than Ms. Ryan's because they were meant to kick off the presentation. I want to reiterate that COGA is supportive of the draft rules. We do have a couple of minor changes, which Ms. Ryan just outlined. But otherwise, we do believe that these draft regulations establish substantial protection against any adverse impacts that could arise from geothermal development. But the draft rules also present a relatively streamlined process, certainly in comparison to the ECMC's rules applicable to oil and gas development. And this is important for a couple of reasons. First, Colorado has some catching up to do with other states in attracting geothermal development. Nevada, as you've heard, has long had an active geothermal industry. It currently has 26 geothermal plants in operation, which generate about 8% of Nevada's electricity output. California also has a long history of geothermal development and currently has 40 operating geothermal plants, which constitute almost 6% of Colorado's electricity production. Moreover, while it is a fact that enhanced geothermal development is in its nascent stages, other states have taken the lead in permitting these kinds of projects as well. In Nevada, Fervo Energy and Google signed a cooperative agreement to develop the first full-scale commercial plant for enhanced geothermal energy, as mentioned by Ms. Leithwood earlier. That was launched in 2021, and the project commenced 2 years later and now provides 3.5 megawatt into Nevada. More exciting, in Utah, Fervo Energy announced earlier this year that it was on track to open the world's largest enhanced geothermal plant by 2026. This facility, known as the Cape Station plant, is scheduled to start producing 90 megawatts of continuous power in 2026 and will expand to 400 megawatts by 2028. And this would put it among the top 10 sources of electricity in Utah. Fortunately, the fact that Colorado has some catching up to do has been recognized. Several commentators have already mentioned Governor Polis launched the Heat Beneath Our Feet initiative to, quote, jumpstart the adoption of geothermal energy in the state. And one of the key recommendations, again, as others have mentioned, is to optimize permitting and improve regulatory certainty. COGA believes the draft rules are a good step in this direction and urges the Commission to resist the request of a few stakeholders to hamper and complicate the application process by adding rules applicable to oil and gas development. Overly complicated rules that mimic existing oil and gas regulation would create a barrier to entry for operators, and we believe a missed opportunity for Colorado. In particular, COGA urges the Commission to not require a cumulative impact analysis in its deep geothermal rules. SB 23285 made many substantive changes to the Colorado Geothermal Act, and as has been noted, requires the Commission to promulgate rules protecting public health, safety, and welfare. But again, as Mr. Tour mentioned at the kickoff of this rulemaking, it did not impose any requirements regarding the need for a cumulative impact analysis. Indeed, the words cumulative impact nowhere appears in the legislation. And as a final example, SB 23285 mandates that the ECMC fund the technical study of the state's geothermal resources, which of course was just published. This study, according to the legislation, should include an evaluation of potential impacts, including environmental and public health impacts. But there is no mention that the study should include an evaluation of cumulative impacts. So we very much appreciate the current draft not including such language. Thank you. I'll now turn it over to Jim Martin to conclude our presentation.
Good afternoon, Chair Robbins. Good afternoon, commissioners, and everyone who's joined the rulemaking hearing today. It's a pleasure to be with you. I, on behalf of API Colorado, have some very brief comments. Want to start by saying that we support the language posed by Ms. Ryan on behalf of COGA, recognizing that we we are not yet sure where Geothermal Rising will come out on that issue. We can't speak for them, but like KOGA and other parties, API Colorado supports the proposed rules being considered by the commission. We believe they strike a fair and effective balance between expanding permitting or expediting permitting rather of geothermal energy projects at the same time while protecting public health, safety, welfare, the environment, and welfare. And I have to say that is probably no mean feat. So we commend the staff for their work on these proposed rules. It's a very finely balanced proposal. Having said that, I want to join in what Mr. Matthews said and expressing some concern about substantive proposals proposed by allied local governments, Larimer County and 350.org, and perhaps others, particularly concerned about the proposal to require alternative location analyses and the proposal the proposal to expand the universe of situations where a hearing before the commission would be required, and thereby extending the time required for permitting process permitting. Hope the commission will look very carefully at those proposals and consider how they would affect that very careful balance that I believe that commission staff have managed to achieve in this rulemaking. No small feat, as I mentioned before. With that, those are our comments. API Colorado supports the proposed rules, and I believe on behalf of KOGA and API, we'd like to reserve the balance of our time.
Very good. Commissioners, the panel is open for questions. It's either getting really late in the day or you guys did a phenomenal job on your case in chief. I'm not seeing any questions.
Thank you, Mr. Chair, commissioners.
Thank you very much.
All right. We've two more. First is GeoX Energy with 5 minutes. Hi there. Are you GeoX?
Yes, I am. Hello. Good afternoon, Commissioner. Oh yeah, I'm ready to go.
No, you're good to go.
Cool. Good afternoon, Commissioners. My name is Kristen Netzer, and on behalf of GeoX Energy, I would first like to thank the Commissioners, ECMC staff, and all other stakeholders for their thoughtful engagement throughout this rulemaking process. GeoX looks forward to the expansion of geothermal operations in Colorado and the substantial direct and indirect benefits clean energy will provide to our communities. GeoX appreciates the progressive and comprehensive regulatory scheme that has been presented thus far and hopes this statement will be taken into account by commissioners to adjust the rules in a manner that is workable for all future geothermal operators. That being said, today, GeoX would like to focus its time on the implications of Draft Rule 1307. As currently drafted, Rule 1307 provides that permits for deep geothermal operations are valid for 3 years, and neither the Commission nor the Director shall approve extensions of these permits. However, 3 years is not an appropriate amount of time for operators to secure a successful geothermal project before their permit expires. Therefore, for the following reasons, GeoX requests that the Commission amend Draft Rule 1307 so that permits for deep geothermal operations are valid for 10 years. Before geothermal operators start drilling a geothermal well, several key steps and preparations are necessary to ensure a project is conducted safely, legally, and efficiently. To provide examples, geothermal operators must complete feasibility studies, secure connections with utility companies, prepare the site, ensure compliance with all environmental regulations and safety and regulatory standards, and secure financing for the project through investors, loans, or grants. Securing connections with utility companies alone and entering into a transmission connection agreement can take years. Additionally, a valid permit is typically necessary to secure financing, and a permit that expires within the timeframe of those discussions will push many projects back to square one. Before the regulatory scheme for geothermal operations can be successful in this state, the Commission needs to provide operators with enough time that attracts investment. A comparison to oil and gas operations further reiterates the importance of a longer permit expiration period. The current ECMC rules and regulations provide oil and gas development plans are valid for 3 years. Thus, oil and gas development plans and permits for deep geothermal operations will be valid for the same amount of time. However, the comparison of experience the state and operators have in oil and gas operations versus geothermal operations is far from equal. For over 100 years, oil and gas operations have been present, and operator expertise and knowledge has been refined to make the process of developing successful oil and gas operation feasible in most cases within a 3-year period. There has been a long history of innovative transitions within the oil and gas industry, and at this point, the field is flooded with experts. On the other hand, this is the first time geothermal operators and the ECMC will be engaging in geothermal operations in Colorado. There are no exemplary operations to replicate as there is in oil and gas. The Commission should take this experimental nature into account and provide operators with enough time to endure the trials and tribulations that will undoubtedly be encountered. So once again, GeoX respectfully requests to the Commissioners that they consider extending the permit expiration period to 10 years. Otherwise, GeoX stands by each of the other suggestions made in its pre-hearing statement as ways to improve the proposed rules. Additionally, GeoX would like to reiterate its support of Geothermal Rising's pre-hearing statement. GeoX and I thank you for your time and consideration today, and we look forward to working with you in the future. Thank you.
Thank you. Does GeoX have a position on 5 years for a permit versus 10?
Yes, so 5 years we agree that it will indeed work in many circumstances, but given the unknowns and kind of the experimental nature of geothermal permitting and partnering with the utilities here in Colorado, we are concerned that a shorter time frame will cause issues in more rural development opportunities. So we're hoping that's something the Commission will consider in choosing a time period longer than 5 years.
Okay, thanks for that. Commissioner Oath?
Yeah. Following up on that, could you explain the last part of what you just said? Why would it lead to more rulemaking opportunities?
Oh, no, in rural areas, it will cause more issues because the electrical grids aren't up to capacity necessarily. So they will need more time to work through that or even update the electrical grids, etc.
Okay, I hear you now. I misunderstood what you said. And then I did have, I think one other question. In your written statements, you also asked for a change for the allowance of the use of wastewater without director approval. Can you talk about that a little bit? And specifically, are there studies that you could point to that talk about relative risk with different types of water that would provide comfort of doing of allowing this without kind of a special look?
Yeah, so I actually am not sure on how the treated wastewater use in the wells works, and we don't have an expert testimony witness with us today, but I can reach out to our client and try to get that information and answer that question for you later on if that's something that is available.
Okay, thank you.
Other questions for the witness? Thank you very much. We appreciate you being with us and being a party to this process.
Thank you.
All right, the last stakeholder that has time on the agenda today is, or in opening, or in case in chief, is Green Latinos. Hey, hello, Mr. Tolfoya.
Hi, Commissioner. I'm hoping Patricia has also been updated. Patricia is going to be leading our presentation.
It looks like there's another person that's been elevated.
Okay, so I'm gonna also try to share my screen now. Here it goes. Alrighty, my screen should be sharing now.
It is, oh, there it goes. Hold on.
Can you tell the kids to sorry y'all, I'm also have kids here today.
No problem.
Alrighty, let's get started. We'd like to thank the Commission for the opportunity to be parties to this rulemaking. We feel with this emerging technology, it's very important that community voices are highlighted. Just quickly, we're going to have a quick rebuttal, reiterate our concerns that we've already sent to the Commission in our pre-hearing statements and our responses. We want to talk about ways that we can implement the Environmental Justice Action Task Force recommendations. And if we have times, we'd like to also touch on a few items that we feel that we are supporting in this rulemaking. So beginning with enhanced consultation and notification requirements, the notice of intent should be sent to facilities that we had stated in our pre-hearing statements. Although there was a broad range of items listed, we feel that those should be also considered for receiving notice simply because during the consultation portion, these facilities, hospitals, rehabilitation center, things like that, that provide medical services are parties that can ask, are parties that can seek a consultation with CDPHE and the Commission. We also hope that the Commission would send out new application notices to ECMC listservs just to keep members of the public and interested parties informed. We'd like to also add a big part 13, well, this would be my suggestion, add a process for consultation for community-based organizations. This is very crucial to ensure community engagement and trust building between the ECMC and disproportionately impacted communities. Communities often feel like they're left out of the process, and so it's very, very important that we have communication and transparency early on. When we talk about the increased community engagement and public comment opportunities, we are in support of extending that public comment period for communities within 1 mile and or school facilities within disproportionately impacted communities. And we'll also be extending the timeline to allow more community involvement, more community education about deep geothermal operations. And we would like to see more outreach efforts for this emerging technology in general. There wasn't a lot of easily accessible information for us to prepare for this rulemaking. And so we feel it's absolutely necessary to have more information available for the public as well. In terms of safety and compliance, the application asks that there should be a review of existing wells within the unit area within, I think it's 1/4 mile. We'd like to increase that to 2,000 feet up to 1 mile in DICs of the unit boundaries. And then when considering converting existing oil and gas to deep geothermal operations, we should consider, in addition to the wellbore integrity, the history of operators with multiple violations, site failures, whether or not there's been a good faith effort to repair repeat violations. While this is a way for operators to extend the life of their assets, public safety, health, and environment should always be prioritized. And then the ECMC is encouraged to establish regular inspection frequencies for geothermal operations. What is a regular inspection? From my understanding, looking at the 600 series, that points us to Regulation 7. The frequency of inspection should be the same as they are in Regulation 7. But when we look at Regulation 7, all of those are specific for pieces of equipment. So I think there needs to be a very clear timeline for inspections of deep geothermal facilities. And then we urge y'all to have some kind of mechanism to be able to pause or stop operations like we had established for oil and gas operators, the ability for the commission to pause or stop operations. And then as far as the setbacks of this new technology, we really encourage the commission to have the same or relatively the same or comparable setbacks for as you have for oil and gas. Continuity of setbacks is absolutely needed. And I'll touch a little bit more on why we feel the continuity of the regulations later on. When we talk about what is environmental justice, just to do a quick recap, it's a fair treatment of involvement of all people, regardless of race, color, national origin, income, respect to the development, implementations, and enforcement of environmental laws, regulations, and policies. And what we're really kind of pulling from is 1266, the Environmental Justice Act, that says people have the right to clean air, clean water, and also have a part in decision-making process about the environment around them. One of the North Stars of Green Latinos is the Environmental Justice Action Task Force recommendation. As many of you know, our state director, Ian Thomas DeFoya, was the co-chair, and so the task force came up with 7 different recommendations to the state agency. And it's also very important to note that there were both community and operators and utilities involved. And so these recommendations are very, very thorough. And just highlighting on a few of those recommendations, environmental justice coordination, we'd like the commission to take the initiative to create ways to share data with other agencies to protect communities. There may be some APCD regulation, definitely utility regulation, because of, deep geothermal is going to be used to create energy, as well as with the Department of Water Resources because of the shallow geothermal instances. We also urge the commission to create background information about deep geothermal and ways that the ECMC regulates this new technology. And so being very clear what the commission's role is to the public is really, really important. Secondly, the second chapter around environmental equity and cumulative impact analysis, Green Latinos is a party to the current cumulative impact rulemaking, and so we're concerned that there is no cumulative impact language in this rule series. I feel like it would be appropriate for the approval of the permit, and these kind of cumulative impact analysis should be conducted at the commission, and we don't feel that local governments necessarily have the capacity to being able to complete this cumulative impact analysis throughout the permitting process. When we talk about data and reducing environmental health disparities, there should be measurable goals for eliminating health disparities. There should be collecting and sharing of data on the feedback provided by community members. And there are recommendations from NREL that include disclosure of chemicals used at these facilities. And there are some operations in Utah that have live seismic activity publicly available. And so we think things like that are also going to be really important to keep Colorado in the forefront of the regulatory spaces. Best practices for community capacity building is going to be huge due to lack of legal representation. Green Latinos were representing ourselves in this rulemaking. And now when we think about the whole scope of the ECMC regulations, there are currently now going to be 13 different sections. Each of these sections is 30 to 70 pages. And the whole series is close to 350 pages long. This draft is, some of the drafts are about 67 pages. And when we look through the rule, this draft rule also references other sections of the ECMC regulations. And so it's not often that community members are able to be completely versed in the regulations and be able to toggle back and forth between the different sections of the rules. We also definitely support tribal consultations, and agencies should use innovative strategies for engaging with Indigenous populations, as well as have sovereignty affirming strategies. And then the last part of the just transition, or the recommendations, talk about a just transition. We really hope that ECMC spearheads workforce development and training. We know that there's been multiple opportunities that have been mentioned today. And quickly, our participation, a lot of you have had many conversations with us. And then just quickly, I want to reiterate that we want to support the request of the Southern nations. We also support the removal of 1321 for special deep geothermal. For the allied local governments, we support their force pulling and notice recommendations, as well as their recommendation that the drilling equipment should be zero to no impact. There is currently a rulemaking at APCD that addresses emissions from fuel combusting equipment already. And so there's a framework and best practices for that. And we also support Larimer County's force pulling requirements to be changed to 51%. And with that, I'd like to reserve the remainder of our time for rebuttals.
Thank you very much. Commissioners, questions for the panel? Commissioner Cross and then Commissioner Oath.
Thank you, Mr. Chair, and thank you for this presentation. I just had one quick question, and I know this is something we've talked about in some other instances as well. One of the things that you proposed was community-based organization consultation. And especially in a situation like this, I'm curious how we define that. So do you think that community-based organizations should register to be approved for something? I'm just curious how an operator will know what community-based organizations to potentially reach out to in such a situation.
Patricia, can I take that one? All right, I think she's giving me the thumbs up. Commissioner Cross, I think what's really important here when you think about this is that thanks to the Environmental Justice Action Task Force and some of the other work we've done at the legislature, you are getting ECMC liaisons. There are other agencies that are cross-coordinating on their outreach, and there should be sufficient data sets, both in collaboration within the government and also to local and regional governments to identify who those partners are. I think the idea of having some sort of hurdle where you have to register, I think is really unnecessary. I think we frequently are called by agencies saying, who are the groups that are doing the work on the ground? You know, from a CDPHE perspective, they have community connector programs that have already been identified in certain parts of the state. And so I think there are sufficient resources that exist within the government already, as long as you are talking to each other, hence the recommendation about interagency cooperation. And Green Latinos is sufficiently staffed to support the growth of the liaisons with ECMC.
Okay, thank you.
Commissioner
And then,
Oath?
I also want to reply quickly. And, you know, I know that this is separate, you know, oil and gas is separate, but community groups have already won the legal precedent to bring up permits for judicial review. And so I think that has already established the importance of community groups when it comes to the permitting.
Commissioner Oath.
Thanks both very much for being here. Really appreciate Green Latinos participating in this process. It's very helpful. I appreciate all of your suggestions, and I think I understand all of them. I actually had one additional follow-up question on the same recommendation about the community-based organizations. I just want to make sure I understand it, and particularly because you referenced it in relation to 1304F, which is about the consultation with CDPHE. So I'm trying to understand what you're proposing in terms of this piece. Are you saying that Can you help me understand what your what your proposal is?
Yeah, and so I think the best way to describe it is that community groups would be able to participate as an interested party, maybe at the same degree that mineral rights owners are able to participate. And the reason we say that is because when we look at like different impact radiuses, again, I'm citing oil and gas because that's already established. The ECMC has established an impact radius of 1 mile. And so when we think about the different, you know, 1 mile is a big area. And so when we think about who lives there, we have to think about that it's not just one community. And there are community groups like ours that take feedback from our community. And so we want to be able to have the opportunity to provide the feedback and have a seat at the table when these decisions directly impact our communities.
If I could just add on there too, first of all, I want to congratulate you, Commissioner, for your new role and the fact that you served on the Environmental Justice Action Task Force with us. I think that, you know, at the heart of this is the fact that we could sign up for every listserv there possibly is. If we don't have the action of the government to be thinking about people who might want to be engaged, we aren't going to necessarily get there. The fact that we're representing ourselves has been a huge hurdle for us, but we wanted to do it to set an example to the rest of the community. You know, AQCC, for example, has started to put together pro bono resources. This is something that I talked with Director Murphy about, and you know, the governor's administration, that we still have to find a way to help community groups get over that hump. And we just think that by making people have to be contacted by the government and then also ensuring and getting resources to the government to be able to do that, that lift belongs there. In order for us to give us even close to a level playing field to participate.
Great, thank you both. I appreciate it.
Other questions for the panel? All right, seeing no further questions, we thank you very much for your participation with us and bringing the perspective that you have into our rulemaking on deep geothermal. All right, could I have our hearings manager, Stephen Smeltz, visualize himself? Hey there, can you,
good afternoon.
do you have a tracking record on who's left with rebuttal?
Yes, I do, sure. And I'm gonna share my screen now.
Okay. All right, I encourage all of our stakeholders to look at the screen. You can identify the time allocations that are left in terms of rebuttal. We can get this posted into the portfolio as well. Commissioners, what's your pleasure? We've got this thing set up for all day tomorrow, all day Thursday, and all day next Monday. We actually are through direct case in chief in the first day, which is great. I'm not sure that I see that there are a ton of disputed areas. We could do one of two things. We could, it's 4:33, we could break for the evening and come back fresh in the morning for rebuttal. The other thing I think we might be able to do this evening is commissioners could review their notes. I'm making this up as we go here, so just bear with. I was wondering if we looked at our notes this evening, commissioners might be able to identify kind of the remaining issues that are out there. And if we got kind of a list of issues, we might be able to then sort of encourage rebuttal along those issues. But I'm, again, sort of making this up as we go. I'm kind of in favor of not doing a ton more work today since we do have 4 more days set aside for this rulemaking. I believe we could probably get through it tomorrow without too much trouble. That's one commissioner musing along. Does anybody else have thoughts? Commissioner Cross?
Thank you, Mr. Chair. I had pretty much the exact same idea. I've been trying to go through some of my notes to identify some of the issues that I think are important. And I think not only for us to try and identify what issues might be appropriate for rebuttal, but I think it probably would help the participants as well to kind of organize their rebuttal thoughts as well, especially where some of them have a smaller amount of time reserved.
Mm-hmm. So are you in favor of calling it and then letting each of us try to get a list and then comparing the list in the morning, and then that frames rebuttal?
I think that would be appropriate.
Okay. Commissioner Messner, thoughts?
Thanks, Mr. Chair. I like the idea of quitting for today. I guess I'm trying to picture how it would work to have commissioners identify issues for rebuttal when our issues all may be different issues, which really leaves potentially the stakeholders or the parties with a lot of different thoughts on what the issues are that may not actually be helpful.
I didn't say it was a good idea. It's just an idea.
I'm not trying to be critical either. I'm trying to figure out how that would work, because I'm not sure our issues are, as commissioners, will all identify the same issues. So I might suggest we take our thoughts, and I'll certainly take the evening to identify my issues, but let parties base their rebuttals on other parties, and then we can perhaps enter into deliberations right after rebuttals tomorrow and start to kind of issue identify ourselves. But I'm just trying to figure out how we're going to align the kind of the issue identification if we're not all on the same page. You know what I mean?
Yeah, I mean, that's fair. I think if, Commissioner Cross, if you want to tally your list and have it ready, you might, we also might, all of us might say, hey, this one deserves some attention. And just, the problem is we don't have a ton of time for rebuttal, and I don't want people arguing about things that we don't really need additional argument on, such as the special deep geothermal district piece, which I wonder if you want to talk to that right now.
Yeah, I mean, that one was, certainly it was left in the rules vague for a reason. It was a concept that really I had thrown out there with the hope that it would be stakeholdered and fleshed out. And it's still pretty vague in the rules. And I still think conceptually it's a really good idea to apply some pretty tried and true local government practices, to not try to do a rulemaking inside of a rulemaking, but rather to work collaboratively to create an efficient process for having public input on an area, and then providing that area for applications to make it efficient for operators and transparent for both local government and the state in a concurrent type of review process. But clearly that thought process didn't get incorporated enough for people to really, I think, understand the intent. And so my suggestion is that we just remove that and, have the existing process where operators are going to have to go through a patchwork of local government processes and a state process. So.
I'm in agreement for now. I think it's something that we might revisit as we revisit these rules down the road. But I find it to be at this point a little bit vague. I can't determine what the intended consequences or the unintended consequences may be. And so, do other commissioners have a thought on that? Maybe we can, if we're not going to identify a list of issues, we can identify a list of issues that don't need to be talked about. Commissioner Ackerman?
Thanks, Mr. Chair. First, directly to the special deep geothermal zones, I'm in agreement with removing it. I do think we should direct staff to consider it for inclusion in the regulatory study, so that we might be able to flesh out some more ideas on that concept. As far as today is concerned, I do think moving to rebuttal tomorrow morning is a good idea, and then directly into deliberations. I would agree that be tough for us to drive rebuttal too much, but I think that in the end, if we had maybe a couple of minutes in the morning to highlight some key issues that we've been thinking about, I think would be one suggestion. But as Commissioner Cross stated, it's likely that parties will be preparing their rebuttal statements tonight. And so I'm definitely interested in hearing what parties' rebuttal statements focus on either way. But I'm in favor of moving that to the morning.
Commissioner Oath, anything to add for the good of the cause?
No, I think I'm pretty much in agreement, so I will not reiterate.
All right, well then let's do this. If commissioners desire to focus in on things, you can do that. We'll give you a minute or two in the morning, but it's ultimately the parties need to rebut other positions or use the time to sort of accentuate things that they feel are important. Again, the list of time, etc., is right here. So everybody take a picture of that with their cell phone before they leave. We'll leave it up for just a bit. And other than that, I'll go ahead and move that we continue this rulemaking to 9 a.m. on August the 6th.
Second.
Motion and a second to continue. All those in favor signify by saying aye. Aye. Any opposed? We'll see everybody in the morning. Thanks, everybody. A lot of really good work today.